this room. This was not the net. You want to go to the police is a bus. You will
land in respect of the suit plot number 2863 and 0.625 decimal land out of 1.25 decimal in respect of the suit plot number 2864. Exhibit number 3, which is certified copy of the registered deed of
Court
deed.
ultimately found that regarding plot number 2863 and 2864, they are very integrated and it cannot be separated. So you claimed exclusive share, it could not be granted because Kamala through Brojabala got only 0.625 decimals in 2864 and also similarly a fraction in 2863. Therefore, you could not have claimed exclusive title of the.
But my lord, here, my lord, the problem is I have purchased through the registered deed of sale. The defendant has the knowledge of that.
No, it was a demarcated purchase.
My lord.
But could Brojabala and Kamala do that because their own shares was only fraction?
My lord, what is my claim in the title suit that the order has been passed? There has been given, and on the basis of that, they have no. The plaintiff has proved his chain deeds. That's why the decree has been passed, and the defendant has not filed any counter claim or a suit challenging the.
No, they are not challenging the suit. The question is how far title passed, exclusive title passed. That is the only thing to be considered.
My lord.
But you have claimed exclusive title. Let us see how you have couched your prayer in the plaint. Have you annexed your plaint to the?
Yes, my lord.
Let us just see that once.
My lord. That is at page 12 to
page 17 is the prayer.
My lord.
And how have you defined? Let us see. Very well. ওটা অ্যাডমিট করছি ওদের অ্যাটলিস্ট ওদের জয়েন্ট ওনারশিপে ডিক্লেয়ার করা উচিত ছিল। This appeal will be heard on the following substantial questions of law. 1. Whether the learned judge of the first appellate court substantially erred in law in reversing the decision of the learned trial judge declaring the title of the plaintiffs stroke appellants in respect of the suit property, comma, in the teeth of the appellate court's finding that the sale deeds and antecedent chain deeds in respect of the suit plots in favor of the plaintiffs were produced, but refusing to affirm the decree of the trial court only on the ground that the that specifically demarcated portions in the suit plots were not did not devolve upon the predecessors in interest of the plaintiffs. Roman 2, whether the learned judge of the first appellate court acted perversely in overlooking the fact that the plaintiffs had proved their title at least in portion in respect of undemarcated portions of the suit plots and reversing the judgment and decree of the learned trial judge as a whole. Any what is this application? Injunction? Did you enjoy injunction in the court below?
My lord, first of all, my lord.
Yes.
In the suit, my lord, I have, my lord, enjoyed.
Since we have,
lord, I am in position.
Since we have already admitted the appeal, comma, a strong prima facie case has been made out for grant of injunction. Full stop. Keeping in view the averments made in the injunction application, comma, we also find that the balance of convenience and inconvenience is in favor of grant of injunction, as well as the plaintiff's appellants might suffer irreparable injury in the event such ad interim injunction is refused. Full stop. Next para. Accordingly, the respondents, opposite parties, and their men and agents shall remain restrained by an order of injunction from disturbing the peaceful possession of the appellants stroke petitioners in respect of the suit property and stroke or from creating third party interest in any manner in respect of the suit property, comma, both till disposal of the injunction application. Full stop. The application shall be listed for hearing before the appropriate learned single judge having determination subject to being mentioned by the parties. Full stop. The appellant shall file an affidavit of service on the returnable date. We shall grant injunction for a limited period, otherwise they would be suffering because we will not be taking up till disposal of the injunction application. Injunctionটা দিয়েছিলাম প্রথমে ওটা till July 31, 2025 or until further order, whichever is early. You are limiting it so that when you mention it, they'll have an opportunity. Till July 31, you will get this injunction. Next. Thank you. Yes, Mr. Banerjee, what is the matter?
My lord, what happened, my lord? I have
Mr. Banerjee, please come a bit closer to the microphone. Yes.
lost both the court, my lord. This week case is
Judgment of affirmance or reversal?
affirmative.
Affirmance. Yes. You are the plaintiff or defendant?
Plenty.
What is the suit for?
Suit for
Can't hear you, Mr. Banerjee.
suit for declaration and for compensation.
Why compensation?
Because, my lord, plaintiff, my lord, an unemployed person, my lord.
Take the microphone a bit down.
Plaintiff is an unemployed
Take it a
person.
bit down. Take it a bit, yes.
Plaintiff is an unemployed person. On that ground, my lord, he's, my lord, got 19,400, my lord, on loan, my lord, from the bank, my lord, to government of India. But bank, my lord, giving my lord loan only, my lord, block capital, my lord, 7,400. And others, my lord, 11,800 has not paid. On that ground, my lord, several demand notice has been.
Section 13(2) notice, Surface Act.
Yeah, no, sorry, that is my lord, old,
Old.
1988.
So demand notice was
88,
given.
my lord. Thereafter, bank, my lord, issued a demand notice for.
What is the plaint? What is the injunction? What is the relief sought in the plaint?
Short, my lord, is that, my lord, bank filed a suit against the bank for declaration of compensation, and that working capital, my lord, has not given. Working capital has not given.
No, what is the plaint? What is the relief sought in the plaint?
And demand notice, both the court, my lord, dismissed this suit, my lord, barred by limitation. That loan was sanctioned in 1989. The suit was filed in 2013. But the bank.
Your cause of action is in.
Is my cause of action is, my lord, 1/2/2006, my lord. Bank, my lord.
No, from 21st of July 1989, your cause of action as per your plaint.
No, bank demand notice, my lord, 1/12/2006.
Bank demand notice does not give rise to the cause of action.
That demand notice again, thereafter I filed this suit, my lord.
No, your cause of action cannot be the demand notice. You have filed the suit for declaration that you are entitled to compensation for non-supplying of working capital, only for compensation. So if you are not entitled to the main relief, that is supplying of working capital,
that is there, my
it
lord.
was sanctioned on 20th of June 1988. As per your plaint case, it has been refused.
My lord, after, my lord, bank, my lord, demanding notice, my lord, then I filed this suit, my lord. Demanding bank demand notice, my lord, 1/12/2006.
Let us see how the courts proceeded.
And bank
So court rightly applied Article 55, 3 years from when the contract is broken, where there are breaches. As per the plaint case, breach started in 89, Mr. Nothing. Sorry. The present appeal has been preferred against a judgment of affirmance. First up, both the courts below dismissed the suit of the plaintiff for compensation on the ground of non-supply of working capital of rupees 11,800, which was sanctioned on June 20, 1986. First up, the suit was filed on November 27, 2009, whereas, even as per the plaint case, the first refusal of the bank, of the defendant stroke respondent stroke bank to disburse such working capital arose on July 21, 1989. First up, both the courts below applied Article 55 of the Limitation Act and held that the suit was palpably barred by limitation. First up, we do not find any illegality and or infirmity in the said in the judgments and decrees of the courts below for us to admit the appeal. First up, moreover, no substantial question of law is involved at all. Accordingly, essay such and such, essay number 148 of 2022 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. No orders to cost. Sorry. Next.
I am for the plaintiff petition and judgment of affirmation, my lord. My lord,
You've got a section 5?
no.
Oh, 7, there is nothing. Yes.
My lord, what happened in the plain, my lord, I have specifically stated that the defendant enclosed the land and constructed a reservoir, my lord. I have not paid any
Constructed a?
reservoir, water reservoir, but I have not paid any recovery of possession. My lord, on that score, my lord, section 34 oblige and should dismiss. In the appeal court, my lord, I made an amendment application, but up to High Court, my lord, I have lost.
Amendment application was rejected.
Rejected.
Why?
My lord, up to High Court, I have lost.
If you have lost up to High Court, you have not, then
Yes.
nothing remains in your appeal.
Only
What can the High Court in second appeal do? If you came before the...
Only, my lord, kindly come to page 8 of the appeal court's order.
Yes.
My lord, second paragraph,
Yes.
third paragraph. However, there is no case of adverse possession pleaded by the defendant. Thus, the trial court ought not to have made any comment in the judgment in paragraph 15 of the defendant number 1 has acquired right.
Right, so in your favor.
That's why, my lord,
He has not. Just
only-
because
only
he has not got adverse possession, that does not mean he will get a degree.
no, that's true. My lord, only,
By
only, my lord, I am praying, my lord, if possible, my lord, kindly give liberty to file afresh because title
Mr. Das,
admittedly,
you have much experience in the civil side and you know what to do. On the self-same cause of action, you cannot file a suit. But you know what to do. Why didn't you take that recourse? We are wondering that only. You could have just shown, we won't advise you on that. Your client is sufficiently in good hands. You advise your client accordingly. Only due to the non-compliance of proviso, it has been dismissed. So, you think what to do. We won't advise you. Now we are very stingy on these things because you don't get fees and we are very disturbed about that. So we won't give you advice. The present second appeal has been preferred against a judgment of affirmance. First of the plaintiff stroke appellant filed the suit for declaration of title, without seeking recovery of possession, despite having admitted that the defendant stroke respondents have encroached upon the suit property. First of next para, the courts below proceeded on the premise that the suit was barred under the proviso to section 34 of the Specific Relief Act 1963. First up, learned counsel for the appellant, in his usual fairness, submits that although in the first appeal, an application for amendment of the plaint seeking to introduce the relief of recovery of possession was sought, the same was turned down, which order was affirmed in revision by a learned single judge of this court. First of next para, as such, in view of the amendment of the that in view of the proposed amendment sought by the plaintiff appellant having been turned down, comma, there is no scope of granting any relief to the plaintiff stroke appellant, comma, since the suit was, comma, indeed, comma, barred by the proviso to section 34 of the Specific Relief Act in the absence of any prayer for recovery of possession on the basis of the admitted position in the plaint as well. Full stop. Next para. Thus, comma, no substantial question of law is involved in the appeal. Full stop. Accordingly, SA 158 of 2022 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure without any orders to cost. Next. Amendment was revision also it was affirmed.
This is my appeal, my lord. It's in a money suit, my lord. I prayed for an injunction, my lord, which has been refused.
Why is it? It is out of time. Section 5 is there?
Yes, 6 days delay, my lord.
6 days, but
6
you have to
days.
serve a copy.
My lord, I have served.
Oh, you are appeal.
In fact, my lord, on the last
Very
occasion,
well. Despite your vehement opposition, we are first allowing
my
the.
lord, Mr. Rajgupta is very fair today, my lord.
Very fair. 6 days
Because
fair.
he's agreeing to the injunction because it's a case.
What's everything?
Yes.
No, not everything.
To an extent, my lord, that will not dispose of his property, my lord. May I just
Only,
indicate?
yes.
Let him indicate, then you will.
Yes.
Whatever.
Let senior citizens residing alone in
Just
Calcutta.
first formally allow the application.
Yes, my lord.
In view of sufficient explanation for the minuscule delay of 6 days in preferring the appeal having been furnished, comma, can 1 of 2025 is allowed, comma, thereby condoning the delay in preferring FMAT 78 of 2025. Full stop. The appeal is now taken up for hearing under Order 41 Rule 11 of the Code of Civil Procedure. Yes.
My lord, the senior citizens living alone, my lord, they were approached by defendant number 1 as a bank's manager. He initially stated that he shall assist the plaintiff in investing his money, my lord. So initially, my lord,
Branch manager of
branch manager of particular bank approached him, my lord. Eventually, what happened, my lord, he advised them to invest in certain policies, my lord, which were market linked, my lord. That's not the subject matter of the suit. That is a different aspect, my lord. But he also, my lord, in course, because he built a relationship with them, my lord. They were living alone. The only daughter lives in Delhi. But the defendant number 1 induced him to part away with about 70 lakh rupees on various dates, my lord, on the ground that he needs it for during COVID, for his wife, daughter, whatever, my lord.
no, he invested.
No, investment is different, about 1.20 crore.
And
70 lakh was given to him as loan.
to him as loan.
Him as loan, because of the relationship that they had.
Very well.
Now, this fact is admitted, not that this is not in dispute. Now, my lord, this money, my lord, he gave on various occasions. There are documents on record, all payments made by bank transactions, my lord, and admitted by WhatsApp communications, which are all matters of records. Now, my lord, when he demanded, my lord, he just refused. Then, my lord, this suit has been filed.
Money suit.
Money suit has been filed for recovery. In the money suit, my lord, I made a prayer for an injunction saying that he has 2 properties which he is now dealing. He has entered into a development agreement with developers. He might dispose of. That's the only asset that he has. Kindly restrain
That's in
him
the
from.
nature of an attachment order.
Yes, my lord. But my lord, the court
Attachment before judge.
under 39 rule 1B, my lord, I was submitting, my lord, because that's the only my lord,
This is
asset
akin
that,
to 38.
yes, my lord, akin to that, my lord. So it was after notice.
But
Today,
even then,
Mr.
you will have a
Dasgupta, my
case.
lord, he is fairly, my lord, he is conceded. He's saying that I will not dispose of my share in that property if it's developed subsequently, so that, my lord, this money can be secured. Because otherwise, it's
But
not in
this is
dispute.
thing, unless he sells the property, how can the money be secured?
Yes, my lord,
He will not get the money.
Today, my lord, he has entered into a development agreement. And the developer is already in the process of constructing these flats, my lord. My lord, my only concern is, my lord, that is the only asset that he has by which he would satisfy the decree, my lord. But the court below, my lord, it's not in dispute that the money was received by him. That
And not in dispute that he has entered into a developer agreement. Also.
not in dispute. That's also not. I've produced documents on record.
So you are wanting an injunction restraining from what?
From, my lord, dealing with his share in those property, my lord, with the flats which will be coming up, my lord, till disposal of this suit.
That would suffice to.
That
meet
would
your-
suffice because that's the only asset that he has, my lord, today. And if this is not done, my lord, this will be a paper decree, my lord. There's a short case, and my lord, fortunately, Mr.
injunction has
Dasgupta, my lord, agrees, my lord.
refused.
Yes, one more aspect of the matter. On the last occasion, my lord, I had taken a leave to file a supplementary affidavit because, my lord, the injunction application was not brought on record. They were not late. Today
You
it's
have asked
ready.
for a stay. What does a stay mean?
My lord,
Stay of what? You should have asked for an independent injunction order.
my lord, I have, in fact, my lord. My lord, the difficulty is, my lord, my supplementary affidavit is ready. it could not be stamp punched, my lord, because, my lord,
That,
the
that
document, my
runs
lord,
on this
is
forum
printed
to-
on an A4 size paper, which is not a
It
bond
appears that
paper,
the
my lord.
defendant has admitted that he has received
Data
money.
Let kindly takes page 31.
Let's see why it was rejected in the first place.
Yes, my lord, the court below, my lord, said that it's unbelievable that this amount of money could be given, because it's a case that was made out is that he got commission, 70 lakh rupees for commission, when his total investment is 1.8 crores, my lord.
But court nonetheless records that written objection. He has admitted that he has received money.
Yes, that's not in dispute.
That was his remuneration.
So, my lord, kindly seize the order, my lord.
Cannot be considered to be an admission. Ridiculous.
The last paragraph, which would be at
No.
the
Injunction application. Have you got a copy?
Yes, I'm
Don't want a.
my lord, it's not punched because it's not on bond paper, my lord. I'll have to seek leave, my lord, to have it punched. He is in Delhi, my lord.
Can you detect the injunction application? Do you have extra copies of the injunction application? We can take that on record and pass an order.
But this is injunction.
Where is the injunction?
Is
Which
a
page?
part of, my lord, this supplementary, my lord. No.
But the application for injunction is annexed without the annexures. In your lordship's
It's part
stay
of my
application,
stay application, my lord,
Page
without
30,
annexures, my lord.
without the annexures.
As a
Page
very, let us see
34,
the
my lord.
prayer at least.
Yes, my lord.
Where do we find the prayer?
My lord, page 56, my lord, will find it.
You have asked for an injunction regarding the entire property,
Yes, my lord, because
but you now restrict your prayer to their
yes,
share.
to these two properties, my lord,
Their
where
share in these two properties.
Yes.
Their share in the.
this property where they have entered into a development agreement.
How can there be such an injunction? The development agreement will be frustrated then.
Well, the allocation that the owner will have in this property after
See,
the
the
flat.
developer, see from the perspective of the developer, developer has entered into a development agreement, he'll rebuild the property entirely, demolish probably and rebuild.
Yes,
Now, if there is an injunction restraining him from transferring or whatever, doing whatever, dealing with his portion,
not the developer's portion, my lord, only the owner's portion, because he's the owner, my lord. His allocated share in the flat
in the flats to be constructed.
yes.
But that's beyond your prayer in the trial court also. That's beyond your prayer in the trial court.
No.
How far can we mold a relief? We'll be granting something which you have not asked for even.
But the order of injunction that I have prayed is injunction on his assets, my lord, that he has. Today, my
Yes.
lord, the immovable property that he owns,
Already entered into a development agreement.
he has entered into, and this fact was before the court below, my lord, that had shown, my lord, the registration, my lord, the document.
No, we are convinced that he's going to, but he has transferred, not transferred.
Yes,
He has
not yet.
retained rights in his portion.
No,
In the development agreement, he has retained rights,
he has
his
retained.
portion which will be given to him after construction.
Should be, because I don't have, my lord,
It will be a prospective injunction, Mr. Singh.
my lord, can this be restricted that whatever his share in the flats be, my lord, will to the
Has been
extent
constructed
to the
already.
extent of 70 lakhs only, my lord.
So, construction of a new building has been made already by the developer.
That my learned friend will tell, my lord, to the status of the
That's not-
property.
Then what can we injunct him from doing? They're the owners.
My lord,
They've entered
he,
into
my lord,
development.
he is the owner. My lord, he has a right in the property, my lord. Now the construction will come up.
Is the development agreement a part of the record?
My lord, I only got it from the website where, my lord, I got that this property, but because there is search Quadi property, my lord. I got a search which would show that that Mr. Dasgupta's client had entered into development agreement with Mr.
That won't suffice
so that-
because
so-
development agreements are of different grades. I mean, we don't
I
know what
don't
has
have
been
the document,
transferred
my
by
lord.
him.
I do not have the development agreement
How
with
can
me.
we give an injunction in thin air? I mean, we don't know what to give injunction
My
on.
lord, this is why, my lord, where Mr. Dasgupta comes in, my lord. He says he has a share in the development agreement which would be given to the owner's allocation share. There are certain number of flats will come to him.
Yes, Mr. Raj, what do you say?
But but I'll not address your lordship on the merits of the matter. But I have my defense. I've filed my written statement. But that will be tested in trial. But insofar as the interim orders or interim reliefs are concerned, it is an admitted position that there is a development agreement. But the development agreement has not been disclosed. So
The
my lord, I
development
cannot,
agreement, we have to have a copy of the development agreement at least.
my lord, if your lordship
You have
directs,
disclosed that in your written objection or
no,
written
no,
statement.
no, the development agreement has not been disclosed. The case in the written objection as well as the written statement is I got this money on account of commission. But that will be tested in trial. I'll not trouble your lordship with that.
No, but this is a fit case where 38.5 should be invoked in the garb of.
I understand. I understand. No case of security being furnished may have been made out, but some interim reliefs may be the plaintiffs may be entitled to.
Then we have to ask you to secure the money.
But I do not. But the
This is a-
security.
we can mold the relief and take it as an order 38 rule 5 scenario.
But that is
Is
why.
it people given you money
But
admitted?
I understand. But that is why I was beseeching your lordship if I could disclose the development agreement, and I may be restrained from alienating my share, whatever I get from the development agreement.
We don't know what you have retained for yourself.
But I shall disclose the development agreement. Kindly gives me 1 day or 2 days. But I'll disclose.
One day, come back tomorrow.
But I'll come
Sir
back.
Tajud. We'll keep it at the order 41 rule 11 stage. It may be disposed of also if both parties agree, we can also dispose of the main
Yes,
appeal.
Lord. Can
Yes,
be
my lord.
disposed of. Well, lordship will kindly keep
Day
it
after
day
tomorrow. Day after tomorrow.
Day after.
Very good. The appellant, comma, being,
Against all the.
what is your age?
My lord, I'm 72 years today, my lord.
Being a septuagenarian, comma, granted loan to the respondent number 1, only to respondent number 1.
Only to respondent number 1, at the instance of the respondent number 1, to the others.
Respondent number 1, comma, allegedly at the instance of the other respondents, full stop, next para. Although the quantum of such loan is admitted, comma, it is submitted that the learned trial judge disbelieved the case of the plaintiff and refused and dismissed the application for injunction filed in a suit filed by the plaintiffs for
Mother, Aruna.
suit is for recovery of the money.
Yes, my
For recovery of the money. For sub next para, learned counsel for the appellant submits that it has come to the notice of the appellant that in the meantime a development agreement has been entered into by the respondent number 1 with third parties. Full stop. It is submitted that, comma, in the list, comma, the respondent number 1 be restrained from selling his share, from transferring and or dealing with his share in the property to be constructed in the the building to be the construction which is to come up on the developed portion of the suit property, comma, to the extent of the shares of the defendant number 1. Full stop. Next para, learned counsel for the defendant respondent number 1 submits that he has indeed entered into a development agreement. Full stop. On the query of court, comma, learned counsel for the respondent number 1 respondents seeks a day apostrophe accommodation, 2 days accommodation to furnish a copy of the development agreement. Full stop. We find that a fit case for injunction and stroke or relief under order 38 rule 5 of the code of civil procedure, comma, by molding the reliefs made in the injunction application, comma, has been prima facie made out. Full stop. However, comma, in the absence of the development agreement, comma, this court is not in a position to pass appropriate orders, comma, since the extent to which the defendant stroke respondents have alienated stroke parted with their shares in the suit property by virtue of the said development agreement will affect the outcome of the injunction application. Full stop. Accordingly, let the matter stand adjourned and be listed under the same heading. Listed under the heading for orders on June 18, 2025, comma, when the respondents shall furnish a copy of the development agreement entered into by them with an advance copy to the learned advocate for the appellant. So, acha, এটা for order-টা to be mentioned এর পরেই দিয়ে দেবেন. It will be immediately after the to be mentioned because we intend to take up the applications first from tomorrow. This will appear immediately after the to be mentioned,
Very
day after tomorrow.
Two small changes, my lord. It's not respondent number 1. It's respondent 2 and 4. The father and my lord, the wife. The
What
properties are of not R1, but it's of respondent 2 and 4.
properties of 2 and 4?
Belong to 2 and 4.
2 and 4. And there are 2 development agreements, not 1, my lord.
Development agreements করে দিও.
And instead of respondent 1, 2 and 4.
আর প্রথমেই যেখানে করেছি লোন নিয়েছে রেসপন্ডেন্ট নাম্বার 1, কিন্তু বাকি যেখানে রেসপন্ডেন্ট নাম্বার 1 বলে গেছি সব রেসপন্ডেন্ট নাম্বার 2 and 4.
Yes, my lord.
2 and
I stand
4.
corrected. But
প্রথমটা শুধু লোন নিয়েছে রেসপন্ডেন্ট নাম্বার 1. আর ডেভেলপমেন্ট এগ্রিমেন্টস
But, will your lordship be kind enough to make one change? But quantum, lordship has mentioned quantum of loan. Will your lordship be kind enough to make it quantum of the amount received? Because my defense is it was not a loan, it was by way of a commission. But the rest of the order, I'll not travel. Instead of loan, because that will effectively take away all my defense.
কোয়ান্টাম কথাটা যেখানে আছে, কোয়ান্টাম দিয়ে ফাইন ফাইন কোয়ান্টাম অফ লোন করেছি, কোয়ান্টাম অফ অ্যামাউন্ট রিসিভড, লোনের বদলে অ্যামাউন্ট রিসিভড।
I'm so grateful.
My lord will kindly grant me leave to stamp punch, my lord, the supplementary affidavit, because this is, my lord, not on bond paper, my lord.
Take this.
I'll take back stamp punch and it, because, my lord, the department will not do it unless I am granted leave, my lord. It's not an A4 bond paper, my lord. It's normal paper. my
আচ্ছা,
lord.
লিভ ইজ একটা লাইন অ্যাড করে দাও, লিভ ইজ গ্রান্টেড টু দি লার্নার, লিভ ইজ গ্রান্টেড টু দি অ্যাপিলেন্ট to file a supplementary affidavit on the returnable date with an advance copy to the learned advocate for the respondent.
Let's
Grateful.
leave to stamp punch, my lord. I've served, my lord. The department will not stamp or punch it because it's not an A4 bond paper, my lord. So this leave has to be granted, my lord. It's not on the normal paper that we normally affirm, my lord. It's a normal.
How can you give the leave then? That is the rule
Well,
of
the
this.
person is in Delhi, my lord. He has been detected with stage 4 cancer, my lord, after the appeal has been filed. So at its
Leave is granted to the appellant to affirm such bond paper, affirm such supplementary affidavit executed on what is the
normal A4 size paper.
on normal A4 size paper, in view, keeping in view the fact that the appellant is residing at in Delhi, and it will not be possible in so short a time to have it executed properly. First up, the concerned department shall accordingly stamp punch the supplementary affidavit on the paper on which it has been executed at present.
I'm deeply obliged, my lord. এটা দিয়ে দিন দুটো। হয়ে গেছে, অর্ডার হয়ে গেছে।
টাকাটা ঝেড়ে
Item number 9, my lord, I appear for the appellant, my lord.
করে দেবো, দয়া করছেন সরি আমি করবো।
But this is an appeal, my lord, against, my lord, an application, rejecting an application. under
What is the
section-
defect? Let us just check.
defect, my lord, section 24, section 25, my lord, of the Hindu Marriage Act has been rejected, my lord, by the court below, my lord. Against that, my lord, the since and decree has been drawn up.
Decree. Suit was there was a divorce suit.
Divorce suit also, and also there was an application for separate application for permanent alimony, my lord. That permanent alimony application has been rejected, suit has been decreed.
Your suit has been decreed.
No, this suit.
Their suit.
Their suit has.
You are not challenging the divorce decree.
The divorce decree. But permanent alimony, my lord, has been rejected, my lord, holding that I am not entitled to get alimony. Although, my lord, at the interim stage, my lord, the under section 24, my lord, alimony was granted. Only the two points that has been raised, that neither of the parties adduced any evidence as regards the income of the other. Rate for permanent alimony only for medical expenses suffering from arthritis, but no medical documents has been given. No alimony paid for daily
Mr.
basis.
Sten, can we record your submission that you are not challenging the divorce decree?
My lord, already an appeal has been filed, my lord. Let the
Separate appeal has been filed.
separate appeal has been filed. Let the appeal appear, my lord, we will withdraw that.
No, that is a different proposition. But this separate appeal, as of today, a separate appeal is pending against the divorce component. So, yes, why was it rejected? Let us see that portion.
But
That you have failed to. What about the court invited affidavits from both parties?
my lord, affidavit, evidence,
Do
all,
they have any asset?
my lord, the affidavit of assets all were filed.
No, is there any asset of the husband? Does the husband has any asset?
No, he has denied everything that he has any asset. Although he is working, my lord, as a contractor, electrical contractor in various.
Zero amount has been given. No order has
amount
to
has been given. No amount has been given.
Why?
My lord, the reasoning at page 8, my lord. Page 8.
Only this.
Only this. I find the prayer for the permanent alimony only for our medical expenses, for an illness of arthritis, but to show the fact that she is in fact suffering from.
You have not paid for alimony for daily basic
But
needs.
that has been paid, the application.
Was the application peculiar order? Yes.
But the application, the prayer portion, we'll see at page 13, entitled to get substantial residential accommodation for the same, such a sum of 20 lakhs may be kindly be awarded at a time. Thereafter, total claim of permanent alimony comes to this
What is the logic of this? Oh, 21 lakh 60 and
21
20
lakhs
lakhs
is, 21 lakhs is that she will be surviving for 30 years, 6,000 per month.
There is no child of the marriage. See the body of
Page 12, last part, and the page 13, the prayer
So let us see what is your abhorrment. Whether it is only for rheumatoid arthritis. You have not stated that you don't have any income.
No, my lord, I don't have any income so far as.
Yes, no personal.
And my lord will kindly consider, page, so far as the evidence, page 67, page 67 is the order passed by the Honorable Court, on the 24 applications. And page 69 is on the 125 proceedings, Interim maintenance was granted.
To the tune of rupees?
In the tune of rupees 4,500. My lord can direct also, at least that be paid, my lord, and.
That was granted in 2012.
My lord. Thereafter, continue.
What is his income according to you? According to him?
He has stated he has no income. He used to work, now he is not working, and his brothers are looking after him. That is his case.
The brother started looking after the decree. Till the decree, you are getting alimony.
Right.
4,500.
5,000. That is the 125 proceedings, margin of the both.
Yes.
5,
You did not ask for an enhancement, only 5,000.
No.
We will direct that for the time being to be given. The office has given a report as to the appeal being defective. Full stop. However, learned counsel for the appellant wife clarifies that in the self-same order stroke decree, the learned trial judge was pleased to decree the suit for divorce filed by the respondent husband and dismiss the appellant-wife alimony, permanent alimony application under section 25 of the Hindu Marriage Act, being miscellaneous case number 01 of 2019. Full stop. Next para. Whereas a separate regular first appeal has already been filed against the divorce decree, which is now pending in this court, the present miscellaneous appeal has been preferred only against the component of the impugned decision, whereby the permanent alimony application was dismissed, which is an appealable order. Full stop. We agree with such contention and accept the proposition that the present miscellaneous appeal is quite maintainable, being directed only the component of the impugned order, whereby the permanent alimony application of the appellant wife under section 25 of the Hindu Marriage Act has been dismissed. Full stop. Accordingly, the defect pointed out by the office is deemed to stand cured. Full stop. Next para. We find a sufficiently strong prima facie case for admission of the appeal being made out, since the learned trial judge, while dismissing the permanent alimony application as a whole, failed to take into consideration the fact that the appellant wife was already enjoying alimony pendentility throughout the pendency of the suit. Full stop. The learned trial judge also proceeded on the apparently erroneous premise that the prayer for permanent alimony of the appellant wife was restricted to the cost of treatment of her rheumatoid arthritis, whereas the alimony application sought both a right of residence as well as consequential payments, as along with permanent alimony for the daily living expenses of the appellant wife as well. Full stop. The appeal is admitted and will be heard on the above questions as well as the other grounds taken in the memorandum of appeal. Full stop. The appellant shall serve a copy of Can 1 of 2025 on the respondent, indicating that the application shall be listed in the monthly combined list of cases for the month of July 2025, when an affidavit of service to that effect shall be filed by the appellant wife. Full stop. Next para. Since, comma, till the disposal of the suit, comma, the respondent was already paying alimony pendently to the appellant to the tune of rupees 5,000 per month, comma, we direct we direct the respondent to go on paying an amount of rupees 5,000 per month to the appellant wife on an ad hoc basis till disposal of the present application. Full stop. It is made clear that such payment shall be without prejudice to the rights and contentions of either party in the final hearing of the application and the appeal. Full stop. The first of such amounts shall be paid for the month of June 2025 by June 30, 2025, and thereafter, comma, by the last day of each succeeding month for such current month. Full stop. It is made clear that the above direction shall be subject to the outcome of the present application. We are not directing arrears of alimony at this moment because we'll dispose of it. This is an ad hoc amount.
Let the first appeal file against the decree be tagged with this.
আচ্ছা ফার্স্ট অ্যাপিলের ইয়েটা নিয়ে নিন তো, ওটা এমনি জাস্ট মেনশন সিটটা নিন। রাইট টু বি মেনশন মিস্টার সেন, রাইট?
I have given the number.
No, to be mentioned, right? To be mentioned. Otherwise, it will go under the wrong heading. To be mentioned for withdrawal. Write that and just hand over the slip. It actually list দিয়ে দেবেন. To be mentioned for withdrawal. But 10.
My application. Interesting matter, a suit for.
But what is the defect, Mr. Banerjee?
A memorandum of appeal, these 3 words have gone missing. If your lordship gives me the liberty to correct it, I'll just.
What is the
That's
appeal?
what I'm told is that, look, this is Exide Industries is before your lordship.
Yes.
In 2006-7, I get into this absolute conversation with somebody.
Mr. Banerjee, can you just take the microphone a bit?
I'm sorry.
Here,
Yes.
This side acoustics are very bad.
Look, 2006-7, Exide gets into a conversation with somebody who claims to have a process payment with regard to detecting.
Yes, sorry, who claimed to have?
This defendant in 2006-7 claims to have a patent, a process patent on how to understand in a battery whether the battery, what is the life of the battery. This wasn't the acid regulator of a battery. This was in 2006-7.
Yes.
That discussion failed, nothing happened. Now, Milord, he goes about writing to everybody, Exide America, which is a different company,
Yes.
to BBC, saying, I am a thief. The company is a thief and the company is indulging in fraudulent practices.
What have you done? You have usurped his
I have
patent.
nothing. His patent is also not there anymore. I have.
So what is his allegation? What have you done?
This is a suit for defamation. I asked for an injunction on the first
What
day.
is his allegation? What have you done?
I'll show you. I'll also show you. Let's see.
Thief, why? What have you stolen?
Well, kindly have a look at page 81. His allegation is that I've stolen the patent itself. But kindly have a look at what is
Does
going
he have a patent? You said he doesn't have a.
It's expired. I have had nothing to do with him anymore. That also we've done. He's kindly have a look at page 81. I'll show 1 or 2, Milord. It will make an interesting read. This is to Excite Technologies in USA. This is an email that a defendant, respondent writes. Dear original.
You are affiliated to that.
No, not
You're not
at all.
connected
Just the
with
name Excite. My name is Excite India. So this is a defamatory. Kindly have a look at what he writes.
Yes.
I am to bring to your attention a grave matter that affects not only our organization but also the reputation of your esteemed company. We are a R&D company based in India, and we have been a victim of harassment and exploitation by Excite India, a fraudulent company based in Kolkata. I'm a listed company, Lord. Excite India has been illegally using your company's name and reputation to sell used products causing harm to innocent customers and damaging the goodwill of our brand, of your brand. Furthermore, they have been stealing our
So your defamation suit was dismissed.
defamation suit injunction was not granted. So ex parte ad interim was refused on the ground that truth is a defense. He might have defense as a truth, and therefore I'm not going to grant you an injunction. But it is imperative, I'll tell you, Lordship.
Produced your documentation regarding you being a company, registered company, and all this.
Yes, yes.
Because his allegation is also that.
The allegations are. Bears with me for 2 minutes. I've seen these letters myself.
Regarding his patent, yes, we can appreciate that he may have a defense and all that.
Yes, but he can take recourse whatever in law he has.
Exploitation by Excite India fraudulent company, these are obvious.
It's a listed company, and not just that. There are more. He writes to BBC.
Saying what?
BBC is saying, please go out and put it out on your Ray and give him money to fight a litigation against me because I'm a thief. He uses this word. I'll show that.
Which BBC? British Broadcasting
British Broadcasting Corporation.
Where is that?
Please have a look at page 80. At 91, please have a look at. At 91, my Lordship will see.
Is this Kollul Basu?
No. Kindly have a look at the CC in the email at page 91. Channel BBC News. We are sorry, BBC. We are fighting with the world's #1 fraud company. And then he writes to me at 12:30 saying it's because of you that I've become mad. And now, Mulot, what is more troubling from my client? Now he started.
So what has the BBC done? I mean,
thankfully, BBC has not done anything.
What is it expected to do?
To give them money. BBC will donate money to the defendant, so defendant can fight a case against me.
Why should BBC give that?
That let him come and explain. With this can't go. Now the bigger problem, he started sending bloodstained letters to my officers.
Bloodstained?
I don't know if it's blood or red. But
have you got it tested whether it is his blood? Get a DNA test. We're not convinced of the privacy case.
Please have a look at all this. So what he sends is he sends these email.
Does he mention anywhere he's a parliamentarian? Otherwise, we won't take up the matter. We'll release our person.
So, and your Lordship will open. If you open the attachment, this is what comes. Saying he's.
What is the injunction of sort?
Injunction
won't be preventing him.
Injunction won't be preventing. That I have.
Anyway, what injunction? What injunction did you see? Why was it refused? Let us see the reasoning of the trial.
Yes,
that will also be interesting.
Page 1. Page 1. Page 154.
Yes.
Truth can be a defense, therefore.
Truth can be a defense, definitely.
Yes, which is why we prefer the appeal. At 155 at the bottom, your Lordship will find. At 156, actually. In this context, I would like to mention.
We have seen. Where is your injunction prayer, Mr.
Yes, not in this one also we have.
In the trial court?
Here, your Lordship, we prayed for those orders.
Same thing, that's it.
Same, yes, same. Kindly consider page 33I, 34I. I have one more request. This is actually creating some kind of trauma to my employees. Your Lordship will also restrain him from sending these intimidating emails, these blood-stained pictures of him coming and trying to eat me up. All these, he started sending these emails now.
If he's restraining from sending blood-stained letter, he'll stain it with something else.
No.
So let us restrain him blanket fashion from
Kindly
sending any income.
Kindly
but let us see your prayer first, whether we can grant.
34I. Either through email, social media, or through any other internet or cellular medium, or any printed manner containing the words or any words similar to the ones used in letters and or communications, Annex G of the plaint, any other communication. The II also is important. He started threatening us.
Leave is granted to the learned advocate on record for the appellant to make good the defect pointed out by the department by carrying out the necessary correction to the memorandum of the appeal. Next para. Learned counsel for the appellant contends that the learned trial judge erred in law and in fact in refusing the prayer for ad interim injunction sought by the plaintiff in its suit for defamation against the defendant by completely overlooking the damaging and immediate nature of the allegations of the wild allegations made against the plaintiff company. For sub next para, we find from the impugned order that the learned trial judge primarily proceeded on the premise that the defendant may have a good defense insofar as the plaintiff company usurping the patented technology of the defendant is concerned. Full stop. Next para. However, from the annexures to the present application, annexures to the application filed in connection with the appeal, which are also placed before the trial court, we find that the allegations are palpably unacceptable and are not confined merely to the purported usurpation of the patented technology of the defendant stroke respondent. Full stop. In the several communications made to different unconnected authorities, the defendant respondent has made patently baseless allegations such as the appellant company being a fraudulent company and other such damaging statements, which prima facie have the effect of adversely affecting the business of the appellant as well as being patently defamatory in nature. Full stop. Accordingly, the defendant stroke respondent stroke opposite party shall remain restrained by an order of injunction from in terms of the prayers made in Can 1 of 2025, to the effect that the defendant stroke respondent shall not, by himself and or through his men and agents, threaten, publish or circulate any article or issue any statement to the appellant and or to any third party, either through emails, social media, or through any other media whatsoever, containing words similar to the ones used in the letters and communications annexed as Annexure G to the plaint filed in title suit number 639 of 2025, as well as any other communication having the purport or effect as mentioned above or fitted to FITTED to injure or fitted na kore or designed to injure the business and reputation of the appellant and stroke or any other threatening communication in any other manner whatsoever, having the effect of defaming and interfering with the business and regular affairs of the appellant company till disposal of the application. Full stop. An affidavit of service to that effect shall be filed by the appellant on the returnable date. Full stop. The application shall next be listed in the monthly list of July 2025. Thank you. Please carry out the correction to the memo.
Yes, yes, not immediately.
Right.
Very great. না না এখানে ওসব হয়ে যাচ্ছে
যত রকম পাগল ছাগলের পাল্লায় খারাপ হয়ে গেছে বিবিসি কে লিখছে পয়সা দাও কালকে এই যখন অ্যাপিয়ার করবে তখন ইন পার্সন না অ্যাপিয়ার করে Yes, Mr. Banerjee.
Appeal from refusal to grant ex parte ad interim order of injunction in a suit for specific performance of 2 oral agreements and 1 written memorandum of understanding.
Why refused?
It says that there is no prima facie case made out. Those 3 tests only indicated that nothing has been made out and is refused.
2 oral agreements.
2 oral agreements
And 1?
And 1 memorandum of understanding pursuant whereto I have paid 25 lakhs of rupees to the defendant who was a facilitator for sale of certain lands to me. I was proposing to build as residential commercial building. This defendant he either co-owned or owned certain lands or his relatives and friends, my lord, were owning certain lands. My lord, he entered into an agreement with me, my lord, verbally and through, my lord, this memorandum of understanding, saying that those lands, my lord, would be sold to me and he would facilitate. My lord, I paid, my lord, 25 lakhs of
But
rupees. my lord,
if
to
he
him.
is not the owner of the
My
property,
lord,
then
he is also owner in some of the lands. My lord, those deeds are annexed.
those lands we can appreciate. But regarding the other lands, if he is a facilitator only, then what sort of injunction did you ask for?
My lord, nothing should be done, my lord, with those properties. Properties should not be
But if he is
alienated.
not the owner of all the properties, Mr. Banerjee, can we
The
restrain?
properties where, my lord, he's a owner and he's a co-owner otherwise.
Have you delineated those regarding which he is the owner? And
My lord,
because
we
all properties
have a, my lord, schedule of ownership at page 69.
60.
9.
These respondents are either jointly or separately
Yes.
the owners of this
Yes,
property.
yes.
They have also given out to you that they'll sell other property. They'll facilitate sale of other properties, or these are the only properties?
No, there are other properties as well.
Let us see your injunction prayer.
My lord, the application for injunction, my lords, will get at, my lord, page 50. Prayer is at page 65.
It is similar to what you have prayed here.
Should be, my lord. I have not, my lord, really.
No, not. Don't go by should be.
My lord,
If you have not checked up, you check up. Should properties schedule, yes.
yes, my lord, same. My lord, there is a prayer for stay of operation, which, my lord, I am not, my lord, asking for. Prayer B is, my lord, the same relief.
Let us see the impugn order once just before. A prima facie case for hearing of the appeal has been made out. Hearing of the appeal on merits has been made out inasmuch as the learned trial judge, without adverting to the relevant averments and annexures of the injunction application filed in the trial court, merely refused to grant ad interim injunction on the ground that the defendants are required to be heard, and that no prima facie case has been made out, by overlooking the averments on oath to the effect that the defendants respondents are owners of some properties and facilitators in respect of others, and assured, by two verbal agreements as well as a written memorandum of understanding annexed to the papers in the court below, to sell to transfer the suit properties in favor of the appellant. Push up next para. Although we have some doubt at this stage, accordingly, the appeal is admitted and will be heard on the above question as well as the other grounds taken in the memorandum of appeal. Push up next para. Can 1 of 2025 is taken up for hearing. Full stop. Although, at this stage, we are a bit hesitant regarding whether we can grant an injunction in respect of properties to which the defendants stroke respondents have not been alleged to have ownership, a strong prima facie case has been made out even at this stage as regards grant of injunction with regard to the properties which the plaintiffs has alleged to be under the ownership of the defendants stroke respondents as mentioned in the chart given at page 69 of the present application. Footstep next para. Accordingly, the respondents and their men and agents shall remain restrained from dealing with and or creating any third party interest and or transferring or alienating in favor of third parties, till disposal of the present application, any of the properties as mentioned in the annexure at page 69 of the of Can 1 of 2025, which are enumerated as below, colon diye niche in dag number 18. Roman 1 দাও নিচে colon দিয়ে, within bracket deed number 17186 of 2012, bracket closed. All are in Mauza Donnagar,
Yes, my lord.
Gopalpur, Chandigarh.
Yes.
Full stop. In Dag number 18, comma, Khatian number 469. Roman 2, deed number 16610 of 2012. In respect of Dag number 7, comma, Khatian number 469. Roman 3, deed number 12736 of 2012. In respect of Dag number 65, Khatian number 469. And Roman 4, deed number
So
12735
there are
of 20.
three darks, my lord, under the number 12736, 65,
আচ্ছা
66.
এর আগেরটা যেটা বললাম 12736 দাগ নাম্বারস
Great.
65, 66 and 67
Great.
খতিয়ান নাম্বার যেটা বললাম আর 4 হচ্ছে ডিড নাম্বার 12735 of 2012 দাগ ইন রেসপেক্ট অফ দাগ নাম্বার 12 কমা খতিয়ান নাম্বার 469 কমা অল ইন মৌজা ডোননগর DONNAGAR ডোননগর ডন নগর আর কি কমা JL 48 কমা গোপালপুর চণ্ডীগড় কমা JL 50 comma West Bengal. Full stop. The appellant shall file an affidavit of service to that effect on the returnable date. Full stop. The application shall be listed for hearing in the monthly list of July 2025.
Grateful to your lordship.
You have granted till disposal of the application for the time being.
Grateful, my lord. Grateful to your lordship.
তন্ময় যদি ডাউট থাকে নাম্বার তাহলে 69টা
Should I, my lord, tear off the page and make it over to my lord's court?
Pardon?
office as well? Should I tear off page 69 from my copy, my lord, and make it over to my lord's?
No, need not. It's a part of the record.
Grateful.
আচ্ছা ভেরি ওয়েল ইউ
I
ক্যান
can
ডু
do
দ্যাট
that.
তাহলে 69 টু উনি তোমার দিয়ে দিচ্ছেন ওটা দেখে দেখে মিলিয়ে আলাদা করে ইয়েস থ্যাংক ইউ মিস্টার ম্যান দ্যাট উড হেল্প ইউ
Grateful.
12 yes
Item number 12, madam, appearing for the plaintiff appealing before your lordship, madam.
yes yes
No, last occasion, your lordship directed me to serve a copy, madam. I have
it
served.
appeared yes what is it against just remind us
Yes, madam. This is a suit, madam, wherein I have prayed for.
take it up the mic
But this is a suit, madam, wherein I have prayed for an injunction that, madam, this property is totally different property from the mortgage property. Now, my lord, injunction has been refused, ad interim refusal of the injunction, madam, I am before your lordship. Now, my lord, before your lordship proceeds, my lord, I'll just brief lordship only 1 minute. What is the facts, madam?
what will be your defense
My lord, they have alleged that I have proceeded with the surface proceeding for attachment of another property, which is not a secured property. That is not right. I'll satisfy your lordship.
which is a suit property I mean they say suit property is a different
They say suit
property from this
I say no. This property was
no they say the suit property is not one of the mortgage properties not one of the
yes,
secured assets
even I have not proceeded in terms of surface proceedings, so far this property is concerned.
so then regarding this injunction you cannot have anything to say
My lord, what I have made an application before the commercial court at Delhi under section 9 of the Arbitration Conciliation Act. Since the secured asset is in problem, so secure my claim of 3 crores, I have made an application under section 9 for injunction, which was refused, which they are contesting. Now they want
Not refused.
no let us hear them because we'll come back to you
yes. Now, my lord, they want an injunction, injuncting us from paying for this security before the commercial court. If your lordship kindly sees the impugned order once.
but if this was not a secured asset how
Yes, my lord, I have not claimed that this is a secured asset. I have not claimed that.
then can you at this stage can you I mean encumber this property or have any right on this property
My lord, that is why I have approached.
that is the meaning of secured asset
Since
that will cover the security
yes,
at a future stage if the secured assets do not meet your demands if you after sale also then only you
that
can-
was not allowed, my lord. That was not
So,
because
but this injunction if this is admittedly not a part of the secured asset
my lord,
they're entitled to injunction regarding this property
my lord, injunction as to what?
what have they prayed we don't know.
that is why, my lord, I am
from disturbing that peaceful person
yes, my lord. If your lordship kindly
and
My plain
kindly see the impugned order once.
you cannot transfer alienate you they cannot create any third party
now, my lord,
they are not the owners of this
now
property
what has happened, my lord?
they cannot disturb your possession only to that
Yes,
effect
but they are trying to create a charge on the property, which is also a mortgage property to a different bank. And my lord, I have obtained an order, my lord, from this court wherein an injunction has been given indirectly that till the pendency of the
so then
demarcation
at best you are entitled to injunction subject to hearing
Yes, my lord.
injunction not disturbing your possession and from encumbering this property in any manner, charging and or encumbering. This much only. What can you have to say against that?
My lord, if your lordship kindly sees the
We'll throw in a line of without due process of law.
My
Without
lord,
due process of law, with due process of law, they can.
that is why we have approached
My
in
lord,
terms of
That's why you are putting in that. Because with by due process of law, you can do that.
By due
that is
process
what
of
we have
law-
done actually.
No, they have
Yes,
not
my
done.
lord.
Well, under the RDDB Act, there is a provision.
We'll dispose of the appeal.
Yes,
We'll grant injunction.
Yes, ma'am.
Ad interim has been
Yes,
refused.
I didn't.
We'll grant injunction to suit,
Yes, ma'am.
restraining you from disturbing their peaceful possession and enjoyment of the property, and or from creating any charge or encumbrance in respect of the property without due process of law. This is the exact language you use.
Well, I have nothing to say.
The conspectus of the present in view of sufficient questions of law and fact have been raised, we admit the appeal to be heard on the grounds taken in the memorandum of appeal. Full stop. Next para. Since both sides are represented and both the contesting parties are represented and the ambit of the appeal is extremely short, coextensive with the scope of hearing of the injunction application, on consent of the parties, we are taking up the appeal and the application together for hearing. Only to that. Full stop. Next para. The plaintiffs appellants have filed a suit claiming their title and seeking injunction in respect of a property which, according to the plaintiff, is not the subject matter of the mortgage created by the plaintiffs in favor of the Punjab National, in favor of the PNB Housing Finance Limited, of which the defendants stroke respondents are the functionaries. Full stop. Next para. It is contended that despite the same the defendant stroke respondents 1 and 2, through the PNB Housing Finance Limited, are seeking to disturb the plaintiff's possession and encumber the property unlawfully. Full stop. Next para. Learned counsel appearing for the contesting respondents numbers 1 and 2 submits that the PNB Housing Finance Limited has already initiated an application under Section 9 of the Arbitration and Conciliation Act 1996 in Delhi, where the ad interim prayer having been refused, and a challenge has been preferred. Full stop. It is submitted that by virtue of the present injunction, the plaintiffs are seeking to frustrate the said proceeding. Full stop. Next para. However, we find upon hearing learned counsel for the parties that prima facie, the subject property involved in the present suit is not a secured asset in the mortgage created in favor by the plaintiffs stroke appellants in favor of PNB Housing Finance Limited, and as such, the respondent numbers 1 and 2 cannot create cannot encumber or charge the suit property and or disturb the peaceful possession of the plaintiffs in respect thereof without due process of law. Full stop. Accordingly, FMA 758 of 2025 along with Can 1 of 2025 are disposed of, thereby restraining the defendant stroke respondent numbers 1 and 2 from disturbing the peaceful possession and enjoyment of the plaintiff's appellants in respect of the suit property and or from creating any charge or encumbrance on the suit property till disposal of the suit without due process of law. Full stop. There will be no orders to cost. Full stop. Next para. We make it abundantly clear that the above findings are tentative in nature insofar as the suit is concerned, and the learned trial judge shall adjudicate the suit independently on its own merits without being influenced in any manner by any of the observations made in our order and or the order impugned here.
I prefer only one instance is that this order will not prejudice the proceeding pending before the.
It is further made clear that nothing in this order shall adversely prejudice either of the parties in the proceeding pending at Delhi, which has been referred to above.
One prayer,
and or any other proceeding.
Because my other contention was that they could have proceeded under the Sufficiency Act, but they have not, because I have
defense in that proceeding. You have already been successful at the first stage there.
Yes, my lord.
You argue your case there. Thank you.
Grateful.
Thank you. হ্যাঁ জাজমেন্ট ফরম্যাটে হবে অ্যাডমিশন তারপরে অ্যাডমিশন কেউ একসঙ্গে হচ্ছে জাজমেন্ট ফরম্যাটে Why? দেখি।
Although she is residing there, my lord, according to my instruction, avoiding service.
What is the endorsement?
That the undelivered copper is not.
Intimation served, unclaimed. This is good service. We'll proceed. What is the application for? Second appeal has been admitted.
No.
Oh, acha.
Order 41 stage, my lord, the matter was dismissed for default on the ground that due to my.
Oh, this is the restoration application. We'll allow the restoration and take up the appeal for under order 41 rule 11 hearing right now.
Not right now.
No, no, no. You have to come prepared.
No, I have forgotten. My lord, I've forgotten everything. Give me.
We find from the affidavit of service filed today that despite intimation, comma, the respondent has not claimed the postal service, full stop. We treat the same to be proper service and take up the application for hearing. What is the delay in filing the application?
No delay, my lord.
Very well. Upon going through the averments made in the application, comma, we find that sufficient cause for the absence of the appellant on the relevant date has been made out, full stop. Accordingly, can 358 of 2015 is allowed, comma, thereby recalling the order dated December 11, 2014, dismissing for default SAT 4206 of 2024 and restoring the said appeal to its original file and number. Was there any connected application? No. To its original file and number. Full stop. Let the appeal be listed for hearing under Order 41 Rule 11 of the Code of Civil Procedure
Any date,
on June 23, 2025, next Monday.
Good.
But yeah, for the appellants, my lord. My lord, now, my lord, one
for
of
the
the-
respondents.
What is the defect? Defective?
My lord, defect. Well, defect কি আছে? My lord, I think, my lord, there is a small causes court appeal. That is the reason it's defective. It is not small causes court, my lord. It's a special causes court, my lord, which should be there, my lord.
No, we have put in the deficit court fees late. We'll accept that.
Yes, my lord.
No difficulty. Small causes court.
It is there, but it should be a special causes court because when it is transferred from the senior division, my lord, to another court, my lord.
But it was by chance a small causes court, but it was acting as a senior division.
Yes, my lord. Should be under 150 of them in the CPC as well as, my lord, should be, my lord. Now, my lord, my lord, one of the
No, you
appellants
also have to correct the two things you have to correct in the memo. Apart from that, one is that it will be judgment and decree dated.
such and such, my lord.
The date of the judgment is the date of the decree. So that you have to correct. It will be judgment and decree dated the date of the judgment, and decree dated such and such will be deleted. And the appeal has to be classified as an appeal from original order.
Order and
it will be decree.
Decree, my lord. Should be decree because it was dismissed, my lord. The
As a
plea
leave
was
is granted
dismissed.
to the learned advocate on record for the appellants to carry out the necessary corrections, comma, classifying the appeal as a memorandum of appeal from an original decree and deleting the date of the separate date of the decree as given in the preamble of the memorandum of appeal. Full stop, such corrections shall be carried out during the course of the day.
Yes, my lord.
Full stop, the deficit court fees belatedly deposited are hereby accepted. Full stop. The appeal, the defect in that regard, we deem to stand cured accordingly.
My lord, only one thing on one of the appellants have expired, my lord. That also has to be brought on record. His legal heirs are required to be brought on record, my lord. That's also there, my lord.
One of the appellants, his heirs are on record.
No, my lord, not there, not there. Appellant number 3, my lord, has expired, my lord.
Then carry out these. We cannot pass any order in the name of a
Yes, my lord, that is what, my lord,
Just
only.
sorry.
No, what we are saying is.
Lordship, just one submission, Lordship. If your Lordship would be pleased to fix the matter in month east of July, Lordship, subject to your.
No, they have to file an application. This will for the time being go out. They have to prefer an application.
Substitution to file for it.
Sorry.
The corrections you carry out.
The corrections carry out, but the substitution will do it. Thereafter, we will do
At
that.
this juncture, learned counsel for the appellant submits that one of the appellants has died in the meantime. Full stop. to enable the appellants to take out an appropriate application in that regard, comma, let the matter go out of the list with liberty to the appellant to mention for inclusion in the list as and when such appropriate application is filed.
Grateful, my lord.
Thank you.
Lord, obliged.
Thank you. Ajay Dipankar aছেন? Mr. Bose, you are for the appellant?
Respondent.
I am for the appellant.
Yes.
Helpless husband.
Helpless, why? Because in your hands.
They admitted some, was submitted on the earlier occasion.
What is that? You are filing an affidavit of service?
No, in opposition.
There was a direction previous.
Affidavit of compliance in respect of my lord
Assets.
Neha and Rajnish, as per that, the asset is being filed.
Where are your affidavit of assets, Mr. Bose? Combined with this?
Yes, combined. That was a direction. Now my learned friend wants to move an application bill for.
There was a direction to file affidavit in opposition as reply as well. I received it on Friday, so I couldn't prepare the reply.
This has become Friday.
Friday.
Why have you captioned this as affidavit of compliance of the division bench?
Compliance of the order passed on.
What sort of you should have checked up? This is an affidavit of asset and liabilities, as rightly mentioned in the back sheet. So this is the husband, this is the wife's.
So I am told this was told by the department that it should be prepared in this format.
Henceforth, you give up your brief and ask the department to give them legal
My
advice.
junior.
So this is the wife's. Yes, what do you want to do now? What has to be done?
Worship, on Friday I received the opposition, so I need some time to file the reply.
Use your reply then. Are you enjoying any interim order of maintenance?
Worship, there was an order of maintenance of
here in this court?
In this court, in this appeal itself, that was not being paid. So I have taken out two applications, one for implementation of that order and the other one is for enhancement.
So this is for enhancement?
As far as enhancement is concerned, my learned senior friend's client has filed the opposition. As far as the implementation is concerned, I have served, but I do not think there is an order for filing of opposition.
There is no direction.
Should he direct you to? You are complying with the order?
Yeah, the admitted amount I have paid within time. And the rest amount is disputed, but I found that there was a direction prior to the order passed by your lordship's court, November 19, my lord.
Yes.
My lord, this, according to me, my lord, there was a certain amount which was due and payable. That, according to my calculation, 2,40,000. That was given on 23rd of May, my lord. Now, my lord, before that, there is an order passed in court under section 125 of the Code of Criminal Procedure also. My lord, this
you have to pay the larger amount. That is a settled law, you know.
Yes, larger amount. But, my lord, this was calculated on and from the date when this honorable court has passed this order on an application filed by them. But the previous application that was directed to be ordered, that was also not given. I have found, my lord, checked out.
That was not
given to the paid to the my lord respondent.
So you have to pay that?
Yes, I have said. But I calculated. I asked him to calculate.
So that is your admitted amount,
including amount in this proceeding, my lord, I have given.
What about the other amount? Pay that
other amount, my lord, 125 proceedings that was passed previously. Prior to that, I found out, my lord, that was not given. So
then you should give it.
Yes, my lord. I told my client, my lord, to give it.
3,15,000.
That also comes within your admitted amount. Then what do you mean by admitted amount?
My lord,
whatever you admit is the admitted amount.
That is why I paid, my lord, that the calculation that was
in the meantime you will give them some time to use a reply. In the meantime you pay the dues.
Permit me, my lord, to respond to the application for implementation of the order.
So that is because the
but you have to pay and respond. I mean,
yes, I will. I have asked my client, my lord, to pay.
There was a direction to pay 25,000 every month. That is also not being paid. It's only about arrears that is being.
What does your client do, Mr. Bose?
Dr. Miller, onco surgeon.
Here also onco. You don't. Anyway.
Statistics, sir. In chamber, we come to know that you always think about law as statistics.
Cancer, statistics, and fish. Fish. These are the three USPs of Mr. Bose.
This is what we have been taught in the chamber. You always think about law and taking in account.
Mr. Bose, law, fish
That is
and cancerous. Yes. Anyway, on the prayer of learned counsel for the appellant wife, comma, the time for filing reply to the affidavit in opposition to the affidavit of assets and liabilities is extended for a fortnight from date, full stop. The respondent husband shall file opposition, comma, if any, to the application filed by the appellant wife for implementation of the order of alimony within a week from date. Full stop. Reply, if any, thereto shall be filed within a week thereafter. The applications shall be listed together for hearing on July 2, 2025, 2nd July. Your diary is, you are available on that day?
Yes.
In Calcutta?
July 2, Lordship, I have some difficulty.
You have some difficulty. Then when should you keep it?
না, ঠিক আছে, আমি তো-
1st July, 1st July?
1st July, my lord.
You have some difficulty. When do any
July,
of
my
you
lord, 3rd
have no
July.
difficulty?
4th July.
4th July.
4th is a Friday, so I
4th
think
is a Friday, so 7th July.
7th.
7th July, Mr. Bose?
Yes, yes.
No, no, consult your diary.
Yes, my lord.
You're all right on that?
Yes, yes, my lord.
July 7. Returnable date is July 7. আরেকটা line add করে দাও. It is expected that the respondent husband shall clear all dues, comma, if any, regarding interim alimony in the meantime. What is, you have acquired this habit, Mr. Bose?
I cannot match with your lordship's instant wheat, my lord.
Match with our
Shavian wheat, my lord.
Shavian wheat means as in Bernard Shaw. We'll discuss about this on the next returnable date. About the Shavian wheat and oncology. Yes. What is the matter?
Matter, my lord, pursuant to your lordship's rejection, my lord, at first, my lord,
Yeah.
all the defendants in the court below have been implicated as a pro forma respondent in this, my lord, case, my lord.
Why all defendants as pro forma?
My lord, only one, I was the respondent in the trial court, my lord. The appellant herein was the respondent in the trial court.
You are the defendant in the trial
Yes,
court.
in the trial court, my lord.
So the plaintiffs are the respondents.
Plaintiff are the respondent.
How can they be pro forma respondents? They are
Yes,
respondents.
yes, pro forma respondent. Because there are 70 respondents, my lord. Your lordship's direction was to serve the, my lord, party.
How many?
70.
We find only 10 here.
At first stage, then I have imputed them as a party pro forma respondent.
You
Pursuant to your
deleted the other 60.
Yes, I have imputed them as a party pro forma respondent pursuant to your lordship's direction.
They were co-defendants with you.
Yes.
Acha, but you have to mention them in the cost title of the applications.
I have filed, my lord, separate seat, my lord. Pursuant to your lordship's direction, my lord. Due to dearth of a space, my lord, I have filed, my lord.
The appeal is against what? A preliminary degree of partition?
Preliminary degree. Suit for a partition.
You've asked for a stay.
Yes.
Section 5 has to be allowed first.
Yes, section 5.
You have served copies?
Yes, I have served copies, my lord. Man, these are the affidavit of service.
What are the envelopes? What is the endorsement on the envelope?
Refused.
You have checked up all?
Yes, I have checked.
What is the delay in preparing the appeal?
Delay, my lord, I have stated in my section
1 to 62 days. Why? What is the reason? There is no reason at all.
Yes, my lord, I have stated, my lord.
You have stated that one, you have named an advocate. You have, the entire blame has been cast on the previous advocate.
No, my lord. I have
Read your paragraph 3
paragraph 3
of the section 5. That is the only explanation. You met one, the advocate's name is there, but due to his latches, could not be filed within time. This is the only allegation.
Paragraph 3, paragraph 4, paragraph 2, paragraph 3.
Yes, that is the only allegation.
Yes, my lord.
We are not satisfied. We shall dismiss the appeal on the dismiss the section 5 application.
No, preliminary
What is the blame of the advocate? You have not even explained.
Yes, I have stated, my lord. Namely, one Kamal Das and another Anil Das.
All the Dases are responsible.
Yes.
First paragraph, you say you met your trial court advocate.
Yes, namely one Kamal Das, who was the trial court advocate, my lord.
Yes.
Then
Please read out para 2.
Yes, that the order passed under trial court appellant made to the learned advocate, namely one Kamal Das. of the Tumluk Court after obtaining certified copy of the order to the case before the Honorable High Court. Appellant was
Read it in the microphone.
Yes, appellant was of the bona fide belief upon his learned advocate. The learned advocate first advised him to file this case under Article 227 of the Constitution before this Honorable High Court. And ultimately, after a lapse of 1 year, he advised him to meet with the learned advocate of the Honorable High Court. Then, paragraph 3.
He advised you to file Article 227 application.
Yes, yes.
What steps did you take to file a 227 application?
No, that I was not filing.
Ultimately, a lapse of 1 year, he advised you to meet the advocate of this court.
Oh, yes.
So during this 1 year, you did not grow suspicious that nothing was being done. What steps did you take to file the 227? Even if you are advised to file 227, nothing. And the next paragraph, you say you made you name an advocate of this court.
Yes, one Anil Das, my lord.
But he once again, due to his laches and negligence, what laches, what negligence?
No, he could not file, my lord, before this Honorable High Court, my lord.
Not acceptable. We are dismissing this application. Sorry. Application হয় নাকি? The affidavit of service filed to be kept on record along with the connected envelopes. Full stop. Since the service has been refused by most of the respondents, we treat the same to be good service and take up the application for condonation of delay for hearing. Full stop. Next para. The explanation given for the delay of 1262 days in preferring the appeal is absolutely cryptic. Full stop. In paragraph number 2 of the application, the appellant mentions the name of his advocate in the trial court and contends that the said learned advocate advised the appellant to prefer an application under Article 227 of the Constitution of India, and after a lapse of 1 year, advised the appellant to meet with a learned advocate of this court. Full stop. Next para. However, not a single line has been devoted as to what steps the appellant took for preferring, even if erroneously, such application under Article 227 of the Constitution during the said period of 1 year. Full stop. Next para. In paragraph number 3 of the application, another advocate, apparently practicing in this court has been named, and it has been barely stated that due to the laches and stroke-on negligence on the part of the said learned advocate, the appeal could not be filed in time, and ultimately the learned advocate returned back all the papers to the appellant, whereafter the present appeal has been filed. Full stop. However, we are unable to convince ourselves as to sufficiency of the ground in preferring the appeal. Full stop. Nothing is before us, nor any averment made in the application to show that the advocate who was instructed to prefer the appeal was properly paid, and or that the appellant took appropriate steps in contacting the said advocate in order to ensure that the appeal was filed in time. Full stop. Next para. Thus, we find that the reasons purported to be given for the prolonged delay of 1262 days in preferring the appeal is absolutely insufficient. Full stop. The negligence of the appellant is palpable from the said averments itself. Full stop. Next para. Although under normal circumstances a liberal view is taken in such matters, it has been held time and again by different high courts and the Honorable Supreme Court that such benevolence is not extended to a litigant who is either negligent or is not diligent enough to ensure that the appeal is filed in time. Full stop. Thus, we do not find any sufficient explanation for preferring the appeal beyond a period of 1262 days. Full stop. Accordingly, can 1 of 2025 is dismissed. Full stop. Consequentially, FAT 205 of 2017 stands dismissed as time barred, and accordingly, can 2 of 2025 is also dismissed. No arrest to cost. Next.
But this is the Appeal, my lord, from the order 1711, your lordship required the RP to come.
RP, yes. You are
But I am for the resolution professional.
stand.
Well, I'll tell your lordships, my lord, your lordships have put me on a kindly sticky wicket here. That's why perhaps I'm standing in the middle. Well, I am being appointed by the National Company Law Tribunal well, it's February 2024. Kindly marks the date, 28 February 2024. Well,
February?
28 February 2024.
Right.
Well, that's the initiation of the corporate insolvency resolution process in respect of the appellant number 1 company. Goes without saying, my lords, the appellant number 1 company has to be represented by the resolution professional, because the suspended board of directors, as per section 18 of the insolvency code, the power stands suspended. Well, that is settled now. Your lordship's judgment is also there subsequently. Well, now the question is, my lord, I am an officer of the court. I have to take an independent stand. But my respectful submission would be, because I have to point out what has happened, and your lordship perhaps have to take into account the subsequent events that has taken place in respect of this particular company. Well, whether suit filed, dismissed, suit filed in 2016, well, dismissed in 2019, appeal filed in 2019, no steps taken, nothing. But well, what has happened in subsequently, because essentially the suit was for a suit for damages against the banks, against the official liquidator, the banks. On the ground, and they said that they were theft when the official liquidator was in possession of this particular assets, for which loss have been suffered, for which, as a consequence thereof, the claim of the banks goes down, and as a consequence thereof, they want release of their personal guarantees. Now, my lord, of course, I'm here, my lord, for the first time before your lordships in this matter today. But my lord, I don't know whether Mr. Sen has informed your lordships about this, because this is a very important fact which has to be done. When insolvency is initiated in respect of this company, your lordship knows the procedure. Public announcement is made by the resolution professional. All creditors files their claim. And accordingly, what a committee of creditors is constituted. Committee of creditors comprises of only the financial creditors and the banks. Coincidentally, these 4 banks who are parties here had also filed their claim. Claim has been accepted by the resolution professional, not challenged by the suspended board of directors. First point. So practically they have given a waiver or a go-by to Malad, whatever they claim they made in the plaint which should dismiss. Nevertheless, but Malad, most importantly, Malad, what Mr. Sen, perhaps, I don't know Malad, whether he has pointed out, I cannot say that because I was not here.
I've pointed out nothing.
Oh, I'm sorry. I'm grateful to my senior Malad. But perhaps he's also not aware. He's also not instructed, probably because some other set of advocates are appearing there. Senior Mr. Banerjee, Mr. Mitro, everyone is appearing there. When Malad's an expression of interest was published for calling for resolution plan, your lordship knows, if the company is an MSME, the promoters of the company can give a resolution plan by fiction of section 240A. That's the exception cut out. Otherwise, they will not give a resolution plan. The same promoters, the appellant 2 and 3, approached the National Company Law Tribunal with a desire to give a resolution plan in respect of the debt of the financial creditors whose claim has been accepted. So accepting again the claim, gave a resolution plan, once again canvassed the same cause of release of the personal guarantees there. Plan was rejected. Second round, some properties were discovered. Now they have given another resolution plan. And on the same cause of action, they have filed an application before the National Company Law Tribunal. And if I may say, quite rightly so, that will succeed or not, but that the NCLT will decide so, that my plan has to be considered and my guarantees are required to be released. And your lordship knows the proceedings under insolvency.
So within the contemplation of their plan, the plan which they have submitted,
yes,
this claim is also there.
Correct. The claim of the financial creditors are there.
So it should be decided there.
Correct. Now, Malad, your lordship knows 238, there is a of non-obstantly clause your lordships have held in the, Malad, I have pleasure to assist your lordships, Malad, in the KMC matter, upheld by till the division bench. That, Malad, this has an overriding effect. Supreme Court time and again has said this. Now, Malad, your lordship recently also, lordship knows, Supreme Court has said that even, Malad, personal insolvency, these guarantees has to be dealt with if the company borrower is under insolvency before the National Company Law Tribunal. The personal insolvencies will also have to be dealt with before the National Company Law Tribunal under section 95. Your Lordship's view, my lord, I was citing that Australian High Court judgment in the other matter, Mr. Singh and myself. We showed to your Lordship the entire provision. I don't want to waste your Lordship's time. My lord, greatest of respect today, my lord, I have to take a neutral stand. My lord, the cause that my learned senior friend is canvassing, yes, against the, my lord, I have nothing to say. I cannot defend the bank. I cannot defend the official liquidator. But my lord, by this mean, if my lord, the CIRP process which is going on is interdicted, then my lord, that will cause my lord, issues. And my lord, what greatest of respect, my lord, because I have examined the plaint in detail, and I will say that with some sort of my lord, perhaps my lord, there is nothing remains in the plaint after the subsequent event in the suit, after the subsequent.
So we are on two aspects of the matter. First, you are given a notice primarily because to know your stand, whether you want to be on the same board with them, you cannot be, because that will be contrary to your submissions.
Contrary to my submission,
then you can be relegated to the
no. I'll tell you once again, my lord, once again, because the language what the Honorable Supreme Court uses in this kind of matters is that it's the committee of creditors who is the protagonist of my lord's, any insolvency resolution process. JP Kensington and the light of judgments. Now, COC has confirmed my lord, which comprises of the same banks who
resolution plan has been approved. The resolution plan
is final. Voting is going on. And in two stages, not only one. First stage, when the expression of interest was given.
That is on the merits of the appeal.
Yes.
We were only to ascertain whether you were on the.
So, my lord, I
want to join with
no,
them
so-
because company has been implicated as a party.
No, my lord, I'll tell you, lordships, it seems like, and that's again my next submission. Well, I ask myself this question: if your lordship sees the plaint just for once, I mean, not going into the merits of the plaint or anything, or the cause title of this appeal, lordship would see an appeal has been filed by the appellant number 1, which is the company.
Not only him,
and
others also.
Now, number 2, as directors of the company.
As guarantors.
So I'm coming to that, my lord. In the suit, in the plaint, they say directors as well as we have extended the guarantee. Now, the cause of action of a guarantee cannot independently coexist if I segregate this from the borrower, because they say that who has suffered the loss? Borrower has suffered the loss. Because the borrower, which is the company who has suffered the loss, the claim has gone down for which the guarantee should be extinguished. It cannot be segregated. I saw your lordship's judgment.
Two things are there.
Yes.
One is that you are right in a sense that yes, if they have submitted a resolution plan themselves,
that's right.
Then probably they cannot do this. But we are now to ascertain whether you will be on the same boat with them. Now, on the last date, we had passed an order where we have said that they are in two capacities. One is director of the company,
yes,
and as guarantor of the company.
Lordship, please.
The capacity for filing the appeal is somewhat, in a sense, unconnected with the outcome of the appeal.
So, my lord,
in the sense that we are on cause of action for filing the appeal.
Yes.
They have a dual cause of action for preferring the appeal. One is that as directors, they would definitely suffer, which is one leg.
Yes.
The other limb is as guarantors independently also they have a claim.
Lordship, please.
Which claim will go.
Lordship, please.
Now, it's a different question. We may dismiss their appeal even in the capacity of guarantors.
Yes. No, my lord, so as regards to my lord answering.
We'll just put you on the pro forma defendant,
Yes, your
pro forma respondent.
Yes, my lord, your lordship always.
Category.
I remember always tells to me that Mr. Banerjee, just have a look at the orders. So, my lord, I got an occasion to have a look at your lordship's order of 7th May. I think, my lord, subject to correction. I think, my lord, 7th May, your lordship framed an issue.
Yes.
But I just, if your lordship permits me with greatest of humility, my lord.
Yes,
just
absolutely. Yes.
One indulgence, considering the submission that I just made to your lordships. My lord, as I told to your lordships, I understand the principle of guarantee is joint, several, liable, coextensive, my lord. But it entirely depends on, as I said, it's intrinsically connected to, say, for example, the debt was 100 rupees of the financial creditor of the banks. It was 100 rupees. They say that 60 rupees have to be reduced from that thing, but because 60 rupees what the property has gone away. So I am liable to pay only 40 rupees. So my guarantee to that extent, 40 rupees will be made by the borrower. So my guarantee now stands extinguished because the entire debt stands discharged. So my lord, if I give this particular example to your lordships understands that the issue of guarantee is actually, it cannot be independently dealt with. That's
This is not a claim against the company. As opposed to that, this is a claim by the company.
No, so that's exactly my point. Number
Plaint
one
is by the company and its directors.
Mostly, but if I say something, Mr. Sen, my learned senior friend would say that it would go to the merits of the matter. But just if my senior friend just allows me for 30 seconds. what has perhaps not told to your lordship, but it's disclosed in the plaint also, but the trial court has not gone into that issue. The suit itself could not have been filed because winding up order was already there. So the
These
fiction
are
of,
all on merits of the
These are-
suit,
these are merits of
and
the
which
matter.
you are fully, everybody is
But
entitled, the bank is entitled to take it up.
Your lordships will decide whether I'll be a pro forma respondent on appellant number 1. But considering the facts here, since the COC is the protagonist of this entire thing, my lord, I perhaps, my lords, cannot continue this as an appellant number one. But at the same time, my lords, I would say this, my lord, that perhaps segregating the cause of action and the plain if I may use
No,
this for
you are
compartmentalization.
transposed as a pro forma respondent, that does not automatically mean that you are not affected by the outcome of the same, or that the
No, so I am.
the segregation of the cause of action for the appeal. Yes,
So, my lord, may I say
it's
this?
your choice to prefer or not to prefer or
So
continue
my,
with an
so
appeal.
my set, my lord, I'll tell your lordships, my lord, today, my lords, going by the subsequent fact that has taken place, and I have only been appointed, my lords, on.
So you can conduct an appeal, you can proceed with an appeal, or you may be a pro forma
Independently, I may not support
even if you are
the appellant.
you may not support
I
the
may not
appellant.
support the banks also.
Even if you are a pro forma respondent, that does not automatically mean that you are surrendering the interests of the company.
My interest is of the company
No,
itself.
because under Order 41 Rule 33,
Yes.
as well as Section 107, you know very well
I am so grateful.
that whatever happens, we may pass an order which may affect them
I am so
adversely.
grateful.
But the company is not affected.
I am so
in a
grateful.
sense. So even if you are a pro forma respondent,
I am
that
so grateful.
situation does not change.
Today, I am.
That means that you are not one of the persons who is challenging the impunity order.
Yes.
That is
Now,
the
my lord,
impunity decree rather.
yes. Now that's the point. Now, my lord, regarding the merits, my learned
We'll
senior
keep
friend-
you as a pro forma respondent then.
Doesn't matter.
My lord, I leave
We'll
it to
record your submission that according to you, since the appellants, the other appellants than appellant number 1,
Yes.
since they have already put in a resolution plan where they have incorporated this claim also, the claim made in the suit.
My lord, greatest of respect, appellant number 1, the company,
Yes.
cannot and should not have been the appellant at all before any court, or the plaintiff or appellant before any court.
On the date when the appeal was filed,
On the appeal was filed, date on
CIRP
the
had-
suit was filed.
No, that time there was no CIRP.
No, no.
No, CIRP had not
no.
come in.
CIRP
Winding up order was there. 556
No
of the
state.
very
There
well.
was
Let
state.
me show to your lord. No, it was not. I'll tell your lordships what.
Very
And
well, let
then
us
again,
not go
that's the
into it
catch.
now.
My lord, again, that's a catch. Please appreciate this. The winding up petition, which was pending before the Honorable Calcutta High Court,
Yes.
because that was transferred to the National Company Law Tribunal. Your lordship knows 2016, the rule came in by an order. Then line of cases, starting with my lord Shonji Banerjee's cases, Supreme Court judgment.
Unless substantially it has.
That's right. So it was transferred. They intervened. In fact, my learned friend's advocate on record was that they intervened in that matter. Lost. After that, CIRP was initiated. That was not challenged. That order was also not challenged. That attained finality. So now for my learned friend to say that winding up order was state perhaps is not correct. And in fact, I'll show from the plaint itself, they made the admission that they failed to make the payment after admission of the winding up petition. So, my lord, I am saying
Then also it would not be maintainable at the behest of the
appellant number
company.
1. Yes, that's
Appellant, that
right.
means.
That's right.
We'll put you in as a pro forma. We'll record that submission also.
So because, my lord, I should not mislead your lordships.
No, why
Just
should-
one thing, just kindly, my lord, sees this, the winding up order. Just one thing, and the fiction, my lord, give me the Companies Act quickly. 1956. My lord, your lordship has the Companies Act, old Companies Act.
56 Act একটা দিন তো Companies Act
Sorry for this purpose.
এখানে আছে, সরি আমার এখানে আছে এই বইটা ওনার কাছে ওদিকে থাকবে এইটা
Kindly see section 457 of the Companies Act. Wait. Yes, I'm sorry. Kindly see 456 of the Companies Act.
Yes.
And your lordships may disagree with me, but my lord, perhaps correct my understanding also.
Yes.
Kindly sees, my lord, 456 once. First, kindly sees custody of company's property. This is very important because of the issue. When winding up order has been made or a provisional liquidator has been appointed, the liquidator of the as the case may be shall take into custody under his control all the property effects and actionable case for which, so my lord, it becomes custodial legis of the court of my lord, the official liquidator and the court. Because kindly sees 1A, it says, my lord, the permission of the court is tribunal is required. But kindly now sees 457. This is very important. 457, the next liquidator. I'm sorry, your lordship has got it. 457. liquidator in a winding up by the tribunal shall have the power with the sanction of the tribunal, kindly sees A, to institute or defend any suit, prosecution or other legal proceedings, civil or criminal, in the name on behalf of the company. Now that's the problem. The winding up petition which is pending here has been transferred to NCLT now after the 2016 notification. Your Lordship wants I'm carrying everything, but I'm not traveling.
We will
It's a niche point of law.
yes, it's subtle, but we'll draw a distinction. We draw out an exception out of this 457 when the allegation is against the official liquidator himself.
Now,
it will be an absurd legal fiction if the official liquidator files against himself.
Greatest of respect. The recourse was, and again, Companies Act provided, to approach the company court, which was the High Court here, file an application in the company petition, take leave of the tribunal that I want to proceed against the official liquidator. But tribunal is the High Court now, and or file an application that because it's custodial against in the official liquidator.
Under which provision?
Yes. Now, my lord, your lordships would kindly see, this is very important.
Yes.
447. I'm sorry, my lord.
Under which provision?
Yes.
56 Act ছিল আগের বার।
Please see. No, I'm saying it.
These are all presumption that the company continues to be in winding up. I would just show your lordship one order.
We'll come to you. Yes. Yes.
Malad, I'm sorry. Kindly first comes to Malad 446 once, Malad.
446?
Yes.
Done.
446. Malad, I'm sorry. I should have got another copy for this.
So difficult.
Malad, can I hand up my iPad, Malad?
446?
I'm so sorry, Malad.
Yes. Please continue.
Malad, kindly see suit stayed on winding up order. Lordship has got that?
Yes, got it.
Kindly says when a winding up order has been made or the official liquidator has been appointed as provisional liquidator, no suit or other legal proceeding shall be commenced or if pending as on the winding shall be proceeded with against the company except with the leave of the tribunal. Tribunal is court. Subject to such terms as the tribunal proposes. Now kindly see tribunal notwithstanding anything contained in any other law, tribunal is the High Court then, for the time being enforced have jurisdiction to entertain or dispose any suit or proceeding by or against the company. Lordship has got that? By or up against the company. Any claim made by or against the company, including claims by or any other branches in India, any application under section 391, that was one of the previous mergers acquisition, any question of priorities or any other question whatsoever, whether or of law or in fact, which may relate to or arise in the course of the winding up of the company. This is very important. A fact, winding up, D, because if the theft is committed, it's during the provision. And kindly sees the contradiction. Greatest of respect, he has not, my learned senior friend has not made his submissions. He says he has filed it against the official liquidator. The winding up order was not set aside. Official liquidator was in possession. Official liquidator, then anything against the official liquidator at that point of time. And we all do that, your lordships have also done that. Whenever in a company is in winding up before the High Court. Unfortunately, now everything has shifted to the National Company Law Tribunal. That's why we go there. But there's still, Justice Krishna Rao is taking up the matters, old matters, in which sale has taken place, everything has taken place. Where any question of fact, we go under 446(2). It's quite wide enough. And there are other provisions as well. I can lead it to a lordship. And in fact, there are judgments of the Supreme Court, the judgments of our High Court on this particular provision itself. So today, the appellant number one, I understand, yes, a party cannot be non-suited. That's the principle what perhaps your lordship was troubling your lordships. That what happens, it's a case made out against the official liquidator. You go, the directors could have gone, the suspended board of directors, the directors or the promoters of this company could have gone, approached the company court to say, look here, your court officer, whom you have appointed as an official liquidator, has done XYZ mischief. There is a theft under his custody, for which, the remedy lies there.
Winding up order was passed when?
Yes. Now, I'm so grateful, Please see page 51 of the appeal paper book, 3/12/2012. 3/12/2012.
Winding up order was passed.
Yes. Now, perhaps Mr. Sen will show Malats, the order of 19th November 2014, and I'm assuming that my learned senior friend will show that.
Yes.
19/11/2014, passed by the Division Bench of the Calcutta High Court, page 104. Please see this. And Your Lordship would note the date of filing of the plaint, Malats. It's a suit filed in 2016. 2016. So the application, yes, application. 19th November 2014.
Yes.
Malad, kindly sees the order of winding up was, their prior orders which I showed to your lordships. The order of winding up was stayed on condition the company would continue to pay off the dues of the creditors in installments. Kindly note this. There had been default that was condoned subsequently. In the process, a sum of rupees so and so became due and payable to the pressing creditors on account of principal amount and amount of so and so on account of interest thereon. It was at that juncture the company filed an application for permanent stay of winding up on the ground that a BIFR reference has been made. The learned judge declined, hence this appeal. Kindly notes. In course of hearing, so and so learned advocate being led by Mr. So and so learned counsel, the applicant would rely upon a decision of the apex court in so and so, and would submit that in view of the decision of the apex court, the order of winding up cannot be put into implementation. However, in deference to the desire of this court, on instruction, so and so would offer so and so per month as installment, so long as the amount due to the so and so is not cleared off. Mr. Garg, appearing on pressing creditors, would however ask for a higher amount. Since the company is in a precarious condition, we permit the company to adhere to the proposal that they make before the court. Hence, dues as would be cleared of paying 50,000 per month as offered by the appellant so and so to pay the
At this juncture, we'll just
now.
No. At this juncture, we'll just record that your contention, the rudiments of your contention, and see that the tenor of the submissions of the resolution professional on behalf of the company would be substantially different from those of the
both the parties.
Other appellants.
I'll say both the parties.
So we are concerned with the appellants only
yes,
as far as.
Yes.
So therefore, we'll put you as the pro forma respondent and independently permit you to address the court when you take up the applications. We'll keep the other application for hearing on some other.
Your lordship is practically then deleting plaintiff number 1 from the suit and
no.
Also from the suit.
You are putting. You are being put as a pro forma respondent in the suit. One of the plaintiffs may very well choose not to pay for an appeal.
Yes.
If a suit is dismissed,
subject to
if some of the plaintiffs are not even available,
yes,
then also they are put as pro forma
yes.
respondent.
That's there. But this issue, yes,
this issue has to be decided, but we'll keep the applications on some other day because the other applications are all held up for this.
I'll just make one.
We'll just put you as a pro forma respondent.
Yes,
that was
this
the reason.
Not that stop the process, which is at a very
No, we'll
advanced.
put the application along with the appeal was to be heard along with the application. That was the application.
It was not yet admitted. There is a section.
It's not
5
admitted
application.
Oh.
Which has not been sought.
The delay and
Yes.
What is the delay?
95 days.
Reason?
It has not been sought, my lord, till now.
Copy has not been sent. Some copies come back tomorrow. Come back next week. We'll take up the section 5 along with the other stay applications and all, and you'll hear.
I'll try to assist your lordships, and with an understanding between Mr. Sen, what I'll
And
do is-
whom? And you are.
I am no. I am also very much new.
You first have to understand what is the understanding.
I know he will not deny that. The fact that he has given a resolution plan and has filed an application with the national, can I bring them by way of a compilation?
Supplementary affidavit.
It's a subsequent event.
May I say this?
He will not deny. I'm saying is
You start preparing your opposition to the stay application. We cannot direct you to file affidavit without allowing the stay section 5. So we can keep the section 5 application tomorrow. Give a copy to Mr. Roy and to all of your friends. So come back with the section 5 tomorrow. We'll allow the section 5 tomorrow if you feel so. And then direct affidavits to be exchanged in respect of this stay application. And we may direct the appeal along with the application to be heard out together because the conspectus is similar.
It's similar, it can be disposed of, It can be disposed.
So very well, let us just, for the time being, we'll just put you as a pro forma respondent.
And your lordship will kindly make it clear that your lordship is not interdicting the process because sometimes
we are not interdicting anything.
Submissions have been made.
Appeal is non-est till the section 5 is allowed.
So
that is the law. No question of clarification.
Sometimes it's very difficult to make it understand to the company law tribunal that
company law tribunal is very intelligent. Why should we assume that?
Mr. Banerjee knows it better.
that can cut either way. He knows better. He knows whether the company law tribunal is aware of this. Heard learned counsel for the resolution professional. Full stop. Several arguments have been made on behalf of the resolution professional which indicate that the suit itself might not have been maintainable on the date as on which it was filed, comma, in view of the pendency of a winding up proceeding in respect of the appellant number 1 company, which was subsequently transferred to the tribunal. Full stop. It is submitted that in view of the composite effect of sections 456, 457 and 446 within bracket 2 of the Companies Act 1956, which would be the governing statute in the present context, the civil court did not have jurisdiction to take up the suit. Full stop. Next para. In view of the tenor of the contentions of the resolution professional, indicating that the same would be qualitatively different from those to be advanced by the other appellants, who are the directors as well as guarantors in respect of the appellant number 1 company, it would only be appropriate if the appellant number 1 company, represented by the resolution professional, is transposed as a pro forma respondent in the appeal, full stop. Next para. Accordingly, the appellant number 1 stroke company, represented by its resolution professional, is directed to be transposed to the category of pro forma respondent in the appeal. Full stop. The learned advocate on record for the appellant appellants shall carry out the necessary corrections, amendments to the cause title of the memorandum of appeal, as well as the connected applications in that regard during the course of the day. First up, you will just delete the name of the appellant number 1, renumber these other appellants as 2 and 3 will be 1 and 2, and add them at the bottom, whatever the number is, pro forma respondent number such and such, during the course of the day. Full stop. Next para. Copies of the applications for copies of all the applications filed in connection with the appeal, as well as a memorandum of the appeal, shall be served on all the contesting respondents as well as the pro forma respondent by tomorrow. Full stop. The applications shall be listed for hearing on when should you keep it? Day after tomorrow?
Day after tomorrow.
On June 18, 2025. So you are correcting the cost title of everything, giving copies of all the applications and the memo of appeal to the resolution professional as well as obviously them.
But would your lordships allow me to join virtually on this day after?
Yes, yes, definitely.
Always.
Your lordships, permission, can it be done during recess with your?
Yes, yes, absolutely. You'll do it here. Because otherwise it has to go out of the list. You'll have to do it here.
That's one line of that clarification.
What clarification?
Well, that your lordship is not staying the CIRP process. Although no praise be made.
That will indicate that you had an intention to stay. That may be constituted otherwise.
Well, Mr. Sen is not appearing there. So, if Mr. Sen was there, I could have said Mr. Sen was someone else.
Question of that.
Nevertheless,
rather, on the contrary, we have said that the tenor of your submissions are contrary to theirs or qualitatively different from theirs.
So, subsequent events, your lordship.
We have not said contrary because some of the interests may be common.
Yes.
The interests of the company might be common.
Yes.
Vis-a-vis the suit. So, we have not said your interest is contrary to them.
Yes,
we deliberately use the expression qualitatively different from them.
That's why I said, I cannot take, it's something which is the cause of the company as well as the cause of the
Precisely. So you have to, both of you are speaking for the company, but in different capacities.
Yes.
So therefore, qualitatively different is the best expression.
With the facts, I'm here to assist your lordships with the law, if I say so. Let them both fight as regards to the guarantee aspect.
All of you are here to assist the court with the law.
Absolutely.
Order 7/11, which has been decided, but in the appeal, it has to be decided only on the issue which has been raised by the defendant in the suit. Whether the suit was bad or not maintainable on those grounds. Today, my lord, I do not think, my lord, the validity of that impugned order can be adjudged on any other ground of maintainability.
We'll consider that also.
Because please continue.
Because
of the original proceedings.
No, the trial court.
The only question
Consider that also.
I'll come with that.
It was not heard on merit. Very arguable question. Yes.
I was ready with that because
heard on merit.
no,
Yes, yes, that is
suit
the
is not heard on merit. That's
Then the suit be
the question is it's in continuous. An appeal is continuation,
Because this
but
you have
they,
Both of you have understood. You have also
Yes.
understood. Yes.
I'm grateful.
Yes. কি হয়েছিল এখানে?
এটা আমার।
ও,
এটা
আচ্ছা। Court. 18 who is appealing? Yes.
Was taken up by your lordship, Lord. They said, Lord, they didn't get the Lord.
You have the respondent. Right.
Lord, 1 day delay, Lord, I pointed out, so far the delay goes, Lord, that defect.
This is a Section 5 application.
Yes, Lord, so far, Lord, can 3.
Can 3. Let us take that up first. Delays of 30 days.
One day.
1 day. Oh, is that
1
clear?
day. Yes.
In view of sufficient explanation for the minuscule delay of 1 day being explained, being furnished in the application, can 3 of 2025 is allowed, comma, thereby condoning the delay in preferring FAT number 73 of 2023. Push of the appeal is deemed to stand registered and admitted accordingly. Now we are taking up can 2 or can 1.
Applications are there. One is for stay, Lord, 2, Lord, mainly I'll be pressing.
One is for stay. This is against a divorce decree.
No, Lord, actually there is nothing to be stated. It's a partition suit between 2 sisters. My suit for partition, Lord, I am the eldest. Dismissed on the ground.
Stay, there is no.
Yeah, Lord,
What is it
that's why
appropriate?
2, Lord, I really is really pressing, Lord. It's a Lord joint property, Lord, above which, Lord, I am not staying there. Lord, the respondent is staying
The
there.
2 let us dispose of saying that it is no scope of passing any order.
1.
Sorry, 1. Can 1 of 2023 is an application for stay of operation of the impugned decree. Pushed up by the impugned decree, comma, the partition suit instituted by the plaintiff stroke appellant was dismissed. Pushed up as such, comma, there is no scope of grant of stay. Pushed up accordingly, can 1 of 2023 is disposed of as not maintainable, nor as to cost. Now can 2, yes.
Now, Lord, 2, Lord, I have prayed formula and injunction against the respondent. Lord, because she is fixing.
Why appropriate order? What is this practice of appropriate order application?
It's really, Lord.
You ask your learned junior. Yes.
It should have been, Lord, an
You have
order.
taught for injunction in the body also and in the prayer portion also. So injunction doing what? From doing what?
Lord, from erecting a structure on the dilapidated building. Lord, I have no access to that structure. Lord, I have no access to the building. Lord, for a long time, Lord, I am ousted. I, Lord, periodically visit the place. Lord, I was told by the local people and, Lord, a person, Lord, who is staying at the downstairs, Lord, that a certain structure is being, which is told to be, Lord, a solar panel. Now, Lord, that
what difficulty can you have with a solar panel?
Lord, only thing is, Lord,
solar panel is not a change of nature character of the property.
Dilapidated
I'm grateful,
condition
madam.
of the building.
They are residing there. You are not residing. If they take the risk of the building falling on their head, I mean, how can your allegation be accepted? I mean, even be tenable?
Lord,
They are residing there. They are installing
really,
a solar panel.
I really do not know, Lord, what they are doing. Lord, I got a photograph, Lord, which seems to be very sketchy. Lord,
Solar
give
panel, we are not.
Lord,
your allegation in the application is they're installing a solar panel. Let
Lord,
them install
that's
it.
what, Lord, the local people have
You
told me.
get it with the solar panel if you win the appeal.
Lord, Lordship, kindly just have a look at the Lord structure that is being built. Lord,
Yes,
that
yes.
seems to be, Lord.
Let us see.
Only the photograph I can refer to.
Yes, which page?
Lord, এটা কোনটা রিপোর্টটা? And 2 photograph. The last pages.
Yes.
Last few pages. 55, 56.
Seems to be a solar panel, exactly.
Seems to be.
With only aluminium paneling and all. I mean, this is very light. We don't have any idea as a court, I mean, of the weight of a solar panel.
My Lord, I also
appears to be thin plates.
Yes. My Lord, I thought, my Lord, that should be brought to the notice of the court.
Definitely,
that is being done, my Lord.
Whatever structures they make, they will restrain them from changing the nature and character. But at the same time, subject to hearing, your learned friend. But at the same time, we'll say that they will not be debarred from installing the solar panel. They have already installed, in fact.
If it is, my Lord, not, my Lord, harmful to the stability of the building.
That will be very subjective. We won't be able to implement that order. You will say it's harmful, they'll say it's not harmful. Solar panel will exclude from this nature character.
Two sisters fight, my lord, one side will say it harmful. I am duty bound to say it harmful.
Yes, right. What do you say to this? I mean, nature character we can't permit you to change, but at the same time we'll say. Yes, sorry.
Extremely sorry, my lord.
Please, yes.
My lord. My lord, we are not changing any nature and character. We are residing, my client is residing in that particular property. My learned friend's client is not residing in that particular property. He's residing at Howrah. So, and my lord, I have the report of the solar panels, my lord. If my lord kindly see, there is no chance of changing.
You have to give a copy to them also. If you want, we can direct you to put in a short affidavit in opposition.
Yes, my lord. I want that, my lord.
Do that, but in the meantime, we'll.
I just want two days time to file the written.
No, you will not change the nature and character of the property.
I will not change
and
it.
we'll say that the solar panel which has already been constructed will be subject to the outcome of this application.
My lord.
It had fair. Learned counsel for the at a can to a report.
My lord, one thing more, my lord.
Yes.
There is no allegations against my client that they are changing the nature and character of that property, my lord. In the petitions of the injunction applications, as I understood, that only one allegations my learned friend's clients put here.
Yes.
That is that we are installing the solar panel on the roof of that particular property. And by installing that solar panel on the roof of that particular property, the entire property will be damaged. The passerby will be killed, and these types of allegations are there. So there is no contents, my lord, will find in that particular petition.
This appeal is against rejection of a plaint.
Rejection of the non-release of the plaint.
Suit was dismissed.
The suit was dismissed, my lord.
All right. There is no such allegation.
No, my lord. Kindly say.
Basically,
it is
my lord,
needed that kindly allow me to file the affidavit in opposition against these applications, my lord. And then, my lord.
May I make one humble prayer?
Yes.
There is no
the
such
initial order my lord was proposing, my lord, if that be there, I think, my lord, none of the parties are going to be prejudiced. Now, my lord, at the same time, lordship kindly expedite the appeal.
We can dispose of the application by we say that you deny this, and we'll also observe that as per our view also the solar panel installation of the solar panel does not tantamount to change of nature and character. If you say that, you are safe from the trouble of, and we'll say that you are denying the allegations made in this. But in a partition suit, generally also you should not change the nature and character.
I am not changing nature and character.
There
is no diary against me. There is no report against
pass an order of status quo restraining both parties from changing the nature and character of the
both
suit.
parties to change it.
I am not there. I cannot do anything, my lord, for a long time.
Just to save time for you, so that they don't use an affidavit in opposition. Your learned friend will be happy if he restrain you also.
My main interest is to get the appeal hard.
Wait. Can 2 of 2025 has been filed for an injunction restraining the respondent from changing the nature and character of the suit property. Full stop. In the application, the primary allegation made against the respondent is that the respondent is attempting to change the nature and character of the suit property by erecting a solar panel on the dilapidated rooftop of the suit premises, which may affect the stability of the property itself. Full stop. Next para, certain photographs have also been annexed of the said structure. Full stop. Next para, learned counsel appearing for the respondent vehemently opposes such contentions and submits that the installation of the solar panel cannot, in any manner, be construed to be an alteration of the nature and character of the property. Full stop. That apart, it is pointed out that it is the respondent who is in occupation of the property as opposed to the petitioner who resides elsewhere, and as such, the respondent would not do anything to affect adversely the structural stability of the building. Full stop. Next para, learned counsel for the respondent further submits that the respondent is armed with reports to indicate that the installation of the solar panel shall not affect the structure of the property in any manner. Full stop. Upon hearing learned counsel, we find from a perusal of the photographs annexed that the structure used for installation of solar panel on the suit building cannot be termed as an alteration of the alteration of the nature and character of the suit property, but is only a temporary structure. Full stop, next para, as such, comma, there cannot be any apprehension of the structural stability of the building being affected by installation of the same. Full stop, that apart, comma, we cannot also overlook the fact that it is the respondent who is physically in occupation of the property, and as such, comma, it will only be contrary to the interests of the respondent herself in the event the structural stability of the building is disturbed. Full stop, next para. However, comma, uh, we are of the opinion that since the challenge has been preferred against the dismissal of a partition suit, comma, keeping in view the nature of the LIS, comma, it would only be appropriate if the parties maintain status quo regarding the nature and character of the suit property till disposal of the appeal. Full stop. Accordingly, comma, can 2 of 2025 is disposed of by directing both parties to maintain status quo with regard to the nature and character of the suit property till disposal of the appeal. Full stop. Since we have not invited affidavits to be exchanged, comma, it is deemed that none of the allegations made in can 2 of 2025 are admitted by the respondent. Full stop. The appellant shall, in view of the appearance of the respondent through her learned advocate, comma, the service of notice on the respondent is dispensed with. Full stop. The appeal be treated to be ready as regards service. Full stop. The appellant shall put in due requisites for. Now, the trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. প্রথমেই একটা করে দেবেন যে affidavit of service filed to be kept.
Grateful. So for my lord, condonation of delay, my lord has been pleased to allow.
Oh,
can 3.
এই সবকিছুর আগে এটা করে দিন।
Can 3.
Affidavit of service filed. No, yes, we had.
Yes, it is already.
That's
allowed.
the first portion of
Yes, the condonation of
that we started with that.
Yes.
1 day's delay.
Yes.
You remember that. One and 2 both have been disposed of.
This 1, 2, and 3.
1, 2, and 3, 1 and 2 rather.
3, 1, and 2. Correct. I take my lord's leave. Grateful.
You are for the respondent.
Yes, ma'am.
Is the appellant moving on legal aid?
No, my lord, in the first half, he was present, my lord, the appellant.
They were present in the first.
Present in first half. And also informed me that he has no brief today.
But he should come and say
at,
that
at
to us.
hand.
We have to dismiss because we gave a last chance to them. Last chance দিয়েছেন আর কি করা যাবে? The matter has a history. Full stop. The matter has a history. Full stop. Initially, the same was dismissed for default, whereupon an application for restoration was moved. Full stop. Although the respondent was 1 to 7 opposed the said application for restoration, since it was the second instance of dismissal for default, comma, keeping in view the marginalized circumstances of the petitioner, comma, we allowed the restoration application. Full stop. However, comma, thereafter, the appellant remained unrepresented on June 11, 2025, when the matter was taken up for hearing. Full stop. Even today, comma, at the time of call, comma, none appears for the appellant to move the matter. Full stop. We recorded in our order dated June 11, 2025, that a last chance was given to the appellant to move the application, that is Can 3 of 2020. Full stop. Next para. However, even today, none appears for the appellant at the time of call. Full stop. Accordingly, Can 3 of 2020 is dismissed for default without any order as to cost. Full stop. The appellant shall put in. There are other respondents than you.
My lord, other respondent is there, my lord.
Pro forma. They are pro forma.
Not pro forma, my lord. Direct respondent is included as a direct.
They have been made pro forma here. Why? What is the matter arises out of what?
Yes, my lord. This is a partition suit.
Partition suit.
Yes, my lord.
Partition suit.
Partition
Then all have to be served. The appellant shall put in requisites for service of notice of the appeal on the respondent numbers 8 to 16 and pro forma respondent numbers 17 to 20 within a fortnight from date. Full stop. You are for 1 to 7.
1 to 7.
In view of the appearance of the respondent numbers 1 to 7 through their learned advocate through their learned advocate, comma, service of notice of the appeal on the said respondents is dispensed with. Full stop. The trial court record shall be brought by special messenger at the cost of the appellant, comma, also to be deposited within a fortnight from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Full stop. The learned advocate appearing for the respondent numbers 1 to 7 shall serve a server copy of this order on the learned advocate appearing for the appellant at the earliest. Please serve a server copy of this order on their advocate.
Yes, my lord. Interim order, my lord. There is an interim order, a status quo order. It may be vacated.
In respect of Can 3?
Can 3.
আচ্ছা যেখানে বললাম Can 3 of 2020 is dismissed for default without any order as to cost. Interim order, if any, stands vacated. Please serve a copy of this order on your learned friend for the appellant. And you keep the receipt with you.
Yes.
So that we may require it later on.
20 minute FA for the appellant.
Yes.
Lord, the plaintiff in a suit for specification of contract. Lord, ad interim order refused, against which, my lord, we have preferred the appeal.
We had admitted the appeal and granted injunction.
No, my lord. There are two applications. One is for injunction and one is for substitution.
Substitution as well.
Substitution, my lord. The respondent number 1 died.
Let us take up the substitution application first.
That would be Can 2 of 2024. Lord, now, my lord, the respondent number 1 also happens to be the defendant number 1 in the suit bill.
1 minute. Can 2 টা কোথায়? Can 2 টা? Supplementary affidavit is in
Yes, my lord.
respect of two.
Two, my lord.
Defendant number one,
That all have been served.
no, you are starting something. You're starting.
Service
Who has died?
My lord, defendant number one has died, my lord.
Defendant number one.
That is the respondent number one here, my lord.
Acha.
Well, the respondent number one dies, my lord. We have come to know about his death on 9th May 2024. My lord, we are not aware of the date of his death. We come to know on 9th of May 2024 that he has died. My lord, we take out this application, my lord, on 12th of August 2024. That is a delay of 3 days after, my lord, the expiry of 90 days.
90 days is from the date of death.
Yes, so my lord, we are not aware. So
The entire period will be counted.
But till today, my lord, we are not aware of the date of death.
Oh, as then.
Till today, my lord, we are not aware of the date of death.
So how did you come to know of the death?
My lord, we came to from the locality, my lord, the reliable source in locality. That 9th May he has died. So we take out an application. 9th May 2024, we come to know that he has died. We take out an application for substitution. But my lord, then we realize, even then, if on 9th May we come to know, even then, assuming that he died on 9th May as well, even then it was by 3 days.
Then?
Even then there was 3-day delay because we filed it on 12th of August.
Yes.
We filed this application 12th.
Yes, yes.
So, my lord, but there was no prayer for condemnation in the application. So we sought for a leave, my lord, to file a supplementary affidavit, which we have done. Now, my lord, in the supplementary affidavit, we have said that there's a delay of 3 days. And we have also said that insofar as we do not know the exact date of his death, abatement might have set in. Abatement might have set in. So, my lord, we have made a averment in the supplementary affidavit for setting aside abatement, if any, that prayer is there, my lord. In these facts and circumstances, my lord, these two applications have to be taken up for hearing, my lord. Because we are not aware.
Mr. Mukherjee, you are for which of the respondents?
But I am appearing only for the respondent number 2.
The partnership firm.
Only thing, but I am telling your lordship, but I don't know whether in the court below, but whether they have taken step, because my if your lordship see, I have taken from the computer, till today no summons has been received, and my suit was filed in 2023, but I am kindly pardon me, I have only one copy, my lord.
What is this?
The date, my lord, in the Justice Kumar, kindly pardon me, I have only one copy, my lord.
No, I am pardoning. This will be given to Justice Kumar. Yes.
I am tendering. Now, my lord, if your lordship see, till today no
You and the defendant number one appeared together in the suit.
summons not served. Kindly
Summons not served.
next 2023 suit filed. Now, my lord, kindly see the last date. Next date has been given 5th July 25 for SRAD. All the dates are SRAD. I don't know what is the suit for.
We were aggrieved by the refusal of ad interim order of injunction. My lord. The suit was filed in 2000.
How did you come to know about the heirs if you don't know about the death?
Locality, my lord. We don't know the date of his death. We are aware that he has died.
No, we cannot allow an application just like that without knowing the date of death.
Court below also no steps taken, I think.
And you have not taken any steps in the court below, the suit has abated.
My lord, what I say, my lord, is that we take out we file this appeal before this court challenging an ad interim order of injunction.
But the suit must have abated by now.
I am not aware, my lord.
If you have not taken any steps, you cannot take. I mean, the appeal has become infructuous, in fact.
No, my lord, appeal has not been infructuous, my lord.
If the suit is abated, then what remains?
The suit is abated, my lord, but what
If you have not taken any steps in the court below, then suit must have abated.
Steps have not been taken, my lord.
At least from the date of knowledge, I mean, 90 days have elapsed.
My lord, but we had taken out this application, my lord, before this honorable court.
Here.
In 2023, my lord.
Does not percolate down because this is a miscellaneous appeal.
Miscellaneous appeal, my lord.
And you have to take information about the date of death, Mr. Bordun. We cannot.
We are not getting it, my lord. We know that he has expired, but the date of death we are unaware.
Have you served copies of this application on the surviving respondents and their heirs and his heirs? Did you direct you?
No, my lord. Upon the heirs, probably not. Heirs service করেছিস? মনে হয় না। চারজনকে করেছিস।
What about the other defendants?
My lord, if all defendants have been served, দিয়েছিস তো। Well, there are 4 defendants, my lord. It is basically, my lord, the defendant number 1 was the owner of the property. Defendant number 2, 3, and 4, my lord, they are developers. Partnership firm means partners. My lord, we are the purchasers.
1 and 2 are on the same footing.
No, 1 is the owner.
2 also?
2, 3, and 4. 3 and 4 are the partners of the partnership firm. Who is the developer?
But since they're saying that they have handed over an information slip showing the dates that no substitution application has been filed, Then the suit has abated.
That to that one we take
Take instruction, come back tomorrow.
tomorrow. Pardon? It's on Monday, my lord.
Monday.
Moreover,
Can 2 of 2024 is taken up for hearing. Full stop. The same is an application for substitution on the death of the original respondent number 1, Prashant Kumar Dotto. Full stop. By way of a supplemented affidavit, comma, the appellant has also sought for setting aside abatement on condonation of delay, comma, on the presumption that the date of knowledge of such death of the appellant, the date of knowledge attributable to the appellant regarding the date of death is construed, that is May 9, 2024, comma, is construed to be the date of death. First up, the present application was filed on August 12, 2024, comma, that is after the expiry of 3 days from the limitation period of 90 days having been exhausted after the date of knowledge. For sub next para, even if it is submitted by the appellant that even if we proceed on the premise that the date of knowledge was the date of death, comma, the application could not be filed earlier because the appellant was not aware of the demise of the original respondent number 1. For sub next para, learned counsel appearing for the respondent numbers 2 to 4 contents, comma, by placing reliance on and handing over a case history obtained from the trial court, comma, that no application for substitution has been filed in the court below in respect of the suit from which the present appeal arises. Full stop. Next para. It is further submitted that summons of the suit have not yet been served as well on the defendants. Full stop. Next para. We find prima facie from the case history submitted by the respondent numbers 2 to 4, comma, which is kept on record, comma, that no application for substitution appears to have been filed in the trial court. Full stop. In the absence of the same, comma, in any event, comma, the suit has abated. The suit must have abated, comma, thereby rendering the present appeal itself infructuous. Full stop. At this juncture, comma, learned counsel for the appellant seeks some time to take instructions as to whether any steps have been taken in the trial court for filing any application for substitution. Full stop. Next para. In order to enable learned counsel for the appellant to do so, comma, let the matter stand adjourned till June 23, 2025, when it will be listed under the same heading.
I'm so grateful.
Affidavit of service you have filed today.
Yes.
Affidavit of service filed today be kept on record. Even if you take steps there for substitution now, unless that is allowed, the suit remains abated. The appeal.
I'm grateful.
Item number 19, my lord, I went to take some tiffin, my lord. That is, my lord, I could not. Some tiffin, my lord. I could
We had
not.
finished our tiffin.
No, my lord, can she has been dismissed, my lord. This is endeavor folded and I request, my lord.
No, repeatedly, it was dismissed for default twice. You are continuously negligent. Sorry, Mr. Mukherjee.
Can she, my lord?
No.
For injunction, my lord.
No, and we cannot even assure whether even if you file a further restoration application, we will. But we have directed you to put in the requisites and all these things. Do that.
My lord, kindly one thing, my lord. Can she is for injunction, my lord?
Yes, we have vacated the injunction and dismissed it for default.
Kindly, my lord. I was there, my lord.
No.
Since your lordship raised before recess, my lord.
Sorry, Mr. Mukherjee, not like this. No.
My lord, kindly do some.
No.
Kindly do some. Kindly.
No, you have to be. No, you have to be more diligent. It was dismissed for default twice.
My lord,
This is the third time. Sorry, no. Consistently negligent. No.
My lord,
If this was the first time, we would have considered. This is the third time.
Application for injunction, my lord.
Next matter, please. Yes, 21. Who is appearing?
Lord, I am for the respondent number 2.
Mr. Roy, my lord. Last occasion, your lordship
Start the matter. What is the matter about?
addition of party.
Use the microphone.
There was an application was filed, my lord, that is addition of party, my lord. Upon the date of the respondent number 3 to 13, my lord.
This arises from a partition suit.
Lordship.
Partition should dismiss.
Partition suit dismissed.
Partition should dismiss. Lord, they have taken up 2 applications. One for Lord the substitution, not the addition of party, and another is Lord the application for injunction.
So substitution, what do you say on the substitution?
Substitution is allowed
Not
already.
an
my lord.
application for substitution, it's about addition of party.
Addition of
Already
party.
substitution has been
Allowed.
done, before the learned code below, before the decree has been.
So we'll just add them.
Date of.
That should be allowed.
Number 3.
3 to 13.
13, no, 3.
3 and
3 to
13, not 3 to 13.
3 and 13.
3 and 13 have died. Their heirs are already there on record, had been substituted in the trial court. You should be prepared, Ms. Chakraborty. You are in this matter throughout.
Perhaps it is only 3.
You assist us, yes.
Only if your lordship recollect that the one person has dead, the name has been recorded in the decree date person, although his
Heirs have been substituted. 3 and 13, their heirs are already substituted in the trial court.
The 13, I don't have any knowledge, my lord.
No.
I don't know he is dead or alive, but they have not contested also before that learned code below.
Respondent number 1 মারা গেছে, accordingly তোমরা
হ্যাঁ,
একটা application file করেছে।
If they have not contested, we can dispense with service also. Dispense with implement also.
Dispose of হয়ে গেছে।
Lord, only the defendant number 1 and 2 are contesting the suit. That is my learned friend.
It was dismissed on contest.
Dismissed on contest.
You are for 1
I am for 2, Lord.
and he is for 1.
Friend is for 1.
You only contested in the court below.
Yes. 1 and 2. He is for 1, I am for
Understood, yes. So let us allow the addition of party, because in any event, if they are, have you stated here? Let us see whether they have been added, what they have stated in their
During
application.
the pendency of the suit, my lord, date has not mentioned when they are.
এটাই তো দিয়েছিস তো addition কোথায় চেয়েছিস? Substitution চেয়েছিস।
You have said in paragraph 3 that you have amended the plaint.
So can 3 টা তো?
Can 3 তো দিয়েছিস। Can 2 দিয়েছিস।
Can 3 of 2025 has been filed for addition of the heirs of the defendant respondent numbers 3 and 13 as parties to the present appeal. Push up, it is contended by the appellants that the heirs of the said deceased defendants had already been implicated in this suit, and an amended plaint had been filed to that effect, which was not taken into consideration while preferring the present appeal. It is further stated that the impugned decree also did not reflect the substitution of the heirs of defendant numbers 3 and 13, although substitution had already been effected in reality. Next para. Accordingly, the question of further substitution does not arise, since the heirs of the deceased defendant numbers 3 and 13 had already been implemented in the code below. We accordingly allow Can 3 of 2025 without an orders to cost, thereby directing the heirs and legal representatives of the defendant respondent numbers 3 and 13, as mentioned in the cause title of the present application, as parties to the present appeal. The office shall carry out the necessary consequential corrections to the cause title of the memorandum of appeal within a fortnight from date. Next para. The trial court records shall be sent down the decree of the trial court shall accordingly be sent down for effecting necessary corrections by implementing the names of the omitted heirs of defendant numbers 3 and 13 who had already been substituted during the pendency of the suit. What about Can 1 of 2023?
It's injunction application, my lord.
No order has been passed. What injunction have you sought?
Rashid, there was one grocery shop, my lord, one
Transfer alienation in favor of third parties. Peaceful possession, have the trial court found in favor of your position?
Lord, the trial court has found they have not the title, even the necessary party was not made the part.
No, that is a different, non-joined is a different aspect. But what
title was also not, Lord, defective, Lord.
No, but what about possession? They may not have title.
Kindly see, Lord, the
Grocery business.
Lord, kindly see the recording, Lord, the
That
page.
they are not paid any nothing in regards to grocery business.
Amol Kumar Pal and others. That is the appellants. If you come to page 19 of the trial court.
Lord, page 11 is the, Lord, the relevant issue.
No, but going through the document again, page 19 court finds exhibit 6 series shows the name of grocery shop as Mr. Amol Kumar Pal and others. 13 shows Amal Kumar Pal and brothers.
But they had not paid anything in regard to the grocery shop. Kindly see their plate, my lord.
But documents are not uniform, proving the status of the said grocery shop.
My lord, they had only paid partition in respect to 8 anna share of 0.1 decimal. And the plaint has been amended 17 times.
17?
17 times. Well, perhaps that's why the decree has been also been wrong.
Maybe.
Only schedule amended and respondent added. Still, at the time of passing of the decree, the total property has not been included. Even the all the co-sharers are not included. After repeated amendment.
No, but court has not found that they're not running the grocery. Please come to page 9. At the page 12 we are placing.
Page 11 or not?
Page 11. Let us come to page 11. এই পাখাটা নিভিয়ে দিতে বলুন। Yes, page 11, which portion, Mr. Ghosh? Page 11 is the narrative, the narration of the case. See, please come to page 18. Defendant number, last paragraph, page 18, last paragraph. Defendant number 1 has admitted a part of plaintiff's story regarding joint business, but in another manner. Defendant number 1 is running grocery business. You are running under the name and style of Mr. Shamul Kumar Pal. Acha, you say that you are running. 1 is running. You are 1.
He is 1.
You have stated, we are at page 18 of the chart. You have stated that you are running the business. Acha.
My lord.
Earlier joint in nature, plaintiff number 1 surrendered. But you have, then it goes on to say, you have admitted that the business was earlier joint in nature, but plaintiff 1 surrendered. Plaintiff number 1 himself started his own grocery business under name and style of Amal Kumar Pal. But this defendant himself could not produce any document to show that business was legally transferred in favor of whatever. Confusing.
Page 12.
They have not paid anything regarding the grocery shop.
No, page 19 you have admitted, defendant number 1 has admitted in the second paragraph. Deposing as DW1 admitted that trade license in the name of
partition of the grocery business. Well, I am showing you.
That is not a part of the suit property. That is running the suit property. Grocery business, they need not pay for the partition. It is not an immovable property.
Lord,
Business is an intangible property.
Lord, kindly see the page 12, second paragraph. The findings of the learned judge.
Yes, what is there? Please read out.
Plaintiff have mentioned that the RS Hotiar number 1326 pertinent to RS plot number 351 in the schedule of the plaint describing the suit property, which has, this is the one of the part of suit property, which have been put forward for partition before the court. The said RS Hotiar, in absence of the latter document in the name of the subsequent owner, Sri Pulindranath Chatterjee, heirs, and the relevant probate document could have been shown that right title interest to execute the sale deed number such and such to pass in favor of the defendant number 2. But the plaintiff have not produced any of those documents. In absence of Khotian number so and so, name of the original recorded tenant and their respective heirs cannot be ascertained.
That is a different aspect regarding title. That is regarding the title.
Next paragraph also, my lord, kindly see.
What next paragraph? All this culminates in page 19. Come to page 19. Please come to page 19 and read from the second paragraph onwards.
Defendant number 1, deposing as DW1, admitted that the trade license in the name of the grocery shop business was in the name of the plaintiff number 1 and himself jointly. Further, that the cash credit loan was in the joint name of the plaintiff number 1 and himself regarding the grocery business, but those documents have not been produced before produced either of the parties. The defendant number 2 stated that Messrs. Amal Kumar Pal and brothers was joint business of the entire family, that is that is that is amongst the 7 brothers and the 3 sisters, each having the equal share. Plaintiff number 1 and the defendant number 1 used to manage the business. In the year 2006, in pursuance of the family settlement, said shop was given to Shamal Kumar Pal, that is the defendant number 1, and the plaintiff himself got the another separate shop in the second floor of the house situated in the suit plot. Defendant number 1 obtained the portion to run his shop. Similarly, Amal Kumar Pal obtained an area in the ground floor to run his shop. According to this witness, suit property was already partitioned. No document could be filed to substitute the same. During cross-examination, these witnesses, the said property inherited from their grandfathers has not been partitioned. DW2 also could not show any document to prove that grocery was the joint family business or the plaintiff number 1 and the defendant number 1 used to run the same jointly.
Court has categorically held that DW1 has admitted the trade license in the name of plaintiff number 1 and himself jointly. Further, that there was a partition, that is your case, defendant number 1's case and 2's case. Amol Kumar Pal, as per you, defendant number 2, obtained an area on the ground floor to run his shop. It has also been admitted by DW2. DW2 could not show any document to prove that grocery shop was joint family business between plaintiff 1 and defendant number 1. Court has held Exhibit 6 series shows the name of the grocery shop as Messrs. Amol Kumar Pal. Appellant number 1 is Amol Kumar. But the documents filed by plaintiffs are not uniform, proving the status of the grocery shop. However, plaintiff 1, defendant number 1 and defendant number 2 have put forward such confusing and indefinite evidence. Therefore, admission made by defendant number 1 and 2 regarding jointness of grocery business does not serve any purpose. And plaintiffs have failed to show that Amol Kumar Pal is now being run in the name of Shamal Kumar. Why should the plaintiff, he is Amol Kumar Pal? Why should he show that Amol Kumar Pal, Messrs. Amol Kumar Pal is now run by Messrs. Shamal Kumar Pal? Why should he show that? The trial court's judgment itself is confusing. What is found from here is that you have admitted that initially the trade license was in the joint name of plaintiff number 1 and defendant number 1. Secondly, as per defendant number 2's case also, there was a partition, you say, but Amol Kumar obtained an area on the ground floor to run his shop. So therefore, his possession is admitted. Why shouldn't he grant possession, status quo, injunction regarding possession? And also regarding third-party interest. If you create third-party interest during pendency of the suit, the appeal will become infructuous.
Injunction upon 34 decimal, but from his plaint and from the order, he is admitting that he is possession of 8 anna share of 1 decimal.
Whatever his possession, that
34 decimal, my lord, our property,
his possession,
but
whatever.
they are also others plot owners, who are not also the family members.
Whoever is in possession, he will remain in possession. You cannot disturb his possession. The portion which he is in possession, you cannot disturb.
My lord, as per my instruction, my lord, one difficulty is that I have no objection regarding the grocery business also, because it's a running business.
Yes.
It cannot be stalled. My lord, one question that some of the buildings, some portion are been in dilapidated condition.
If you want to effect a repair, you have to file a formal application, exactly say what are the repairs, and we'll keep that open for.
That liberty will be granted.
We'll keep that open. Can 1 of 2023 is an application for injunction. Full stop. The appeal arises out of a suit, out of the dismissal of a suit for partition. Full stop. We find from the impugned judgment and decree of the trial court that at different places, the learned trial judge observed that the defendant number 1 stroke respondent number 1, as DW1, admitted that trade license in the name of grocer stroke shop business was in the name of plaintiff number 1 and defendant number 1 jointly. Full stop. It has also been admitted by defendant number 2 that Messrs. Amol Kumar Pal and brothers was the joint business of the entire family. Full stop. It is the case of the defendant number 2 that Amol Kumar Pal, the appellant number 1, upon partition being effected, obtained an area on the ground floor of the suit property to run his shop. Full stop. DW2 could not show any document to prove that grocery shop was joint family business or that plaintiff number 1 and defendant number 1 used to run the same jointly. However, however, the trial court also found that Exhibit 6 series shows the name of the grocery shop as Mr. Amol Kumar Pal and others, and Exhibit 13 shows the name as Amol Kumar Pal and brothers. Also, it is observed in the trial court judgment that the defendant number 1 and 2 have admitted regarding jointness of the grocery business in respect of the suit property. Since the appellant number 1, since the name of the appellant number 1 appears in the trade license admittedly, and it is an admitted position that the appellant number 1 has been running a grocery shop in a portion of the suit premises, we are of the opinion that the parties should not disturb the possession of each other during pendency of the appeal. Next para, also, it is a settled proposition of law that the property ought to be maintained in statu quo during pendency of a LIS, particularly in the nature of a partition suit. Since the appeal is a continuation of the suit, we are of the opinion that in view of the circumstances of the case, a prima facie case for hearing the appeal on merits have been made out. Also, the balance of convenience and inconvenience is in favor of grant of injunction in the form of status quo. Accordingly, the parties are restrained by an order of status quo. Accordingly, can 1 of 2023 is allowed by directing the parties to maintain status quo as regards possession in respect of the suit property, as well as the parties shall remain restrained from selling, transferring, alienating, and or creating any third-party interest in respect of the suit property or any portion thereof during pendency of the appeal. Next para. You have not filed any opposition.
No,
Since we have not invited any affidavit in opposition, it is deemed that none of the allegations made in the injunction application are admitted. The appellant shall put in due requisites for service of notice on the respondent numbers, on the other respondents than the appearing respondent numbers 1 and 2 within a week from date. The trial court record shall be brought by special messenger at the cost of the appellants, also to be deposited within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for hearing as and when the same is made ready for hearing. What any other application is still pending?
But he may be given to file.
Oh, yes. To file?
Any application for.
Yes. Since learned counsel for the respondent of 2 submits, respondent number 1.
1AB, 1AB, 3, 4, 5.
Small a, 1 small b, 4, 5, and 6 submits that certain repairs may be required in respect of the suit premises, which is otherwise in a dilapidated condition, we grant liberty to the parties to file appropriate application for repair, if so required, without being prejudiced by any of the observations made above. If such an application is filed in connection with the appeal, the same will be dealt with independently of the observations rendered above.
My lord, one injury, my lord, the suit was dismissed, subject to your lordship correction, the suit was dismissed for defects of party, my lord, because all the plot owners who was in that same dark number are not made party. My lord, injunction order passed without hearing them, my lord. They will also suffer that portion.
No, we have injunction order operates only in respect of the parties to a proceeding. This is not a judgment in rem. And if it was only for
has been covered in the suit property, they are first
they are not bound. They can transfer their shares. If there are other shareholders who are not parties here, they can transfer their shares. They can disturb your position, his position. They can do everything whatever they like. But if it is bad for non-joinder, that is the primary reason. Then if they file an application for implement
Not
of this
Millard, that is not the primary reason.
There are other reasons
They
also.
failed to prove their
we found that we found those observations, discrepancy in title and all.
Judgment is something.
Yes, thank you. Mr. Rai is in court. In this court. Prathapratim Rai you give his name also. Yes.
22, I am for the respondent number 1.
Respondent number
The appellant, my lord.
That application.
They have
Move
filed
the
an
application, Mr. Banerjee will oppose.
Yes, my lord.
What is the application for?
Application for recalling of the order dated.
Oh, then he has to move, yes.
Recalling of the order dated 11th
Now,
August 2020.
Proposition I am supporting that under section 100 subsection 4 substantial question has to be framed while admitting the appeal.
Oh, that, oof.
Now,
Yes.
here, my lord, appeal was admitted. Questions were not framed. Direction was that you are asking for an interim order, serve a copy and come back. But first line says the appeal is admitted. We served, came back. When we mentioned, my lord, the court officer said that since appeal has been admitted, go before the single bench. We mentioned before the single bench and submitted that question has not been framed. Kindly, court can frame subsequently also, kindly frame the question. His lordship said, no, you have to go propriety demands, you have to go before his, their lordships.
No,
And in the
because
meantime-
yes, because of Order 42 Rule 2.
Yes, my lord.
Because it's mandate. Some question has to be formulated.
Yes.
That may be a trashy question also. I mean, but we have to formulate some question, like we
Only
do
one thing, my lord.
generally.
I
Yes.
agree with to the proposition, my lord, raised by my learned friend, but order is passed. Now, by recalling, he is basically asking for review of that order. Now,
Which of the judges? Who are the judges who passed that?
Honorable Justice Mukherjee, my lord, possibly.
Which Mukherjee? Shubhagopal Mukherjee?
IP Mukherjee.
Justice IP Mukherjee is no longer there in this court. Who else?
And Honorable Justice Shubhendu Samant. And Honorable Justice Shubhendu Samant.
Samant is still there, but Order 40 Rule 2 is very specific, Mr. Banerjee. At the time of making an order under Rule 11 of Order 41 for the hearing of a second appeal, the court shall formulate the substantial question of law as required by Section 100, and in doing so, rather it the other way around. Court may direct that the second appeal shall be heard on the question so formulated, and no other question may be taken.
Yes.
Court can do that, but not the reverse.
So if
For
it
the
is not,
first time question, yes.
If it is not formulated, then no question.
Further, and Section 100, your right, that right comes under Section 100,
Yes.
which have to be read together. Section 100 only opens up that opportunity. Let us read Section 100 if there is any scope through that. Probably there is not. Probably there is not.
Subsection 4 says while admitting it has to be done, my lord. Where the High Court is satisfied that a substantial question of law is involved in any
No,
case,
it shall formulate that question, yes.
it may be subsequently also, but in view of
And 5 is shall be hard on the question so formulated.
and the rest-
Otherwise, it has to be hard on that question only. But at the hearing of the appeal, this shall not depart the court from. No. 5 says that they may argue that it does not involve. That is different. 3 says 103 says precisely state, but still 4 says court has to formulate.
No, court has to-
Proviso says that nothing will abridge the power of the court to hear for reasons appeal on any other substantial question of law.
subsequently, not again the court can frame additional questions.
So this does not preclude the court from framing any other question.
Fine.
But that initial formulation has to be there. That order has to be recalled.
My lord, I'm ready, my lord, on the merits of the matter. My lord.
Yes, we'll recall and immediately here right now.
My lord. Only one thing that I must point out.
Yes.
There was a direction to serve. We served, but the postal track reports came back. Others were served. Only one of the pro forma defendants, who was the added party, expired. Now the decree is not binding against that party.
Why?
Because what happened in this suit? The suit is for a declaration by my learned friend's client that I am encroaching a portion of a municipal land, and that construction over that portion should be demolished. In that suit-
পাখাটা বন্ধ করা গেল না এখনো ঠান্ডা লাগছে কেন আর আরো ও এসি মাথার উপর চলছে সবই বন্ধ করে ছেড়ে দিন যা চলছে
in that suit,
Yes.
court came to the finding.
এসি বন্ধ করে দিলে সেটা ঠিক না এটা আসছে এই এসি থেকে আসছে এটা এসিটা গরম করা যাবে একটু এটা তো ইয়ে দিন রিমোটটা আমার হাতে দেবেন যেটা মামলা হচ্ছে সেই অনুযায়ী জোরে আসতে করবো ঠান্ডাটা ইয়েস মিস্টার ব্যানার্জি ডোন্ট কম্পেল আস টু put it on a
Depending on the
yeah.
Now, in the suit,
That will be an indication to counsel also whether we increase the temperature or decrease it. Yes.
now in the suit, my lord, court passed an order that they filed the suit in representative capacity, representing the other people of the locality. Because our point was that you are not the municipality. How can you get that order implemented? That was one of the points. So some persons got
They
added.
said you were encroaching on municipality.
That is the allegation. Municipal land.
That is the allegation.
What is the relief claim?
Allegation, the degree was passed and upon.
What was the relief claim?
Relief claimed is that we have a declaration that we have encroached municipal land, one.
They have no locus standi for that.
They don't have. But in the suit, one order was passed that they are espousing the cause of the local people. In representative capacity, they have filed the suit. There was one order.
Even in representative capacity, then they had to represent the corporation, municipality.
They have to represent, that is one of the points, but in my appeal, firstly, they don't have locus. Secondly, my lord, if it is municipal land, then it's government coming under the.
So what about the death of the who died?
He was not one of the persons who was subsequently added being a local resident. He was added one of the local residents. He was added as a pro forma defendant. So he is one of the pro forma.
No relief was claimed against him.
No relief against, so I say, my lord, if
He did not contest also.
did not appeared, my lord, in I find there is appearance of this particular defendant.
Did he contest the suit by filing a written statement and denying the plaintiff case?
No. Because they are supporting the plaintiff, pro forma.
Of course.
Supporting. So, my lord, he is not against them.
Municipality is a party in
Municipality is the party.
Municipality is different. Municipality has not died. Has the municipality also died?
No, municipality is a party in the suit.
Municipality did not.
We are speaking about the death of a party.
I'm not.
You are also submitting that municipality has died.
Municipality.
But then it has not died, obviously. As yet.
If the appeal is recorded that the appeal has abated as against that person, my lord, the appeal will survive because not that person has not
No relief claimed, yes.
relief claim. No, I'm filing the affidavit of service, my lord.
So let us recall the order and hear out the.
Fine.
The affidavit of service, affidavit of service filed to be kept on record. Full stop. It transpires therefrom that this is affidavit of service of what?
In terms of the order passed by this honorable court, which your lordship is
Regarding the stay application.
regarding your admission of the appeal and service of stay application. That order is
Affidavit of service filed in respect of the stay application, that is scan 1 of 2022, filed today in court, be kept on record. First of it transpires therefrom that one of the pro forma defendants, who had basically supported the case of the plaintiff stroke respondents, has died in the meantime. Full stop. Next para, since there was no effective contest from the said party and the plaintiffs were treated to file the suit in representative capacity, we are of the opinion that the demise of the said party does not affect the appeal, and as such, we dispense with substitution of the heirs and legal representatives of the said respondent. What is the number of the respondent?
Respondent number.
Respondent being respondent number, the blank
6, my lord.
Respondent 6. Next para. We are recalling the order and hearing it right now. Husab, Can 2 of 2023 is an application for recall of the order dated August 11, 2022, passed by a coordinate bench. Husab, by the said order, the present second appeal was admitted without formulating any substantial question of law. Husab, after hearing learned counsel for the parties, we observe that from an interplay, on a proper interpretation of the interplay between Order 42, Rule 2 and Section 100 of the Code of Civil Procedure, it is mandatory for a court, while admitting a second appeal, to formulate the substantial questions of law. Full stop. Although the proviso to Section 100 within bracket 5 indicates that nothing in subsection 5 shall abridge or take away the power of the court to hear the appeal on any other substantial question of law not formulated by it initially, the expression other clause clearly signifies that it is a prerequisite that the provision of Section 100 within bracket 4, which mandates the High Court to formulate a substantial question of law before hearing an appeal, has to be adhered to. Full stop. That apart, Order 42, Rule 2 does not mince words insofar as it mandates the court admitting a second appeal to formulate the substantial question of law as required by section 100 while admitting the appeal itself, and only then direct the second appeal to be heard. Full stop, the expression shall used in Rule 2 of Order 42 is a clear indicator of the mandatory nature of the said provision. Full stop, next para, since no such question has been formulated while admitting the present second appeal, comma, Can 2 of 2023 is allowed, comma, thereby recalling the order dated August 11, 2022. Full stop. Next para, we, on consent of parties, comma, we take up the appeal for hearing under Order 41 Rule 11 of the Code of Civil Procedure for the ends of justice. Yes. What are the substantial questions of law? Now,
But the suit was filed for declaration.
Yes.
That we have encroached, my lord, a strip of land measuring 37 feet by 8 feet, which is a municipal land.
Suit was for declaration that you have encroached on municipal
Municipal
land.
land measuring a particular schedule B, 37 feet by 8 feet.
So first question is of locus standi of the plaintiff.
Whether the municipal plaintiff, who is a neighbor, can enforce this, my lord. Get a declaration.
Municipality was a defendant in the suit.
Defendant in the suit.
Acha. Locus standi, even if he came under Order 41 Rule 8, Order 1 Rule 8, even then he could at best have represented the people of the locality.
But he cannot ask
Not
for
the municipality.
Not the municipality.
Even the people of the locality are on the same footing as him.
My lord. So the first question is on locus.
Locus.
Next question is, my lord. Admittedly, the plaintiff case is based on assertion that it is municipal land. If it is municipal land, it is coming within definition of government land under the West Bengal Public Land Eviction of Unauthorized Occupants Act. If a lordship takes up
What was the year we have forgotten?
It's 1962.
62, right.
If a lordship takes up the definition of land, section 2(7), public land means any land belonging to or taken on lease by the state government, a local authority, a government company, or a corporation owned or controlled by the central or state government.
Yes.
So municipality is a local authority under West Bengal municipal.
Yes.
So it is a public land.
Right.
If it is a public land, then not to get recovery of the land.
They're not asking for recovery. What is the main relief sought by the, only that declaration?
No, mandatory injunction directing us to demolish that construction.
That can only be under this act.
Can only be under this act. There's a bar, my lord. Statutory bar, suit is barred.
Which was that bar?
Section 8, capital A. Because municipality had not served a notice upon us in 2001, saying that we have encroached municipal land. They want implementation of that notice. 8A.
And the provision for removal of encroachment?
The provision, Lord, here, my lord,
Here.
this is recovery.
Yes,
Section
yes.
3. Section 3 is the provision. Collector have to do it. If the collector is of the opinion upon application made by the officer of or the owner of public land.
3(4).
3(4). This is the procedure to be followed. So I say it's a public land. So only under this act they could have proceeded.
Yes, we'll admit on these two questions.
That's two more questions, my lord. Two more questions. Two more questions.
Yes.
The court directed, my lord, demolition of the construction. Now your lordship knows not that for demolition, my lord, only the municipality can pass an order of demolition only by the board of councillors after, my lord, a proceeding under section 218. In this case, my lord,
280.
218. 218
Of the Bengal Municipal
West
Act.
Bengal Municipal Act 1993. Notice below there.
All right.
This is
So
the-
there's a bar under that act also.
Only the board of councillor can do it. This is the notice which, my lord, the plaintiff seek to implement. Kindly see, my lord, passed by the chairman that we have encroached, removed. So this notice itself is without jurisdiction. Only the board of councillor has jurisdiction. I had a copy there. And I'm giving a copy, my lord.
No, this notice we won't go into at this stage.
No, because my lord, they mentioned this, my lord. They mentioned this notice. They want implementation of this, my lord. That is the plain case, my lord. In the plain case, they say municipality has given a notice.
Achha.
On the basis of that notice, it should be removed. So this notice, which in the plain case they seek to implement,
it had to be given by the board of councillors.
councillors only, my lord, after following a proceeding under section 218, which is never done. So that is another point. And the fourth point is, my lord, the court, on the question of, my lord, encroachment, the trial court has, my lord, taken that notice to be sacrosanct. Court has held, I'll show, my lord, kindly see internal page 11 of the order, my lord, taken this to be sacrosanct without
It's an affirmance, judgment of affirmance.
No,
Yes,
judgment by affirmance.
Both court held.
Yes.
Yes, encroachment.
Court has held that since municipality is the competent authority and they have given the notice, that is sacrosanct. That is conclusive proof that there is encroachment. Kindly come to page 11, my lord.
But this is covered by 3, the previous question.
Yes. No, my lord,
Or you say that cannot be sacrosanct.
cannot be sacrosanct. Court has not patent illegality because court has not gone into any inquiry, no local investigation, only on the basis of this notice directed.
Oh, sacrosanct, sacrosanct to
The
the
word
effect that
used-
it was illegal.
My lord.
Very
As conclusive proof, court has held, I have considered the
The
notice.
present second appeal shall be heard on the following substantial questions of law. 1, Roman 1, as to whether the plaintiff stroke respondents had the locus standi to file the suit for declaration that the defendant stroke appellants have illegally, unlawfully encroached on municipal land, comma, in view of the plaintiffs, comma, in their individual capacities, comma, even if acting in representative capacity under Order 1, Rule 8 of the Code of Civil Procedure, comma, could at best have represented the people in the locality and not the municipal authorities. Second, Roman 2, whether the suit was barred under Section 8, capital A, capital A of the West Bengal Public Land within bracket eviction of unauthorized occupants bracket closed Act, comma, 1962, inasmuch as the provisions of the said Act empower the collector to take appropriate steps for evicting persons in unauthorized occupation and demolishing illegal encroachments on public land. Roman 3, whether in view of Section 218 of the West Bengal Municipal Act mandating only the Board of Councillors, empowering only the Board of Councillors of the municipality, comma, upon appropriate prior proceedings having been undertaken, comma, to direct demolition of an unauthorized encroachment, comma, the notice issued by the chairman of the Hooghly-Chinsurah municipality, comma, which was marked as Exhibit 1 in the suit, and the foundation of the impugned decree of both the courts below, comma, was valid in the eye of law. Roman 4, whether the courts below committed a patent perversity in proceeding on the premise that Exhibit 1, that is memo number 4668 stroke capital E small n s hyphen ds dated December 4, 2001, comma, that is the notice issued by the chairman of the Howrah-Chinsurah municipality, comma, was sacrosanct and sufficiently proved the illegality of the construction made by the plaintiff stroke appellants, comma, without considering or adverting to any substantial evidence independently in its capacity as a civil court before coming to such conclusion. Full stop. Next para. Yes. What about the stay? Stay was granted.
Lord, stay was not granted, my lord. I'm praying for stay, although, my lord, a portion has already been demolished, not the entire thing, but still, would we pray for protection, my lord, by way of stay?
Yes, what do you say? We'll grant stay. We have admitted there.
Kindly allow me to file, my lord.
Opposition you will file? Very well. You had that opportunity. I will grant you fresh opportunity. Learned counsel appearing for the plaintiff stroke respondents seeks an opportunity to file an affidavit in opposition to Can 1 of 2022. Can 1 is the stay application.
Yes.
Full stop. Next para. Accordingly, the plaintiff's respondents, would you like to file any? The plaintiff, you have to be neutral here. The plaintiff's respondents shall file an affidavit in opposition to the stay application within
2 weeks.
Within a fortnight from date. Reply, if any, shall be filed within a week thereafter. Full stop. liberty to the parties to mention the application thereafter before the appropriate learned single judge having determination to hear the second appeal and connected applications. Full stop. Next para. There shall be stay of operation of the impugned judgment and decree as on this date till disposal of the application. As on this date, because otherwise their previous demolition will get.
Extremely grateful, my lord.
Yes, thank you.
Can 2 also dispose?
Can 2, what is can 2?
Can 2 or application for recalling. Application
Can 2 have disposed of at the outset? Otherwise, how could we take it up for order? এতদিন order 41 application শুনেছি এবার application order 41 শুনতে হলো yes
I am the appellant plaintiff. On the last occasion when this matter was taken up, your lordships were pleased to pass an order of injunction restraining the defendants from creating any third-party interest in respect of the suit property. Suit is for eviction on the ground of determination of the lease. That's all.
So, misappeal against injunction.
Injunction. Your lordship has granted me injunction. Now, this was.
Have you served properly on the?
We have served the track report. The latest track report says that's downloaded on 9th June.
What does it say?
Out for delivery. Dole law.
Thank you. It transpires from the affidavit of service filed today and kept on record that although due intimation was given to the addressee stroke respondent, comma, the service was not claimed by the addressee. So as such, comma, we deem the same to be good service and take up the application for final disposal. Full stop. In view of our order dated May 21, 2025, comma, where we had elaborately recorded that a strong prima facie case had been made out for grant of injunction and that the other factors, including balance of convenience, were in favor of balance of convenience and irreparable injury were in favor of such grant, comma, and in the absence of anything to show that there has been any subsequent change of circumstance, comma, we intend to make the said order absolute. Full stop. Accordingly, can 1 of 2025 is allowed, comma, thereby restraining the respondent and its men and agents from dealing with alienating, disposing of, encumbering, transferring and or creating any third party interest in respect of the suit property or any portion thereof till disposal of the appeal. Full stop. Next para. The appellant shall put in due requisites and postal costs for service of notice of the appeal on the respondent within a week from date. Full stop. The trial court record shall be brought by special. Should the trial court records be brought?
Not required. I have
Very well.
annexed all the documents.
The trial, in view of the relevant documents being available on record, comma, we dispense with calling for the trial court records. Full stop. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records, incorporating all relevant documents within 6 weeks from date. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
And interim order till
disposal of the appeal.
Great.
Yes.
এগুলো করে দিও notice of appeal.
চলো।
Lord, I appear for the appeal, my lord.
Yes.
Pursuant to the order passed by your lordship on 13th May.
Can you please come a bit closer to the yes.
Sorry, my lord. Lord, pursuant to the order passed by your lordship on 13th May, my lord. Further service has been.
The remaining respondents have been served in the meantime.
I have given the evidence service.
You have checked up the good services?
Yes, yes, yes.
Good.
I have checked it.
What is the matter about?
But this is a suit for partition and injunction. I'm the defendant number 1.
Mr. Rai, what is can 1 for and what is can 2 for?
No, 1 is for section 5.
That has been allowed.
No,
That has not. What is the delay? First, let us think about
1366. 1366.
Only 1000.
Paragraph 4 I have stated, Lord.
Let us see that.
The counsel appeared.
1000 is.
The matter all along, but on the date of argument, he remained absent. That
I got it from the order itself, my lord.
Paragraph number 3.
Paragraph 4, my lord.
4. This is against a preliminary degree.
Yes, my lord. My lord,
We
my-
hope the final degree has not been passed in the meantime.
Has not yet been passed and commission work has not been completed. And my lord, I purchased the property from the defendant number 5 and 6, who got the property from their father Hiralal, who hold 116 CR.
No, but let us come to paragraph 4. There is no explanation at all. Order was passed on in February 2019 and preliminary degree signed on in March 2019. Not known to the petitioner for a couple of years because of pandemic. Pandemic had set in after that.
After 1 year.
1 year after that.
But
You had anticipated the pandemic and sat tight on in your home.
the advocate engaged in the court bill of law, he could not remain present during the
Yes, but what about the explanation for 1 year?
order. He could not possibly the learned advocate remain absent and could.
There is no reason for his absence given.
In the order itself, I got it. In the
You
order-
have you only say that he remained absent, but there has
in
to
the
be a
order,
cogent.
I got it from the order itself.
Not that. Unless you explain his absence, why should he represented you? He represented you. Just saying that he was absent won't do. You have a responsibility also as a litigant. You didn't know that that was a date.
He could not. He remained absent during hearing, and the order was not communicated to me.
You also had some responsibility for 1 year. You did not take any over phone during pandemic. You did not take instruction. In the middle of 2024, you have.
But
There is no explanation, Mr.
But what I have got from the client.
No, you cannot
Till date,
improve the situation.
but I appreciate. I am not. I have no explanation about the situation. The only thing that learned advocate engaged. He could
After 5 years, you have preferred the appeal.
Yes. Well, and
Pandemic came and went in between.
Paragraph 4 and 6 I have explained. The matter came to me, I advised them to prefer the appeal. After going through the order and you will also kindly see the order itself at page 8, my lord.
Cannot look into that nowadays.
So you'll also kindly see.
In view of
Kindly
the
look into the order.
two recent judgments, although there is one judgment after that which is in your favor, liberal, but two of the judgments say that merits cannot be looked into even cursorily.
He is a illiterate lady, my lord. But running, he earns
The
his.
judge was also a lady, so equality on that. Supreme Court judge.
Think not the
Mr. Rai, we can appreciate your
Yes.
agony, but this is no explanation. I mean, see.
I entirely leave to your lordship.
No,
mercy, my lord.
we would have loved
Lord,
to allow
I-
your application, but we cannot do this. I mean, this would be injustice to them also. Rights have accrued in these 5 years.
The situation in the meantime, pandemic situation intervened, my lord.
Pandemic that did not affect you. To March 2019 degree was signed.
Was not conveyed to the appellant even.
That means
Advocate. And
that
when-
means before the start of pandemic for this 1 year, you never contacted your advocate. It is not your case that you contacted his suppressed.
in any event, there was no contact.
If for 1 year you don't contact your client, your advocate, that itself is gross negligence.
But,
Is he contacting you now?
not he,
Obviously not.
appellant could not explain properly. But I got this from the order.
Apart from lady, is there any other mitigating circle? Age 43 years.
Yes, my lord. My lord, he earns his livelihood by running a garment shop. And my lord,
We
she's a
appreciate,
very
Mr.
good lady, my lord. My lord, I could not collect the materials about the proceeding.
For 1 year, she did not even take information of her. We are going by your case.
There is some gap. I understand, my lord. And in
And
paragraph-
pandemic ended long back. Pandemic ended in 2021,
yes, my lord.
2022. What about 22 to 24?
And the situation when she got the information, she engaged another lawyer.
What was she doing in between? It is not your case that she approached her advocate suppressed. If that was your case, we would have directed notice to the advocate definitely. But even then, you would have a case. But
There is a gap.
gap.
There is a gap between the client and the advocate for some time. I understand, Lord, from the situation. Lord,
No, sorry,
the
Mr.
order sheet, Lord, I got it that the advocate remained absent during argument. In the order sheet, I find at page 8.
We accept, we proceed on that premise. Advocate was absent for some reason, which reason you have not given, but let us forget that.
Perfectly right about the negligence on the part of the appellant.
Utter negligence, Mr. Rai. Even if she did not have money, she could have contacted.
No,
Actual thing could have been stated. Did not have money, I contacted, but I could not pay my advocate. Even if that was said, we'd have understood.
Well, if your lordship so want, I can file a supplementary affidavit.
No, don't file.
If your lordship so want.
No, we won't advise. No, don't say that.
Your lordship,
How do you explain 22 to 24?
Yes, my lord.
Pandemic ended.
Yes.
21, in fact.
And 22.
From
Yes,
22.
2 years.
22.
But,
22 to 24, what happened?
Subsequently, he engaged another lawyer.
That you have stated also.
Yes, I have stated.
He also did not contact you.
No. Then I got the paragraph 6, blood.
Paragraph 6, where is the other advocates?
Blood, yes. Mr. I have given the name of the advocate.
This is you, Mr. Rai.
No, yeah, paragraph. Mr. Tapos Addo.
Where is that? This is not in para 6.
Paragraph 4. However, coming to know the aforesaid order, in the middle of 2024, the appellant engaged another lawyer.
No, that you engaged in 2024. What happened between the end of pandemic in 22 and 24? Not a single line stated even. No, Mr.
Rai. Accordingly, an application was made thereafter by the new advocate, and that was also rejected. I have annexed the order. An application was made by the engaged lawyer.
There is a delay of, sorry, Mr. Rai.
Your lordship,
No, there is a delay of about 5 years in preferring.
there is a good arguable case in the first case.
There is a delay of about 5.
Your lordship, one thing, Lord. The plaintiff inherited 1/16 share from the from his grandfather, and Lord, the defendant number 1 inherited the 1/16 property of the defendant number 2 and 2, who got the property from their father, 1/16 share of the property, and this has been recorded in the order, but the defendant's share has not been declared. Held it has been mentioned in the order itself.
It has been held that defendant has a right.
No, that's why I got all this from the order itself.
There is a gap from the inherited person. He claimed that he has gifted the property to their daughters, but those deed has not.
Gift deed is not there.
That's why in the order itself,
No, we won't go into that. That is arguable bad. The delay in filing the appeal is of about 5 years. Full stop. The decree, the judgment, the impugned judgment was admittedly passed on February 27, 2019, and the preliminary decree of partition from which the appeal arises was signed on March 30, 2019. Full stop. Next para. The explanation proffered, offered er age PR hobe, proffered in the application under section 5 of the Code of the Limitation Act is that the said order was not known to the petitioner for a couple of years because of the pandemic within bracket COVID-19 bracket close situation affected at that material time, and that on coming to know of the said judgment and decree in the middle of 2024, comma, the appellant engaged another lawyer to look into the case, and an application was made praying for declaration of the share of the appellant. Full stop. Next para. Such application was apparently rejected by the learned trial judge. Full stop. The appellant only thereafter applied for having the certified copy of the judgment and preliminary decree on December 2, 2024, and the same was made ready subsequently, upon which the present appeal has been preferred. Next para. However, comma, there are glaring gaps in the explanation. Full stop. First, comma, the pandemic started only in or about March 2020, whereas the impugned judgment and decree were passed on February 27, 2019. Full stop. The explanation for the period in between is missing. Full stop. Next para, moreover, comma, there was nothing preventing the appellant from at least taking information about her about her case from the learned advocate conducting the matter in the trial court over telephone, even during the pandemic period. So there is no averment whatsoever that between February 2019, when the impugned judgment was passed, and the middle of 2024, when the appellant allegedly engaged another learned advocate, any step whatsoever was taken by the appellant to inquire about her case. Full stop. Even thereafter, a flimsy application was made in the trial court, which is neither here nor there. Full stop. The certified copy of the judgment and preliminary decree impugned herein was applied for only on December 2, 2024. That is more than 5 years after the filing, after the passing of the same. Full stop. Next para. We do not find any plausible explanation whatsoever having been furnished in the application, and accordingly are unable to hold that the appellant was at all diligent in conducting her litigation all through. Full stop. Next para. The lenient view generally applied in condonation applications cannot be extended to a palpably negligent litigant, who did not look after her own case. Full stop. Next para. As such, we do not find any sufficiency in the reasons shown for preferring the appeal late. Full stop. Accordingly, Can 1 of 2025 is dismissed on contest without any orders to cost. Consequentially, FAT 60 of 2025 is dismissed as time barred. Full stop. Accordingly, Can 2 of 2025 also stands dismissed. There will be no orders to cost. It's a normal format হবে কারণ consequential তো
respond. Respondent. In this matter, I am
for the applicant, my lord.
Yes.
in this matter, I am for the respondent number 1, who is the main defendant in the title suit for partition.
My lord, there is
You have challenged the preliminary decree?
yes, my lord.
Yes.
What is Can 1 and what is Can?
Can 1 is a section 5 application.
What is the delay?
75 days delay.
What is the explanation?
Please let
Not
me-
served.
Not served.
Give a copy, come back.
Only Can 2 is served. Can 2 is the application for appropriate order.
Why should they serve only Can 2?
No, both has been served. That's why my information good.
Can
Anyway,
2
give a
only.
copy, come back tomorrow.
And yes, give me copy now.
Let us come back tomorrow. Yes.
Dear
Learned counsel appearing for the defendant respondent number 1.
Defendant respondent number 1, defendant number 1 also.
Let the affidavit.
You are appearing for defendant respondent number 1.
One.
Learned counsel appearing for the defendant respondent number 1 submits that no copy of the condonation application has been served on him. Full stop. The affidavit of service filed today be kept on record. Full stop. Although learned counsel for the appellant submits that copies of both the applications were served, for the ends of justice, the learned advocate for the appellant is requested to serve another copy of the condonation application on his counterpart appearing for the respondent, number 1, during the course of the day.
Here I am.
Full stop. A copy, as per the above direction, a copy is served here and now. Full stop. Let the matter be listed tomorrow under the same heading. Come back tomorrow, we'll take it.
My lord, I am appearing on the behalf of
এখনো রিমোট আছে? হ্যাঁ? কি খুলে দিয়েছেন? সুইং তুলে দিয়েছেন? মানে উপর দিকে যাচ্ছে এখন। ওই রিমোটটা আপনার কাছে আছে তো? হ্যাঁ, রেখে দেবেন রিমোটটা, মানে কত টেম্পারেচারটা কত আছে ওটা? Yes.
My lord, I am appearing on the behalf of the applicant. My lord,
Yes.
I tender my unqualified.
Accepted, but why?
My lord, the earlier occasion, your lordship actually pleased to direct the 20,000 to
Occupation charge,
respondent,
yes.
and otherwise we are actually bound to surrender. My lord, we actually penniless. We actually, my client actually failed to arrange the money, and he is actually handover and surrender before the present landlord. Present landlord is the owner of the northern portion, and the defendant father is actually sell out the present landlord, and we actually, and Milord actually
They had
that
filed the
present
eviction suit,
landlord
got an eviction decree.
and present landlord acknowledge the page number 8, Milord, kindly.
You have got a copy of this opposition?
Yes, Manoj, this is our
And
client.
your lordship actually direct, if there is any objection of that affidavit, they can.
No,
they
we
can-
don't understand. You have handed over possession to somebody else.
Yes,
The present landlord of the northern portion.
You say present landlord. Did you take this point in the suit?
Yes.
That was turned
present-
down by the court below.
No. That present landlord also file a ejectment title suit against that respondent and party, me as a party, and for the same room.
What happened to that suit?
So it is pending, and it is,
He has already a decree against you.
and these.
He was to get possession from you. You are colluding with the other person.
Yes, Manoj.
See, another suit is pending. We are not bothered with that. This landlord has obtained a decree against you. You are bound by that decree. You have lost the suit.
Milord, kindly
You have to hand over to him.
that. Milord, kindly appreciate that Pritam Gupta acknowledge the
Miss Pritam Gupta. No, we cannot reopen the case. We cannot reopen it at this stage. You have already suffered a decree which is in the it's staring at you.
Milord,
আমার temperature আমার দিকে point করছে ওদিকে point.
kindly appreciate the can 3 already in the records. Milord, we
See,
actually
another suit is pending by a third party who has obviously been set up by you against them.
No.
Impeding you.
They are
That
actually
that suit is for what? Eviction.
eviction for the same room.
Very well. That suit is still pending. There is no decree in that. Listen to us carefully. No decree in that. That is pending. Therefore, there is no executable decree in that suit. But in his suit, he has obtained a decree against you. So you are the judgment debtor. You have lost the suit. You are duty bound to hand over to him. Why did you hand over to a third party?
Milord, kindly appreciate one sentence, Milord. Kindly appreciate that present landlord, forced us, and they took all the responsibility.
He is the present landlord.
Not present landlord.
What a decree saying he's the landlord. You are bound by that.
There is the previous landlord. He is actually sell out the sale of.
You execute the decree
Yes, Manoj.
against whoever is there. You execute it.
And Manoj, for their admission, nothing remains to be decided.
Milord,
They
kindly-
they admitted that this is northern portion and this is southern portion.
Kindly-
The whole
It is-
What have you
it is-
admitted?
It is not a position. It is the southern portion of the northern, and this
Southern of the northern is southern.
southern block. Milord, kindly appreciate they sell out the northern portion.
What is the subject matter of the suit? South or north?
south.
No,
That is in the
Milord.
plain. Described in the plain.
Wait. Milord, kindly see. There is a plaintiff copy. If your lordship see that plane, there is plaintiff copy.
You have not annexed the decree?
Manoj, their appeal.
Oh, you have not annexed the decree of the trial court?
I annexed, Milord. Annex. Certified copy of the degree, Milord. I annexed.
Yes. Room, veranda, privy on the first floor on the southern portion. Suit is southern portion.
Shoot is
Southern portion.
southern portion of the northern side.
Acha.
This is the point, Milord. And Pritam Gupta is that owner of the northern portion. And not only that fact, my lord, Pritam Gupta already filed against me for the surrender of that.
Has he got a decree against you in that suit?
It is pending, and
If
next
it is
date,
pending, why did you hand over possession to that person? Despite
because
having a decree against, there being a decree in his favor? You are suffering a decree in his favor. Why did you hand over to a third party? Either of you, if you can't submit, please let him.
my lord,
Both of you cannot argue together. He's making the gestures and you are making the submissions. It's disturbing us. Either both of you make the gestures as well as the postures, or one of you take your seat and the other argue.
my lord,
One is speaking. This is not a mime theater going on, or a newscast where a person is indicating on the side and you are casting the
my
news.
lord, I'm very sorry.
One of you argue. Let him argue if he wants. Yes, what is the matter? He has obtained a decree against you.
My
You are
lord,
suffering that degree. Another suit is pending and you hand it over to that person.
my lord, kindly see that.
That's a contempt of the court, in fact. That's a
Lord,
contempt of the decree.
I already told my learned advocate on, so
What did you tell him?
that it is contempt of the court, and
You handed over when?
it is, my lord, kindly see
After they obtained the stay.
paragraph number 7 and 8, my lord.
That's serious. Stay obtain করার পর থার্ড পার্টিকে দিয়েছে দেখাচ্ছি থার্ড পার্টি দুটোকেই ঢোকাবো When was this stay order passed?
Stay order pass in that.
Did you advise your clients like this? At 70 years of age, he will be behind the bars.
My lord, I already.
What do you think of the court? When was the order passed?
11 February, my lord.
Let us see when we pass the order. This is palpable contempt. 11th February, you pass an order of stay subject to your payment of occupation charges, and you hand over possession to a third party on the 21st of February. Your client will be present in court. We will take up the matter on Monday. He'll go to court. We'll issue a suo motu rule of contempt.
Kindly allow my learned.
Not now. We gave you that option.
But
সাহস হয় কি করে
it's already.
ওদের প্রেজেন্স অর্ডার হয়েছিল What is the position of that execution case?
My lord, it is my lord state and my lord.
No, there is no stay because they have not paid.
Yes, order 21, rule 97 filed. It is still at the stage of consideration. They have also.
What about the other suit pending by the other person?
That is pending, my lord.
You are a defendant
Yes,
there.
hearing.
That
Yes.
was filed when? After your suit?
Yes, my lord, in 2019. And my lord, my suit is 2014.
But kindly, I submit one thing, my lord.
Because as
They
per their
first they sell out the northern portion. Thereafter, after 9 years back, they suddenly filed that ejectment suit, title suit, no? Title suit, my lord. And thereafter, that present landlord also filed the title suit against us for the same room, my lord. Only one room. And that present landlord take all the responsibility. My lord, kindly peruse that page number 8, my lord. If your lordship pass that at me as a party respondent.
An affidavit in opposition is filed in court today and kept on record. Full stop. It transpires therefrom that in the teeth of the order dated February 11, 2025, whereby we had granted stay of the execution of stay of operation of the impugned eviction decree passed against the appellant and connected execution proceeding subject to payment of occupation charges of rupees 20,000, which has not been paid, the appellant, instead of complying with the said order and taking undue advantage of the said order dated February 11, 2025 within bracket, which was passed in presence of the respondent bracket closed, comma, has handed over possession of the suit property in favor of a third party whom the appellant claims to be the real landlord. Full stop. Next para. We, comma, thus, comma, find that the said act on the part of the appellant is blatantly contumacious, inasmuch as the appellant argues that a suit at the behest of the said Pritam Gupta, comma, to whom possession has been handed over by the appellant, comma, for eviction of the appellant in respect of the self-same property is still pending, whereas the suit filed by the present respondent, Dr. Ranjan Kumar Mitra, was already decreed, against which the present appeal has been preferred. Full stop. During pendency of the appeal, comma, the appellant obtained an order of stay of the execution on condition that of payment of occupation charges, which the appellant did not comply with. Full stop. Thus, hence, comma, knowing fully well that the appellant is suffering a decree passed in favor of the respondent, comma, and taking advantage of the stay order granted by this court, comma, even without complying with the payment of occupation charges, comma, surreptitiously handed over possession of the property to a third party on a subsequent date to the passing of the impugned order, that is on February 21, 2025. Full stop. Next para. It is unimaginable that in his affidavit in opposition, comma, the appellant flaunts such deliberate and willful violation of the spirit of the order dated February 11, 2025, comma, whereby a stay order was obtained by the appellant, comma, the appellant has parted with possession of the property in favor of a third party, comma, obviously in collusion with the said third party. Full stop. Next para. We deem such action on the part of the appellant palpably contradictory. Full stop. Next para. Accordingly, a rule to issue calling upon the appellant to show cause as to why the appellant should not be sent to prison, should not be imprisoned and or imposed with fine and or dealt with otherwise for willful and deliberate violation of the order dated February 11, 2025, passed in connection with Can 3 of 2024, by taking undue advantage of the said order and even without complying with the direct condition of payment of occupation charges, comma, handed over possession of the property to a third party to frustrate the said application and the outcome of the present appeal. Full stop. The rule is made returnable on July 14, 2025 at 10:30 a.m. Full stop. Next para. Insofar as the present application is concerned, comma, in view of the appellant having admittedly parted with possession of the property in favor of a third party, comma, the interim order of stay granted in favor of a third party, comma, as well as since the appellant has admittedly not complied with the precondition of payment of occupation charges, comma, the stay granted in respect of Can 3 যেটা আগে বলেছিলাম ওটা Can 1 হবে। Can 1 of 2023 is hereby vacated, full stop. Consequentially, comma, Can 1 of 2023 is also dismissed as infructuous. Full stop. This much. Rule has been issued. Rule will be issued. The appellate will be personally present at 10:30 on 14th of July.
And the execution case be disposed of expeditiously.
We make it amply clear that the executing court shall expedite the execution case filed in connection with the decree which has been impugned in FA 80 of 2025. So it is expected that the said execution case will be disposed of within an outer limit of 2 months from the date of communication of this order to the executing court.
Grateful.
Please give your names. Both your names. Yes.
My application, my lord.
Yeah, for this.
Before you start.
He has already started.
No, your lordship will kindly.
Oh, nothing in the matter. Nothing in the matter. Nothing in the matter.
No, my lord, there is, my lord, my thing is that these people are fighting amongst themselves. Two husband and wife.
Two husband and wife?
No, I'm saying husband and wife are fighting
Thank God.
amongst themselves.
Yes.
Now, what I was saying, this child is suffering. I tell you, lordship, because the child, somehow or the other is attached to the mother. She can't go there, or whatever is happening.
That
could be sit.
Your beginning means that you have flouted some order.
No, I tell you, lordship, I have not flouted on. Because I can show you, lordship. I can show you, lordship.
We
I
can
filed
decrease the
an-
temperature, but let it be high for the time being. Why have you flouted?
No, but I have filed an application also.
Your beginning indicates that you have not flouted.
Explaining everything.
You have not complied with.
But I feel sorry about this. Because I feel sorry about this child.
I feel sorry about your client because if she has not complied, she'll be in jeopardy.
I have filed an application explaining the circumstances.
Because there was a visitation.
On 10th
Let him open. Let him open his application. Yes.
My lord, on 10th March, your lordship passed an order that on every Saturday from 5 to 7, the child will be produced at the South City Mall in South Calcutta. My lord, on the first occasions, the child was produced in time. On the second occasion, the child was not produced. On the third occasion, my lord, the child was produced at 6:30. Thereafter, the child has not been produced. Now, my lord, I have argued before your lordship that a modification is necessary. Then your lordship grant me leave to file an application for modification. I filed an application for modification, that is CAN 2. Now, my lord, when the CAN 2 was disposed of 22nd May 2025, your lordship directed the opposite party to hand over the child on Friday at 6 p.m. to the petitioner. And my lord, your lordship further directed that the child should be handed over to the mother on Sunday at 10 a.m. Now, my lord, till today, my lord, on no occasion, my lord, the child was produced. My lord, I have filed an application for contempt, my lord, before your lordship. My lord, your lordship can remember that on last Wednesday I mentioned this matter before your lordship.
Contempt is appearing before us.
No, my lord, contempt is unfortunately not appearing.
We'll direct the contempt to be, let the wife come and explain.
And also,
Yes.
my lord,
No, my lord,
application.
my lord, no application, no such application has been filed.
It has been filed. I have filed it
No,
on
at
Friday.
at least-
on
Give the number of that contempt, is right?
My lord?
Give the number of that
Yes,
contempt.
CPA 960 of the.
Please
I have-
write it on a slip of paper and
Yes, yes.
direct that to be listed along with this.
Yes, and my also, my lord, my application also.
Your application is for?
For modification of the order, and I have also explained what he said is not clearly or absolutely correct.
Yes, yes.
Yes, because
Yes.
I'll show you, lordships, from the records.
Your modification, what is the number of that application?
Three, scan number 3. It's been
That is not appearing in the list
No,
also.
it's not.
You also write, give a slip of paper, both the applications will appear together.
My lord, the copy has not yet been supplied.
No, I'll give it today because it's been filed.
My lord,
We'll direct you to
and my
scan a
lord,
copy of the.
further I want to, my lord, clarify myself, my lord. Initially, the learned advocate who is appearing, Mr. Saptarshi Datta. My lord, I doubted that he has not filed the Vakalatnama. Now, my lord, your lordship from the department, and department said no Vakalatnama has been filed. Now, my lord, secondly, my lord, Mr. Tanmay Basu appeared and said he has filed the Vakalatnama. Now, my lord, I went to serve a copy of the contempt application upon Mr. Tanmay Basu. He said he is no more appearing in this matter. Then, my lord, I was requested to send a copy on WhatsApp. I immediately sent the copy on WhatsApp. Now, my lord, it appears Mr. Tanmay Basu is also not appearing. Now, my lord, let me know who is appearing at present in this matter. And, my lord, when he has filed this Vakalatnama, I just want to clarify.
Everything has been filed. You can check it out.
What is the number of that filing number of that? Ask your clerk and give us right now.
Yes. Yes, yes.
16 serial number.
I'll
Write
give
it
it
on
in
a slip of paper.
I'll give it in a slip. I'll give everything in a slip.
Yes.
Now, my lord, one more thing, my lord. Although I have not paid any leave to, my lord, present before your lordships the audio recording. Now, my lord, in the audio, my lord, over the phone call, the word that has been used, I can, my lord, express. My lord, if I express in the audio recording before your lordship, my lord, your lordship be astonished that a lady can speak in such a language.
To your client?
Yes, no.
The other side.
The other side. My lord,
No, she spoke to whom?
spoke
your
to my client. The audio recording is with me. Not only that, my lord, she spoke to me also over phone and said that I shall see you. My lord, I can show, my lord, paste that audio recording before your lordship. It is with me.
Audio recording in 67, we will come in and all this.
Yes, my lord, that's why, my lord, I do not want to. My lord,
Your lordship
linger.
will,
abusive language that
I'm before your lordship. I'll be there before your lordship. And
we are not
Madam,
sure of that. 3 people have been before us for the wife.
Yes. Milord, I
So
can-
you are also not sure whether you will be there on the next.
No, because my affidavit, my junior has filed this vakalatnama.
My lord, let them at least say why till today they have not produced the child in terms of the order. Not only the order passed by your lordship on 22nd.
I will just give custody of the child to you and she'll be behind the bars.
Your lordship
Yes.
will take up my application.
Learned
also
counsel
next day.
appearing,
I'm
learned
not saying
senior counsel appearing for the appellant father submits that
anything.
in stark defiance of the orders of this court, comma, the respondent mother has been consistently defying such orders and has not produced the child even as per the last direction dated May 22, 2025. Full stop. It is further submitted that the respondent mother used abusive language not only to the appellant but also to the learned advocate appearing for the appellant over the phone. Full stop. Next para, it is contended that the respondent has a history of changing learned advocates. Full stop. On the first occasion, comma, a learned advocate had instruction to appear for the matter and had actually appeared at a hearing, but subsequently it was discovered that he had not filed vakalatnama. Subsequently, a different learned advocate had claimed that he had filed vakalatnama, but it was subsequently found out that the said learned advocate had also not been appearing in the matter and had no contact with the respondent. Full stop. Next para. Today, when the matter is called on for hearing, comma, a third set of advocates are appearing. Full stop. The learned advocate on record for the respondent is directed to furnish the details and particulars of the filing number of the vakalatnama and the date of filing of the same to the learned advocate appearing for the appellant during the course of the day, for the latter to verify as to whether such vakalatnama has actually been filed. Full stop. Next para. Insofar as the non-compliance of the order of this court is concerned, comma, learned counsel appearing on behalf of the respondent submits that a modification application has been filed in respect of the earlier order of this court by the respondent mother. Full stop. Next para. The appellant father, on the other hand, also submits that a contempt application is pending at the behest of the appellant, comma, for deliberate violation of the orders of this court. Full stop. Let the contempt application as well as the modification application, comma, the particulars of which shall be furnished by learned counsel for the respective parties today to our officer, comma, be listed together for hearing on June 23, 2025 under the heading application along with the other pending applications. Come back on that date?
Yes.
Thank you. Number পেয়ে গেছেন তো? Contempt still to be given.
I have given everything.
No, you have not given everything.
We have prepared the.
আমি দিয়ে দিচ্ছি।
My lord, we have
have not given
prepared the paperwork. My lord,
that direction was there.
that direction was there. We have prepared the paperwork. Can I, my lord, file this?
Just wait for the contempt order, then we'll. Yes.
This is my application for condonation
But
of.
I beg to appear for the
Respondent.
respondent husband. Lord, am I audible to your lordships? I beg to appear for the respondent husband. Lord, am I audible to your lordships? Am I audible, Lord?
Are you actually speaking or pretending to be speaking?
Lord, I
Can't hear you.
never pretend, Lord.
Yes, now we are hearing you. That's
I
why
think-
that
I think
apprehension
now the
remains.
temperature, I think now temperature will calm down, my lord, in this matter. I believe the
Not
temperature of the
necessarily,
courtroom
not
will calm
necessarily.
down.
You have appeared and so we have grown warm to you.
Okay. Lord,
Yes, Mr. Mukherjee, what is the matter? What is the delay?
not only one
delay has
only-
been caused, my lord. I am telling your lordship what happened.
What is the delay now?
My delay is, my lord, approximately 260-61 days. I mean, the cause is that, my lord, the suit for divorce has been filed by the husband, my lord. That was decreed ex parte. Now, my
may
lord,
I intervene for a
from the
minute? Lord, with Mr. Mukherjee's leave, may I intervene for a minute? Lord, in the section 5, he has filed an application for amendment. So that is to be decided first.
not
He has
amendment,
played
my
for
lord,
amendment
supplementary.
of the application. Yes, kindly see
Yes,
the.
we'll decide everything, Mr. Chakraborty. Let him be heard. Yes.
Yes, very
Nah, the supplementary will do. But your lordship last occasion stated that in the original application, I have stated that I came to learn about the expiry decree on 8th, but it will be from on 9th, not 8th, because my lord, I stated from the proceeding in under section 498A, but ultimately, my lord, I came to learn. The fact is that I came to learn where the police has given a notice to me that when I filed the 498A, that to produce the documents and other, then I came to learn that expiry decree divorce has been passed. Now, this fact, your lordship asked my learned friend, my lord, to file a supplementary affidavit. Pursuant to that, my lord, this supplementary affidavit has been filed. A copy has been given to my learned
Copy has been given to learned enemy. Yes.
Can one?
Can one against it?
I'm filing my opposition. Can one and
Opposition
to
opposition to both the can as well as the supplementary.
Can two.
Lord, may I address, Lord?
Yes.
Can 1 is filed for, Lord, condonation of delay. Now
Right.
they have filed can 3. That is an amendment to can 1.
Can
I have
3?
been served, yes, I have been
Can
served
4.
with can 3 and can 4. Now can
Both
3
are
is an
applications for amendment.
No, can 4 is not can 4 is order for rule 27. He says that
That is later. Yes.
my lord should order an inquiry against me under order for rule 27. That is his prayer. But kindly take up can 3. He prayed that your lordship should order an inquiry.
First of all, Mr. Chakraborty, the delay has to be gone. Let us consider that first.
Delay cannot
delay,
be
my lord,
condoned.
I say, my lord,
I tell you, lordship, why? Because I have conducted second marriage before filing of the appeal. There has been a delay of 300 days almost.
Well, let him move his application, Mr. Chakraborty. Let us.
delay if Mr.
No,
Chakraborty.
what is can 3, Mr.
Can 3, I don't know why my learned junior filed, my lord. Although
You don't know why should you know?
I'm telling you, lordship, my lord, okay, why can 3?
You don't
But
know
in
why it has been filed.
No, why, it is not required in the appellate side, my lord. Now, my lord, why I'm telling? Now, in the pleadings, my lord, he has stated something now which is
Substitution application after sitting as who has died?
substitution, my lord.
Come to the prayer portion, page 9 of can 3. Is it a different matter?
But perhaps my lord is having a different file.
এটা কি সাবস্টিটিউশন অ্যাপ্লিকেশন হাজবেন্ড ওয়াইফ দুজনেই বেঁচে আছে
I was praying for filing an affidavit.
No,
against
don't
can
take the chance, Mr. Chakraborty.
Madam,
Can 3, I'll file an affidavit.
but can 3, my lord, if required, I will not press. My lord, kindly see, my
Please
lord.
keep mum. First, let us consider what is can 3.
But kindly straight away come to the memorandum of appeal. Kindly see the memorandum of appeal.
No, will not. First, we'll look at can 3. এর can 3টা কোথায়?
Can 3 টা কোনো দরকার ছিল ভাই?
ওই অ্যাপিলটা যেটার can 3 এখানে ঢুকেছে সেটাতে দেখুন।
এটা কি চেঞ্জ করতে
বলছি
My lords are muted.
দরকার ছিল না।
Have you got a copy of can 3? There is a handover.
সেরাই করা নেই তো।
ওকে বার করতে হবে can 3টা এক্ষুনি।
হ্যাঁ হ্যাঁ।
দেখে একবার দিন চট করে দিন।
Can 3 তো।
Amendment.
There is second copy.
Second copy দিয়েছে নিন। Thank you.
But the only difference is why file the can 3, my lord, in the original application under section 5. But if your lordship kindly straight away come to page 5. But
No, you have given the
but this has to be replaced and my lord,
it's an amendment application.
practically amendment because my initially I stated, my lord, that when I surrendered before the court below, I came to learn but it will be when the police authority given the notice, I came to learn about this, my lord. This is the only, my
That
lord, change.
changes the entire case.
But just one day, 8th and 9th.
No.
But kindly straight away come to page 3, paragraph 2 first. Page 3, paragraph 2 of the CAN 3.
No, CAN 3 has to be located first. CAN 3 টা কি করেন আপনারা? এটা অ্যাপ্লিকেশন opposition to CAN 3 also, Mr. Chakraborty?
No, there is no order. I want to file an affidavit with
No,
this
you want to
counsel.
file it?
Yes, my lord. Yes.
If they want, my lord,
Yes.
it's up to your
I
lordship.
want.
Only one
Have
thing.
you filed an objection to opposition to the the main CAN?
Yes,
CAN 1 we have filed opposition, CAN 2 we have filed opposition, my lord.
Lord,
CAN 3 also
after-
let them file an opposition.
Yes.
File it within the weekend.
Ma'am,
File
may
it
I-
within 2 days.
May I
By
just,
Monday, I shall file it. By
may
Monday.
I just,
Fair
may I,
enough.
may I just say only one thing? My lord,
Sure.
only one day is different. 8th May, 9th May.
Even then, let them file it in any event the application is not there. CAN 3 is treated to be on the days list, although the same is not physically tagged in our file. Full stop. Our officers are directed to immediately take steps for tagging CAN 3 in the file of the present appeal and to place the same before us on the next returnable date. Full stop. In the meantime, comma, on the prayer of learned counsel for the respondent, comma, leave is granted to the respondent to file an affidavit in opposition to CAN 3 of 2025 by June 23, 2025. Full stop. The affidavits in opposition filed in respect of CAN 1 of 2025 and CAN 2 of 2025. You have filed the opposition.
Yes, it's
That has
already
not,
on
I've been told that has
No.
not been served.
Nah, CAN 1, CAN 2 opposition.
Be kept on record. Full stop. Copies thereof shall be served on the appellant, comma, if not already served during the course of the day. Full stop.
And
Reply.
sir, they have used the reply, my lord, in those
There,
opposition.
no, reply is
Already
also complete.
reply and also supplementary reply to CAN 1.
Filed the replies today.
Earlier occasion
I have
file.
filed the, my lord, one supplementary affidavit, my lord, before your lordship's court.
To the
Have
reply.
you filed any reply to the oppositions to CAN 1 and CAN 2?
Absolutely.
They
yes.
have.
Then why are you saying that no copy has been served?
তোর কথা অনুসারে বলা ভুল হচ্ছে। It is my mistake.
Copy will be served if not already served টা কেটে দিন। So reply you have filed already.
Reply file, my lord.
পরের দিন ভাই আমায় ছেড়ে দে এটা।
কি বললাম বলুন তো? আজে বাজে কথা বলে নিজের মামলায় কি আছে?
বেকার ইমপ্রেশন খারাপ হয়।
না এটা কেটে দিন, এটাও কেটে দিন। গোড়া থেকে শুরু করুন, আমি ইয়ে করছি। Learned counsel, এক পুরো কেটে দিন। Learned counsel for the respondent seeks to file an affidavit in opposition to CAN 3 of 2025. Full stop. Although CAN 3 of 2025 is not appearing in the days list, comma, the same is treated to be on the days list, and the respondent is directed to file affidavit in opposition thereto by June 23, 2025. Full stop. Our court officers shall ensure that the said application is tagged with the file before the next returnable date. Full stop. Next para. Since CAN 1 of 2025 and CAN 2 of 2025 are otherwise ready for hearing, comma, the said applications shall be listed along with CAN 3 of 2025 on June 30, 2025. Full stop. Reply, if any, to the affidavit in opposition used in connection with CAN 3 of 2025 shall be filed before the next returnable date. So opposition by 23rd, reply by 30th, and the others are ready for hearing. All will appear together.
My lord.
All the applications
Only
shall
one
appear.
in.
Hey, Meghnad, all the applications shall appear next on June 30th. বলেছে কি? Let all the applications be listed together for hearing on June 30, 2025.
Only one indulgence, Lord.
Yes.
Only one indulgence. Lord, Mr. Mukherjee's client has filed a supplementary reply annexing that she was there in the office with the day the bailiff has not submitted or served us the copy of the plate.
Yes.
Now, Lord, we have not dealt with that. Lord, we'll deal with that in the opposition filed against CAN 3. So there is no wastage of further time.
But your lordship kindly
We'll deal with
consider that because my lord, the why I filed this because bailiff said that he went to my residence, but I refused to
একটা
accept.
লাইন অ্যাড করে দিন। leave is granted to the respondent to incorporate the necessary statements controverting the contentions in the supplementary affidavit reply used in respect of Can 1 of 2025 in the respondent's opposition to Can 3 of 2025.
My lord, this will shorten the time. I'm extremely grateful to Lordship.
Can 4
Not after two matters, Lord, this matter I believe.
Can 4 আছে?
Can 4 is order 41 to 27.
Ultimately, if section 5 is allowed, then I will play.
আচ্ছা যেখানে বলা along with বললাম appear করবে next day along with can and can 4 of
Unless section 5 is allowed, I can't press for.
direction আছে অর্ডারে যেন থাকে লিস্ট চলে আসে লিস্ট
But only one indulgence. Can
you have
4,
taken
although
several
I cannot
indulgences,
proceed
Mr.
with order
Chakraborty.
41 to-
Yes.
I'll come back on 30th of on
What is
30th. I'll
that?
pray for further.
What is the indulgence?
Lord, order 41 to 27. Although my lord cannot will hear it with the appeal. They are saying that.
What my
Lord, they are saying that.
Chakraborty is saying that they have filed Can 4, which is an application under Order 41, Rule 27.
Yes.
As per law, my lord will hear it along with the appeal, my lord. Let the
Then
section.
you are conceding to the section 5.
Yes, section 5.
Let section 5 be decided, then my lord, we shall file affidavit if required when that.
Yes.
That's
That's why we have not directed even.
My lord.
Right.
Grateful to Lordship.
Item number 29.
Respondent.
Lordship, I'm for the respondent, Lordship. I'm praying.
Mr. Mukherjee is for the appeal.
Yes, Lordship. Otherwise, Lordship has dealt with the matter. I wanted to file an opposition, but I could not prepare.
Already.
Yes, it is over. Therefore, I'm praying for some extension, 1 week's extension, Lordship.
You have to obtain the leave from Mr. Mukherjee.
Yes. I have asked his junior not to call Mr. Mukherjee because I will be praying for some time. 1 week, Lordship.
It's a pleasure appearing before the
And the application is, the injunction is still disposal of the application.
Injunction.
Yes, our other orders are there. Calling for the records,
We'll
preparation.
record the presence of all parties and we'll record, if you want, you can record your opposition to his prayer.
Yeah, definitely we oppose the prayer.
Very-
This goes to show that they have got an intention to deal with the property.
No, you are already enjoying an injunction.
Yes, still disposal of the
intention
application.
of my friends.
This goes on to show that they are colluding with you and
No collusion.
making all efforts that the injunction is.
The matter between brother and sister. Brother wants everything so far as the parents are concerned. This is the condition.
You are the sister, obviously.
I am the sister.
And the sister
Can
has
it be
already-
resolved? Let us send it to mediation.
Never
That
be
will
resolved.
take care of our determination. As long as we are here, we will not,
Lordship can
will not have to hear it.
Lord.
So is mediation possible in this? We'll direct affidavits.
I have to ask. I don't.
Possible. The brother, to be very frank, not to be kept on record, the brother has induced the mother to file to suit against the sister so that the sister doesn't get any property. Thereafter, he has taken so many.
No, if there is a mediation, Mr. Mukherjee, all can be settled once and for all.
Can be settled, but it is very, very difficult. It's not possible.
Lordship, let me file my opposition. Let the appeal be heard out.
On the learned counsel appearing for the respondent seeks an extension of the time to file affidavit in opposition to the injunction application. Full stop. Learned senior counsel appearing for the appellant opposes the same and submits that the respondent is unnecessarily trying to drag the matter. Full stop. However, keeping in view that the appellant is already enjoying an ad interim order of injunction in terms of the prayers made in Can 1 of 2025, we extend the time for filing opposition thereto for a week from date as a last chance to the respondent. Full stop. Next para, reply, the time for filing reply thereto is extended for a further week thereafter. Full stop. The application shall next be listed for hearing on July 2, 2025.
Any other day beside
July 8, 2025. Because 7th will be the combined list. So July 8, 2025. Thank you. হয়ে গেছে পরের দিন আপনাকে
Item number 30.
For the
Respondent number 1.
But by virtue of my lord's last order,
yes,
my lord,
yeah, for this
from the panel, my lord, one.
There is a report. Wait, Mr. Mukherjee. There's an inspection by a panel.
Yes, your lordship appointed, my lord. The report is being submitted before your lordship. My lord, let us, my lord, have a
Go through the
copy of
report.
Yes, so that we can both go through the report and come back before your lordship.
রিপোর্ট সার্কুলেট করতে হবে পার্টিদের
But your lordship in
oh that whether that construction can be made
yes,
boundary
but
one
that boundary wall connected to the structure, whether this can be done or not, this. But only one thing, my lord, it's my duty before your lordship to point out, your lordship has kept it open regarding the remuneration of the my lord.
Yes.
My lord, now, my lord, my learned advocate on record has informed that my lord, the learned engineer, my lord, has given a my lord, his fees, estimated fees, my lord, he has given a fees, my lord, mentioning that 80,000 will be his remuneration. Now, my lord,
what is the panel rate we don't have any idea
but I also don't have my lord. He has submitted it, but if your lordship shows desire, my lord, I can hand it over because ultimately your lordship has kept it open. Ultimately, your lordship has to decide that, and I have to pay.
we have directed you to pay
Yes, that
you
your
got a
lordship-
copy of that
soft copy is not the.
so bring a printout on the next
Yes, I shall give that. And my lord, your lordship can also make it something that I can give a ad hoc remuneration. He has my lord done his job, and thereafter I shall submit before your lordship.
so
what-
has he given any reason for that
Perhaps not, my lord. He has only quantified, my lord, the what will be his remuneration.
An initial 40,000 he has.
we don't know the rates maybe that is a rate a structural engineer is
My lord, we shall come back. We may come back in the next week itself after perusing the report.
can you take information from the Registrar General's office or about the please take instruction and
I shall, yes, I
so
shall
that we
assist
can
you.
have a basis
Very well. I shall do that.
informally approach the registrar you can tell we can give you that liberty to approach the registrar
Yes, yes, Lord, I shall.
রিপোর্টটা কোথায় কোনটা report furnished in a sealed cover by the panel engineer today be kept on record full stop. The seal is opened and the report is perused by us full stop. On the prayer of learned counsel for the parties, comma, let copies of the same be circulated to the learned advocates on record for the parties by the end of this week full stop. The parties shall file their exception, comma, if any thereto by June 30, 2025. Full stop. The application shall next be listed on July 2, 2025. Full stop. Learned counsel for the appellant is appellant submits that bill regarding the fees of the panel engineer has been furnished to him in the meantime. Full stop. The learned advocate for the appellant is granted liberty to ascertain the rate chart of the remuneration of the panel surveyors stroke engineers of this court from the Registrar General of this court in the meantime, and to furnish a copy of the said bill for the perusal of the court on the next returnable date. আচ্ছা এইটার কপি করে ওদের দিয়ে দিতে হবে আমাদের এখান থেকে এই রিপোর্টটার কপি করে দুটো কপি করে একটা ওদের জন্য একটা এদের জন্য দিয়ে দিতে হবে এটা এই বাই দ্য এন্ড অফ দিস উইক বলেছি আপনি কালকের মধ্যে কপি করে দিয়ে দেবেন আর এখানে করা যাবে তো আজকেই দিয়ে দিতে পারেন মেন জেরক্সটা করি তাহলে কালকে দিয়ে দিন প্লিজ কন্ট্যাক্ট আওয়ার অফিসার টুমরো শিল বি হ্যান্ডিং ওভার কপিজ অফ দিস
গ্রেটফুল
একটা রিসিট করে নেবে জাস্ট
ইয়েস উই শ্যাল বি
একটা কপিতে একটা এক্সট্রা কপি করাবেন 3 কপি করাবেন এক্সট্রা কপিটায় দুপক্ষেরই অ্যাডভোকেট অন রেকর্ড বা ক্লার্ক যে কেউ একজন ওরা রিসিভ করে নেবেন একটাই কপিতে দুজনে রিসিভ করে নেবেন আর সেটা রেখে দেবেন সেটা পরের দিন আমাদের দেবেন গ্রেট থ্যাংক ইউ রিপোর্টটা আমরা দেখলাম না এখন দেখে 80,000 কিরকম রেমুনারেশন
Well, I do appear for the respondent plaintiff.
Sir, I appear for the appellant, defendant appellant. Again, this is a appeal, my lord, against an ex parte decree.
1 minute, Mr. Shen, in the morning you moved the matter. While correcting that order, we found that permanent alimony, we have not directed you as yet because you had filed your affidavit of asset in the permanent alimony application in connection with that itself. What is the time lapse between that impugned order and here? Just ascertain that. And if you find that the time lapse is much, then we may direct you to file further affidavit of asset. If you find that it's within a few months the impugned order was passed, then we may not direct. We have not directed, but we are just informing you. Just you ask your client and inform the other side to just take instruction as to their current income, whether there is any change. Tell your other side also, the advocate. Yes, what is the matter?
Now, in this matter, my
Yes.
learned brother's appeal, while hearing the Section 5 application, your lordship permitted them to file a supplementary affidavit since the delay was not sufficiently explained. Now, line limits were fixed.
Yes.
They went out of time. 2 weeks.
You got a
delay.
copy of that?
Yes, they have served us. We need a 1 week extension to file their reply.
Served long time back, my lord,
They
before
filed
vacation.
just 5 days before vacation. We need 1 week time. It's already drafted. It's only getting
Just
set.
5 days before the vacation. What do you mean by just?
They were supposed to file
Most
5
unjust. 5
were-
days before the vacation, you should have filed it before the vacation.
No, they have
Both of you were sufficiently diligent to do that. The client was not contacting or what?
No, we have prepared a list of days. First, we have analyzed all the medical prescriptions.
How soon can you do that?
7 days.
You have a composite affidavit in opposition to both. Or you have
That was
already.
directed. That was directed.
That was the
Composite
direction.
Affidavit of
The
opposition.
time for filing a composite affidavit in opposition to the condonation application and the supplementary affidavit filed in connection thereto is extended till June 23, 2025. Reply, if any, shall be filed by June 30, 2025. The application shall be listed for hearing on July 2, 2025. 2nd July.
Item number 32 with 33.
For the respondent.
Lordship, I beg to appear for the appellant, Mr. Deepak De, learned advocate on record, is expired, Lordship.
He was appearing in this matter.
Yes. Mr. Aditya Mondal is appearing in this matter.
Where is Mr. Aditya Mondal?
His legs before courtroom number.
So why are you taking the name of Mr. Deepak De? Who is the advocate on record?
No, Deepak De is on advocate, was on advocate on record.
How long do you require? Mr. Aditya Mondal is already there.
1 week, Lordship.
What about this Talabana to be filed? You are appearing for which of the respondents, Mr. Chakraborty?
My lord, I am.
You are also appearing.
My lord, I am
Yes.
appearing in, my lord, item number 32, my lord, for defendant number, respondent number 1, my lord.
And you?
Respondent number
Item number 32.
কত নম্বর কেন? না না ভুল হচ্ছে
Item number 32.
না না ওটা ভুল হচ্ছে
Huh? Oh, sorry.
I am for the
Wrong number.
35.
I am plaintiff respondent, my lord.
You are for which of the plaintiff respondent? Which of the respondent? Plaintiff respondent. Achha.
Plaintiff respondent.
1 to 6.
Yes, yes.
1 to 6.
Yes.
So therefore, Taliban is not required.
Not required.
We find from the office report dated May 20, 2025 that Taliban of ₹5 along with written up notice forms have not yet been put in. However, since the respondent numbers 1 to 6 are represented through the learned advocate, such deposit of such amount is dispensed with. Learned counsel for the petition appellant stroke petitioner seeks a week apostrophe accommodation in view of the sad demise of the learned advocate on record appearing for the appellant. Accordingly, let the matter stand adjourned till June 23, 2025. Come back on that date, 23rd June. 23rd June.
Item number 34, my lord, I appear for the respondent, my lord.
Yes.
The probate application has been dismissed, my lord.
Kaushik Dev was appearing.
My lord. But he's here, my lord, has passed an injunction, my lord. I will humbly submit, my lord, injunction, my lord should injunct both the parties from creating any third party interest, my lord. because now the property, my lord, is co-share property, my lord.
Why should you injunct them? You have not made any allegation. We'll just make this injunction absolute.
But so far as our case is concerned, my lord.
You have used an opposition to this.
No, my page 5, my lord. Page 5, paragraph 10, my lord. They have already stated, my lord, that we have inducted one tenant. But
You.
my lord. That is before the order was passed, my lord. My lord,
No, that will operate from the date of the order.
My lord. That remains, my lord. Only I'm just humbly praying, my lord. Otherwise, my lord, I have to file an application, my lord.
No, file an application. There is no allegation. How can we do?
Well,
if you did that at the inception, we could have. So we are doing that. Then you are appearing for all the respondents.
Well,
so we are dispensing with service and directing them to put in paper books and all. None appears for the appellant stroke petitioner at the time of call. Full stop. Next para, learned counsel for the respondents appears and submits that the application may be disposed of upon considering the materials on record. Full stop. We find no change of circumstance from May 14, 2025, when, upon considering the prima facie case and the other attending yardsticks for grant of injunction, we had granted injunction against the respondents. Full stop. Accordingly, can 1 of 2025 is allowed, thereby restraining the respondents and their men and agents from by an order of injunction from transferring, alienating, encumbering, and or creating any third-party interest in respect of the suit property and or changing the nature and character thereof, and from parting with possession of any portion of the property which is the subject matter of the disputed will in favor of third parties till disposal of the appeal. Full stop. In view of the appearance of the respondents to their learned advocate, service of notice of the appeal on the respondents is dispensed with. Full stop. The appellant the trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a fortnight from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for hearing as and when the same is ready for hearing. Full stop. Mr. Shane, please. Just we're not recording it. Just intimate Mr. De that we have passed this order. Otherwise, he'll not be complying with the special messenger cost.
The only thing, my lord, I will humbly submitting. My lord will record my submission so far as one tenant is concerned, because it will create problem in the future.
1/10?
One tenant has been inducted, my lord, before the injunction order, my lord.
আচ্ছা প্রথমেই তাহলে যা বললাম তার আগে করে নিন. At the outset, learned counsel for the respondent submits that one tenant has been inducted in respect of a portion of the property, suit property, subject property, prior to the passing of the injunction order on May 14, 2025. Full stop. Needless to say, the injunction order, ad interim injunction order granted earlier on May 14, 2025 shall be construed to operate from that date only and shall not have any retrospective effect. Full stop. As such, we do not record anything further in that regard. তারপর যা বলেছি
Item number 35.
Item number 35, Millard, is my appeal.
Yes.
Millard, on 6th of May, Millard had admitted the appeal, Millard, and directed me to serve upon the Millard, the opposite parties.
Mr. Dasgupta is still showing as defective. What is the defect? Do you know?
Millard, that Millard,
let us just check up. Wait a minute.
I think, Millard, the valuation was not mentioned. That was being pointed out last day.
Valuation?
My lord, we have last occasion, my lord, we have.
Yes, right.
We have.
You have put in subsequently?
Yes, my lord, on the same date itself.
That was done, Millard, last day.
Yes. We find that the memorandum of appeal has been amended by introducing the valuation statement. Full stop. As such, the defect in respect of the appeal as pointed out by the by the stamp reporter be deemed to stand cured in that regard. Yes, the appeal was admitted. And we
yes, admitted, Millard, we have served, Millard, some Millard, the respondents, Millard, has shown, Millard, it's not being served because left.
Because left?
Left, or
Left, you have to serve again. So you are already enjoying an order of
Milad,
stay
that I
or
am, but Milad, we have the address, whatever we had served on them. Milad, I'll serve again, Milad. In default, I will be asking for Milad, an alternative Milad.
Yes, yes. You are the plaintiffs. What is the suit
Milad,
about?
suit for Milad partition. Declaration and partition of the Milad.
You are the plaintiffs.
I am the plaintiff. Milad,
Suit
I have
was dismissed.
Suit was refused. Milad, injunction was refused. From that Milad, I have come up before
What's
a
this?
lordship.
Injunction was.
Yes.
My lord, an interim order was refused.
File the affidavit of service. You are appealing for which of the
My
respondents?
lord, respondent number 1, my lord.
The affidavit.
One. There are 3 respondents.
My lord, affidavit of service, my lord, one copy, just my lord, the ministry.
One copy will do affidavit of service. You are for one. There are 3 respondents.
3 respondents.
One is insufficient address, respondent number 3. And
Only insufficient address.
Those are Milad, we are whatever.
We don't know, Mr. Dasgupta says this is against an ad interim order. We
These are
don't
the
know
addresses
if
we
it is
had.
served at that address, because if it was an appeal, then we could have ascertained whether they were served at the same address in the court.
Milad, what I suggest, we'll try it again. Milad, if could not be done, Milad, we'll ask for substituted service.
We'll give you one more.
Yes, we'll publish in that.
Very good. The respondent number 1 is represented through counsel, full stop. However, the other respondents are not, full stop. Next para, the affidavit of service filed to be kept on record. Full stop, it transpires therefrom that the intended service on the respondent numbers 2 and 3 has returned with the endorsement insufficient address double inverted mode on the respective envelopes and the track reports. Full stop. Next para. Accordingly, the appellant shall serve afresh on the respondent numbers 2 and 3 and file a fresh affidavit of service on the returnable date. Full stop. The application shall next be listed on July 8, 2025 under the same heading. No, affidavit of service is kept on record. Yes.
My lord, I appear on behalf of the
Obliged.
plaintiff, my lord.
I am for the respondent. Yes. What is the appeal about?
My lord, the partition suit, my lord, suit for
Partition should decreed or dismissed?
dismissed.
Dismissed.
My lord, on the ground of
What is scan 1?
my lord,
Condonation. What is the
condonation of
delay?
my lord.
47 days. What is the ground?
My lord, at the first time, my lord, only the judgment was delivered. Then she was advised to obtain the decree, and the decree was obtained subsequently. My lord, according to my calculation, my lord, 56 days at the delay.
Yes. We are allowing this.
There is
We'll
sufficient ground. I'm not opposed.
we'll
but-
record that it is contested, but learned counsel for the appellant submits that the delay of 47 days in preferring the appeal should be condoned on the reasons as furnished in the application. Full stop. Learned counsel for the respondent opposes the same. Full stop. However, upon a perusal of the averments made in the condonation application, particularly keeping in view the strained financial condition of the appellant petitioner who is working as within double inverted Aya and maintains herself along with her daughter, we are of the view that a lenient approach ought to be taken. Full stop. Hence, can 1 of 2025 is allowed on contest, thereby condoning the delay in preferring the appeal. Full stop. The appeal bearing FAT 151 of 2025 is accordingly deemed to stand registered and admitted. Can 2 is
My lord,
order for rule 27.
application.
Order for rule 27 will take up along with the appeal.
No.
Injunction, what injunction? You have
Not to transfer the property to any other person or third party interest.
what do you say?
There is a non-joinder of the necessary parties.
My
No, no.
The appeal is not maintainable due to non-joinder of necessary party.
No, who has not been added?
My lord,
Purnachandra Mondal died and leaving behind his wife, the 2 sons and 3 daughters. They are not
No,
the
Purnachandra Mondal was a party to
Father.
the
Father of the
Father.
He was the father of.
Name finds place in the decree, impugned decree.
Lordship.
Yes. Delays of 74 days. You have mentioned 47 days.
That it will be 52 days, my lord. According
You have
to
reversed the numbers.
Yes,
no,
yes.
according to my calculation,
out
it will be 52 days, my lord. They have taken into
7.
consideration the date of decree. I have.
You're lucky that we
calculated-
missed it out. Yes.
And my lord,
Wait. Both of you cannot argue together. One of you please argue. You cannot permit this. Wait. No. In the impugned decree, Baby Mondal and Narayan Chandra Mondal are the only parties.
Yes.
Who will argue? Choose between yourself. Have you got a coin?
Yes.
Have you got a coin? Have a toss and decide.
Yes. Should continue.
You appear to be contemporaries. So have a toss and decide.
from the plaint, my lord, we got that Purnochandra Mondal died and leaving behind his wife and two sons.
When did he die? You have to furnish the details. No, Purnochandra Mondal has died. Narayan Chandra Mondal is a party.
Narayan Chandra Mondal is a
Suit
party.
was dismissed for non-joinder of necessary parties.
This was the issue number 3.
Was it dismissed on that issue?
Yes, it was the issue, my lord, and
We are not on issues. Whether the suit was dismissed ultimately on that issue.
Suit was dismissed, my lord.
For non-joinder.
Non-joinder parties and in absence of chain deeds. My lord, the property was not inherited. My lord, the
page
property was transferred by father. Property was transferred by father Purnochandra Mondal to the daughter Baby Mondal, who is the plaintiff.
my lord.
And my learned friend's client is the son of Purnochandra Mondal, who has transferred the property to his son. Father transferred the property to son and mother.
That will be decided in the suit, in the appeal. If it's bad for non-joiners, court has held that it's bad for defect of parties and partial partition. That will be that is the subject matter of the appeal. We will decide in the appeal. At this stage, how can you say that?
And my lord, in page number 6 of the judgment,
Yes.
para number 2,
Yes.
it states that it is stated by the plaintiff in her cross-examination that her mother and sister are alive and she has not implemented all the co-sharers of entire 16 ANA share in suit plot. She further stated that she will not implement them. So from the statement, it is clear there are no co-sharer left who have not been implemented in the suit. And
Yes.
next,
What do you say to this?
My lord, the property
You
is not
admitted.
inherited property.
It is
And my lord, the property.
You have admitted that you have not implemented all the co-sharers.
My lord, subject matter, there is no other co-sharers except both.
This is your admission.
Plaintiff, except
This is your admission in cross-examination. The court is relying on that.
plaintiff in her
cross-examination of
cross-examination.
PW1.
Yes, my lord, this is not necessary because, my lord, he has stated that he has not added the.
You have stated that you have not implemented all the co-sharers.
Yes, my lord, there is.
You have to implement all the co-sharers.
My lord, there is no other co-sharers except the defendant because the property was not inherited. Property was transferred by father transferred to the plaintiff and mother transferred to the son.
Have you
There is
stated
no
that
other-
in your?
Yes,
Have you
yes, my
stated
friend.
that in your plaint?
Yes, my lord.
Where?
Yes.
Show us the plaint. And have you got a copy of the evidence?
Yes.
Give us a copy of that. You come prepared. You should come prepared with 2 copies because we will look into that. Both the judges will.
Already in red.
Marking is not a difficulty. We have to have 2 copies. One of us cannot fight between ourselves for who will look into the copy.
Have a copy.
Because you're relying on that. That's why you were saying. Have you annexed the plaint to any of the stay applications?
No, my lord.
And my lord, it is
Paragraph 7, my lord. No, not.
You come prepared with sufficient copies. The party at the time of hearing of the injunction application, we find that both parties relied on their pleadings on their pleadings and the evidence. Accordingly, learned counsel are requested to come prepared with dual copies of all the pleadings and evidence which they want to rely on. Full stop, let the matter stand adjourned till tomorrow. Come back with take out photocopies, whatever plain written statement, whatever you want to rely on. Bring 2 copies for the judges and preferably 1 copy for them also, and same applies to you also. Complete.
Matter will appear, my lord.
Tomorrow?
My lord, day after tomorrow.
Why? Come tomorrow.
My lord, day after tomorrow.
Why day after tomorrow?
Some difficulty, my lord.
Acha, adjourn till day after tomorrow. Day after tomorrow within bracket June 18, 2025. You have any difficulty?
Kindly take this matter next week because I have some difficulties, family issue. That is why I.
No, you don't have to say, tell the issue. Tell adjourn till June 23, 2025.
I'm grateful. I'm grateful.
You have any difficulty? Tell us now.
No.
Then we will go to them again. So June 23 is all right for all of you.
Yes.
23rd June. Very well. Come back.
I'm
Next.
grateful.
Thank you.
Item number 37.
My lord, I am for the appellants here, my lord. The
Yes.
appeal is against the judgment, which was by which my right of custody of my 14 years old child has been denied by the court. I was appeal was admitted with a limited ground
May I request,
regarding
my lord?
the.
You are appealing this matter also?
No, no. My lord, may I request earlier matter, my lord, except 23, my 20.
No, not now. Sorry. Not now.
My lord,
We asked you repeatedly. Sorry, no.
My lord.
Come back on.
I have
23rd.
served upon
Very sorry.
I am served upon the mother of the child, and lordship, the copy service is completed.
Service is complete.
Complete.
What have you asked for? Interim custody?
This was interim, no visitation right. Only in that score, the appeal was admitted to consider
Acha,
regarding
right,
the
right.
visitation right of the child.
In the trial court, Mr. Chatterjee, this was a custody and guardianship application filed by you.
Yes,
in the trial under the Guardians and Wards Act. Very well.
Section 8.
That was dismissed on what ground?
Lordship, they considered several points. One of the points was that I have remarried, and out of that marriage, I have 3 children, and she has not remarried.
Not remarried.
And considering the economic condition and considering the other aspects and welfare of the child, as the paramount interest, this was given to the mother. The custody was given, as well as they considered the intelligible preference of the child's.
What is the age of the child?
13, 14 years. 13 years old. So, on that score, it has been dismissed, but appeal was admitted with only to the limited ground that your lordship will be considering the visitation rights, which has not been granted to me.
Were you enjoying visitation rights in the trial court? Did you apply?
Lordship, that instruction I don't have, whether it was applied or not.
Because it's very difficult, Mr. Chatterjee, in the absence of the other side to grant a visitation. Invariably, you will go there, she'll refuse.
Nothing will happen.
And a scene will be created and another video will be released on the YouTube. Invariably.
Yes.
We don't want a repeat of that. So,
that we can.
So you take instruction, come back tomorrow. With that instruction, at least, if you had a visitation, we'll give you a little more than that. We want a copy of that visitation application. And please ask your advocate on record in the trial court to obtain an order passed in that visitation if you had
at all,
filed.
application.
Even if rejected.
Yes.
Just get an order, get a copy of that order. We'll keep it next week.
Even keeping the question open whether he made the application or not. That
on that also. If he did not make it, so well and good. Then,
yes.
then we'll proceed on that premise. Otherwise, we'll just take a copy of that, have ample copies for both of us and copy of the order on that also. Whatever order was passed. Learned affidavit of service filed today be kept on record. So despite service, none appears for the respondent mother. First up, the matter arises out of the dismissal of the appellant's application for custody and guardianship of his daughter or son, of his 13-year-old son,
13 years.
of his minor son who is about 13 years of age. First up, next para. For the sake of complete justice, we request learned counsel for the petitioner to take instruction as to whether the appellant had taken out any application for visitation rights in the trial court and, if so, to furnish copies of the same and of any order, if passed thereon on the returnable date, full stop. For such purpose, let the matter stand adjourned till 1 week will suffice. Stands adjourned till June 3rd, 23, 2025. Come back next Monday with those and
grateful.
Time যদি লিস্ট থেকে আসে, যদি না আসে তাহলে এক্সপার্টই করবে।
Item number 38.
আবার কমপ্লিট করবে।
Well, in 38, my lord, I am for the petitioner.
Yes.
My lord, in compliance with your lordship direction, my lord, I have sharp copy of from the opposite party, my lord, and this is the affidavit of service, and the service has been effective.
Effective, right? Affidavit service name.
Well, this is the appeal, my lord, under the what?
Here also similar to the previous matter.
Yes,
You're the father,
yes,
you wanted
yes,
custody.
yes, thanks.
Now, here also we ask this, what is the age of the child?
Child more than 11 years plus.
11 plus. Son or daughter?
Son.
Acha. And same question to you. Did you ask for visitation rights in the court bill?
Yes, my lord, I have applied for visitation right, my lord, and that was disposed of on 30th September 2024. And my lord, the opposite party was directed, my lord, to produce the, my lord, the son in the office of the DLSA. My lord, thereafter, my lord, she never produced the son, my son, my lord, in the office of the DLSA.
Can you bring a copy of that order?
Yes. My lord, I
You
have
got a
annexed,
copy of
my lord,
that order?
kindly page C.
Acha, you are annexed. Very
Yes,
good.
yes,
Yes, yes. Let us see that.
Page, my lord, the application, my lord, page 20 onwards, my lord.
Very good. Yes.
This 20 is the application. And
Yes.
3 is the, my lord, order.
What happened after this? They did not produce. Not even once.
Not a single occasion.
You did not put it to the, bring it to the notice of the trial court.
My lord, my lord, I have brought the, my lord, notice of the trial court, my lord, but nothing was done, my lord.
Where does the child reside?
But child, my lord, at present, my lord, with her mother, my lord.
I mean, where? Where is the mother residing?
Yes, my lord, mother resides, my lord, at, my lord, she is, my lord, residing daughter. My lord, village,
আচ্ছা পশ্চিম মেদিনীপুর
পশ্চিম মেদিনীপুর,
উত্তর বড়
village, my lord, সাউগেড়িয়া, post office,
How far is it from your place?
My lord, this is, my lord, from my place, my lord,
From your client's place?
my lord, at least, my lord, 20 kilometers.
But you are the father, you
Can
should
see,
go
my lord, I
there.
have stated also so, my lord.
So you should go there then.
Yes.
You should go there for having a visitation.
Yes.
Will it be, I mean, there is no matrimonial suit between you. Otherwise?
No matrimonial suit, my lord, nothing.
So we'll direct you to go there and have the visitation once a week.
Not, my lord, my lord, not only the visitation, my lord, my lord, in the house of the, my lord, the wife, my lord, there is no, my lord, environment for education of the, my child, my lord. That is why, my lord, I also stated
Suggest
that.
a common place, I mean, near her house, because it has to be near the child's house.
Yes, my lord, the school, my lord, the Ramakrishna Mission School, my lord, at my cost, my lord, let him admitted in the Ramakrishna Mission School, or, my lord, according to her, my lord, choice.
Here you have asked for only visitation rights.
Yes, my lord, kindly see paragraph 10 to 10 onwards, my lord. Paragraph 10 onwards.
You have to invite an affidavit on this. I mean, these are orders you are praying which have a bearing on the future of the child also. Where is he studying at present?
Pardon?
Where is he studying at present? The child?
Child, my lord, in the house, my lord, the mother, my lord.
He is studying where?
Where, my lord, the school, my lord.
He is presently studying in a school.
Yes, my lord,
So
studying.
to take him off from there and put him
Present.
somewhere else
Yes.
requires I mean, without hearing the mother, we should not. We'll direct affidavits in this matter.
Well, so far that this party is concerned, my lord, there may be the affidavit. So far the visitation is concerned, my lord, kindly allow me, my lord, at least, my lord, twice in a week, my lord, for 2 or 3 hours.
Twice a week is too much. There is acrimony between the parties. It can be once a fortnight or once a week.
Once a week, my lord, in the office of the DLSA later.
Office of DLSA is not conducive for a child of 11 years. Office of DLSA.
But that is the, my lord, middle place.
Isn't there any park or anywhere in between? You take instruction, come back tomorrow. Tell us, we'll direct the visitation there.
If we go to the, my lord, the DLS office, my lord, is the, my lord, the just middle portion. And the lady, my lord, also, my lord, worked there in a nursing home, there is Debra. My lord, it is also the direction of the,
DLS
the trial court, my lord, in the office of the DLS.
DLS office, some park or somewhere there. It has to be a common place. DLS office, why are you asking for the DLS office? That's a formal place. Child will not feel at home. Is it a proper place for a child to go?
Then let me take instruction. My lord,
Take instruction, come back tomorrow, or we can keep it day after tomorrow. We'll record in your order that we have.
day after tomorrow, my lord.
Right.
And my lord, I shall call my client, my lord, to be present here, my lord.
Need not be.
All right.
You can ask your client to be present in court so that you can take instruction, but we don't require your client. Despite service, none appears for the respondent. Full stop. The affidavit of service in that regard filed today be kept on record. Full stop. Learned counsel for the appellant is requested to take instruction as to a congenial place for visitation of his 11-year-old son near the residence of the respondent where the son is now residing. Full stop. Although learned counsel seeks such visitation right to be in the office of the district legal services authorities near at Debra, DEBRA, where allegedly the respondent wife is also near which place the respondent wife is also working, we are prima facie of the opinion that the office of the DLSA is not a proper place for a minor child to visit his father. Full stop. Accordingly, to enable learned counsel for the appellant to take instruction in the above regard, let the matter stand adjourned till June 18, 2025, when it will be listed, when the application will be listed under the same heading.
Good.
Day after tomorrow, please come with instruction. Bring 2 or 3 alternatives, 2 or 3 alternative places.
Okay.
We'll consider among those.